Vacating stay ಹಾಕಿದ್ದೀರಾ ಕೊಡಿ. Vacating stay applications ಯಾವಿದೆ ಎಲ್ಲ ಕೊಡಿ. Only Wednesdays. This Wednesday or next Wednesday? KDB ಕೊಡಿ. 19th. ಇರೋದೇ next Tuesday. Fresh matter 19th. Fresh matters ಎಲ್ಲ ಕೊಡಿ.
Execution.
Monday sir. Pending a fresh. When do you want it? Settlement. For settlement ತಗೊಳ್ಳಿ. You ಕೊಡಿ sir. Tuesday. Why sir? In execution. You have seen my judgment? We'll see. Give it. Wait. When is the next date there? 2:30. Yes. Why? Extension of interim order?
Oversight interim order is not extended.
Pending what? CRP.
GMPTC
Kodi.
Monday
Monday pending matters I take. Illala. Vacating stay is it?
No,
Then
there's no interim order.
give it. Extension matter.
Tuesday.
No, madam, give it.
Milord, fresh matter.
PDA matter, my lord.
ಯಾವ್ದಾದ್ರು ಸರಿ ಕೊಡಿ. Fresh ಆ pending ಆ sir?
120 site orders have been deprived. This is the third
ಆಯ್ತು,
consecutive.
ನೋಡೋಣ. Give it.
Milord.
Execution.
Give it sir. No date sir. Give it. Yes.
Next
The
week.
Kanpur matter. The Kanpur matter.
ಬಂದಿಲ್ವಾ?
ಅದು ಇಲ್ಲ, ಅದು ಕ್ಲಾರಿಫಿಕೇಶನ್ ಹಾಕಿದೆ ಇಲ್ಲ, ಮೆಮೊ ಫಾರ್ ಬೀಂಗ್ ಸ್ಪೋಕನ್ ಟು ಹಾಕೊಳ್ಳಿ ಅಂತ ಮೆಮೊ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ರು. It may be had on Tuesday, my lords.
Give it. ಅದನ್ನ Tuesday ಹಾಕಿ madam.
Milord, fresh matter, Milord, for admission. Milord, the urgency is this.
Fresh matters give everything.
Milord,
My lord,
delivery
it's a
warrant
C-
has been issued, Milord.
What?
Delivery warrant has been
So what?
issued.
Give it.
My lord,
Monday.
Arrest warrant ತರ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. Delivery warrant ನ ಕೊಡಿ.
They're trying to, with police protection.
No sir. Give it. Yes.
my lords,
Fresh matter.
Fresh matter.
my lords,
Come
it's
give
a-
it.
I'm moving, third time I am going this memo, not
And then
listed.
I'll not take that memo.
Milord,
Yes.
there is no
ಈ
order.
third time 10th time ಎಲ್ಲ ಬೇಕಾಗಿಲ್ಲ.
Objection.
Fresh ಆ pending ಆ?
Fresh matter.
ಕೊಡಿ.
my lords,
There is-
stands-
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೈ ಮಾಡ್ದೇನೆ ಇಲ್ಲಿ 3ನೇ ಮೆಮೋ 10ನೇ ಮೆಮೋ ಅಂತ ಸುಮ್ನೆ ಹೇಳೋದು. ಅಲ್ಲಿ ನೋಡಿದ್ರೆ ಕಂಪ್ಲೈ ಮಾಡಿರಲ್ಲ.
ಆಗಿದೆ ನಾವು.
ಕಂಪ್ಲೈ ಮಾಡಿದ್ ಒಂದು ಫೈಲ್ ಪೆಂಡಿಂಗ್ ಇಲ್ಲ.
Milord, Monday.
Mondayಗೆ.
2000 ಮ್ಯಾಟರ್ ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಅಲ್ಲಿ ಇದೆ. 2000 ಮೆಮೋ ಮೂವ್ ಮಾಡ್ತೀರಾ, ಒಂದು ಕಂಪ್ಲೈ ಮಾಡಲ್ಲ, ಇಲ್ಲಿ ಬಂದಿಲ್ಲ ಅಂತ ಕಂಪ್ಲೇಂಟ್.
My case are complaint.
ಫಸ್ಟ್ ಡೂ ಯುವರ್ ಜಾಬ್ ಸರ್. ಆಮೇಲೆ ಕಂಪ್ಲೈ ಆಗಿದ್ ಒಂದು ಫೈಲ್ ಉಳಿದಿದ್ರೆ ಯು ಟೆಲ್ ಮಿ.
Milord,
All right.
Monday, Milord, please.
Do it. ಅದು ಕಂಪ್ಲೈ ಮಾಡಿ ಬರುತ್ತೆ.
Milord, Monday, Milord. Delivery warrant has been issued, Milord.
ಪರವಾಗಿಲ್ಲ ಕೊಡಿ ಸರ್, ಏನಾಗಲ್ಲ.
ನಂದು Mondayಗೆ ದಂಡ ಕೃಷಿ ಮೇಲೆ
ಅದು
demolition.
ಕಂಪ್ಲೈ ಆಗಿದ್ರೆ ಬರುತ್ತೆ ಸರ್.
Please.
ಗೋ ಅಂಡ್ ಕಂಪ್ಲೈ.
Execution proceedings in a money decree state since 2021, my lord. There's some
Vacating stay.
Vacating stay.
20 which matter?
It's a 21 matter.
21 matter, not before me. 23 ಇಂದ ಇಲ್ಲಿರೋದು.
No, this is a 25 matter. They
Then
filed
how
a
do you say it stayed since 21?
Execution proceedings is of 21.
Huh?
The original proceedings are of the year 2000.
ಸುಮ್ನೆ ಏನೇನೋ ಹೇಳ್ಬೇಡಿ.
It is of 25.
Madam Lord, for consideration of the interim prayer, Lord, your lordship said that, my lord, immediately after service of the notice, it has directed to post, my lord. On 26/6, my lord, Wakalat has been filed by the respondent, my lord.
What is filed?
26/6, my lord, respondent has filed the Wakalat.
ಆಯ್ತು ಬರುತ್ತೆ.
Since till today, they are
Give
not
it, sir, it
posted.
will come, it will come. Yes.
Also, this is a recasting of issues case, my lord. 2 times it wasn't reached. Monday evidence.
Hasn't reached, what can be done, madam?
My lord, today end of
Can't,
the list.
no
Monday,
today, yes. What's the next date there?
Monday, my lord.
It's a fresh matter, is it?
Yes, my lord.
Fresh matter.
This
Fresh matter is not reached. No, it must be a pending matter. One,
ma-
if it's a pending matter, it won't be taken at 2:30.
my lord. Monday we have to read evidence finally and the chance.
No, Monday, tomorrow can I take it?
Today end of the list.
No, madam, it's, if it's a fresh matter, give it. But if it's a matter that is pending, it won't come at all.
It once reach agilla, my lord.
Reach ಆಗದೆ ಇರೋದು ಬೇರೆ. ನೋಟಿಸ್ ಆಗಿದೆಯಾ?
Illa, my lord.
ಕೊಡಿ, ಯಾಕೆ ಆಗಿಲ್ಲ? ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ರೀಚ್ ಆಗದೆ ಇರಕ್ಕೆ ಸಾಧ್ಯವೇ ಇಲ್ಲ, ಕೊಡಿ.
One CRP matter, my lord, one
Give it,
CRP
sir.
matter, my lord.
My lords, it's a
91
fresh
years old, my
matter.
lord.
ಅಯ್ಯೋ ಕೊಡಿ ಪರವಾಗಿಲ್ಲ.
Tuesday, my lord.
No, no, you don't push the dates, sir. Give it. Days are already fixed. It will come only on those days.
Let's I request to make a mention, my lords.
Give the memo. Fresh or pending? No problem. 18th is Monday, right? 8th or 19th.
My lords, it's a fresh matter. It's a CRP, my lords. My lords, a miscellaneous petition has been filed seeking for setting aside the consent decree after lapse of 17 years, my
All
lords.
right, give it.
My lords, kindly Monday, my lords.
No, Monday. Yes. Not on Monday. It will come on a CRP day. Fresh matter.
Fresh matter. My lords, in the
Fresh matter. Application ಆಗಿದ್ರೆ ಮಾತ್ರ. That will come along with the notice.
two other fresh matters on tax. It's already covered, my
Tax
lords.
Thursday.
Kindly,
Yes.
my lords.
That tax ತಗೊಳ್ಳಿ madam, Thursday.
My lords, fresh matter, my
CRP,
lords.
give it, sir. Fresh matter ಅಲ್ವಾ? ಬರುತ್ತೆ.
My lord, fresh matter, my lord. Order of the police protection is under challenge, my lord. Execution matter is listed on Wednesday, my lord. Kindly have it on Monday, my lord.
Fresh matter, give it.
Fresh matter, my lord.
Fresh matters ಕೊಟ್ಬಿಡಿ ಅಲ್ಲ, ನಾಳೆ ಅಂತೂ ತಗೊಳಕ್ಕಾಗಲ್ಲ, ಕೊಡಿ. Please give.
Monday, my lord.
We'll see Monday ಅಷ್ಟೇ.
CMC.
1000 ತಗೋಬೋದಾ? Monday ಇಲ್ಲ ಅಲ್ಲ? ಕೊಡಿ. Yes.
Lordship
Give it.
signed leave, my lord. Fresh matter. Matter where a miscellaneous petition has.
Give it, sir. Yes.
Monday, there is some urgency because the review.
Yeah, everybody have urgency. Everybody have urgency, sir.
Can it be
I can't take it beyond my capacity. Give it, sir. That's all.
requesting for Monday?
No problem. Your request accepted. Supposed to be listed. ಯಾಕೆ? ಏನ್ ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಾ? ಏನ್ ಅರ್ಜೆನ್ಸಿ ಇದೆ? ಬ್ಯಾಂಕ್ ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಕೊಡಲ್ಲ. Whatever it is. By way of an interim order, no defreezing, no de-attachment. Monday ಅಲ್ಲ, next Thursday ಕೊಡಿ. Fresh matter ಆದ್ರೆ Monday ಬರುತ್ತೆ. ಆಯ್ತು.
It's to recall the order, my lord.
Which one?
To non-compliance of office objection, my lord.
Give it.
Last two occasions
ಆಯ್ತು,
are
ಕೊಡಿ,
given.
ಕೊಡಿ.
Kindly, any date may be fixed, my lord.
Madam,
because-
ಅದು 2:30ಗೆ ಆಕ್ಸಿ.
Can
2:30ಗೆ recall.
I request to make a mention, my lords.
Adjournment.
No, but it's for withdrawal, my lords. Serial number 35 and 42.
Thank you, sir. 35?
And 42, my lords.
42. Yes,
And it's,
35 and 42. You have filed a memo or what?
We have 5 minutes.
In terms of the memo, yes.
Minutes. Please.
Call the cases.
Order. This one, seal
With
number
my lord's kind permission.
Yes, Dharwad 2:30.
2:30. Please, my lord.
Yes. Yep. Orders ಅಲ್ಲಿ ಬಂದಿದೆ madam ಇದು. Orders ಅಲ್ಲಿ ಯಾಕೆ?
Pleadings are complete, my
Covered.
lordship.
It
It's
is
not
a covered judgment.
Then why is
my
it come in
lordship.
orders?
It is covered judgment, my lordship. I pray for 1 week time,
Covered.
my lord. It is
Not covered.
covered by coordinate bench, my lordship. I'll produce the judgment.
Yes, Dilip.
To be argued. my lord.
Yes. Place the matter in B group on 28th. ನೀವಿದ್ದೀರಾ ರವಿರಾಜ್ ಇದ್ದಾರಾ?
It's Raviraj, but my lord, same office.
No problem.
number 2.
Dismissal of writ petition for default. Why? No representation on behalf of the petitioner. Objection ಹಾಕಿಲ್ವಾ? Nobody present. This court on a coordinate bench of this court on 2/6/2025 had passed the following order. The coordinate bench was clear that for a period of 1.5 years, the copy was not served and nobody was present. The matter was again listed before the court on 3/7/2025. A submission is made that the papers were misplaced and it would, the needful would be done in the next by the next 1 week. 2 weeks have passed, 4 weeks have passed by. Needful is neither done nor the petitioner is present. In the light of the order passed on 2/6/2025, the petition stands rejected for its non-prosecution. Yes, next.
3.
Post immediately of service of notice upon the
My lords, the
respondents.
notice could be served upon the panel advocates for
They are
R6 to
6, 7,
R7.
26, 43. Who are they? Which panel are they?
Lord, 6 and 7 is Karnataka Residential Education Institution Society.
6,
6 is Karnataka Residential Education Institution Society.
Christ. Serve on air, madam. Or?
KDP my lord.
Huh?
KDP ನಾವು appear ಆಗೋದು.
KDP ನೀವು ಅಪೇರ್ ಆಗ್ತಾರೆ ಗೊತ್ತು ಇರಿ ಒಂದು ನಿಮಿಷ. ಸೊಲ್ಯೂಷನ್ ಕೊಡ್ತೀರಾ ಅಂದ್ರೆ ಕ್ವಶನ್ ಕೇಳ್ತಾ ಇದ್ದೀರಾ. Yes.
7 is my lords PWD.
1 minute. Christ. ನಾಗಪ್ಪನೇ ಇರ. Christ ಒಬ್ರು ಅಪೇರ್ ಆಗ್ತಾರಲ್ಲ. ನನಗೂ ನೆನಪಾಗ್ತಾ ಇಲ್ಲ. Yes. 6 and 7. 7 learned HCGP. ನೀವೇ ಅವರು not the tax HCGP. Public Works Department. Learned HCGP is directed to accept notice for the 7th respondent. Council 8 yaru?
No, my lords, then it's 26.
8 agide already.
Yes, my
Who
lord.
is 26?
26 is
Six-
IDWT Shivamoga Division.
26 is again HCGP. 43.
26 to 43, my lords.
26 to 43 is it? All are government?
Yes, my lords.
26 to 43. Illa madam, smart city, chief officer, up to 37, 26 to 37, the learned HCGP, ನೀವಲ್ಲ, the, ನೀವೇ ಆಗ್ತೀರಾ? ಅಲ್ಲ ಬೋರ್ಡ್ಗೆ ನೀವು ಅಪೇರ್ ಆಗಲ್ಲ. ಐ ಆಮ್ ಓನ್ಲಿ ಟಾಕಿಂಗ್ ಆಫ್ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಇಂಜಿನಿಯರ್, ಪಬ್ಲಿಕ್ ವರ್ಕ್ಸ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅಂಡ್ ಆಲ್ ಅದರ್. ಈಗ ಉಳಿದಿರೋದು 4 ಮಾತ್ರ. That is R7 Nagaya is directed to accept notice. R6 sorry, R6 Nagaya, R7 is R7 learned HCGP, R26 again learned HCGP, 43
26 to 40.
26 to 43 alla ಬೇರೆ ಬೇರೆ ಇದ್ದಾರೆ. 26 to 43 Commissioner Mahanagara Palika adala, he can't appear. 26 to 43 counsel for the petitioner is permitted to serve on any panel counsel representing those respective respondents. List the matter. ಏನು ಇಂಟರ್ ಮಾಡಿದ್ಯಾ?
No, my lords. It's a mandamus. It's a mandamus. There's no interim.
Mandamus.
But my lords, it's already covered by the.
Cody,
judgments
which
of
is
the
that?
court. My lords, it's covered by 9721 Chandrasekhara's order. It's also covered
Page
by
124,
page 123.
123, 124, Justice Sachin Shankar Magdum.
104908 is 124, my lords.
That's one, it's not covered by that.
It's covered. Both the orders apply on.
Yes, we'll close it then.
My lords, it could very well.
ಅಲ್ಲೂ ಅಷ್ಟೇ ಕೊಟ್ಟಿರೋದು. ಡೈರೆಕ್ಟೆಡ್ ಇದು ರಿಯಂಬರ್ಸ್ಮೆಂಟೇ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. Let it come. List for preliminary hearing on 21st.
May I make a submission, Maharaj? My name is shown as with respect to respondent number 3. However, my lords, I don't appear on behalf of respondent number 3. Advocate B.R. Srivatsa appears for the Tumkur Smart City.
Sakshi M. Alva.
Please.
Who appears?
Advocate Shri B.R. Srivatsa.
Learned counsel for the learned counsel Sakshi M submits that she does not appear for Tumkur Smart City. Tumkur Smart City The counsel
B.R. Srivastava.
so and so appears, therefore registry to delete the name of Sakshi M and print the name of so and so is appearing for the third respondent. Yes, list on 21st, we'll see.
Grateful, my lords.
Next,
4.
taken as filed.
Petition for a mandamus for refund, my lords. There's a case where for 3 assessment years, demands were raised.
Next week, my lords, next Thursday. My lords.
Why Dilip?
My lords, by oversight, I could not see my,
Preliminary hearing next.
please,
List for preliminary hearing on 21st. ಇದೆಲ್ಲ dispose ಮಾಡ್ಬೇಕು ಅಂತ
please,
ಮಾಡ್ಬೋದು.
my lords, my name, it's
Last
not.
chance was given on the last time to file. I usually don't object, my lords, but this
Last
matter.
chance by me,
Previous.
or
roster,
previous
but-
last chance previous. Now last chance, yes. Yes, Dilip, ಮತ್ತೆ adjournment ಇಲ್ಲ.
My lords, name was not shown reflected
Where?
properly, my lords. That's we did not get the file. Next week, my lords, next Thursday.
You are not Dilip, is it?
DILIP.
Oh, you are LIP. ಎಲ್ಲ permutation combination check ಮಾಡ್ಬೇಕು. LIP, LEEP. Yes,
Sorry.
Great.
21st.
5.
Withdrawal in terms of
6.
non-serving.
Serial number 5. my lord.
5 withdrawal, madam. Yes.
I prefer the petitioner, my lord.
5 or 6?
6.
Ah,
Copy serve ಆಗಿದೆ sir.
served.
It just served, my lord.
Learned
And
counsel.
the second respondent, my lord.
Learned counsel of the petitioner submits, the copies of the petition have been served. Now list the matter on 4-9. Objections if any. Saka madam? ಏನದು?
Much obliged.
ಅಲ್ಲ ಅಲ್ಲ, what is that? 4-9 ಹಾಕ್ಬೋದಾ?
ಹಾಕಿ sir.
Objections
I will seek
if any
instruction.
by 4-9. List on 4-9 in preliminary hearing.
Okay.
7.
My lords, show cause notice was issued while I was in judicial custody for cancellation of GST registration, my lords.
You did not reply.
My lords, I was in judicial custody. my
ಆಯ್ತು,
lords.
that is why you did not reply. Yes, notice ಆಗಿಲ್ವಾ? ಜೀವನ್ ನೇರಳಿಗೆ accepts notice.
ಇಲ್ಲ, notice ಆಗಿದೆ sir.
My lord, in this case, my lord, one small mistake has happened, my lord.
By you,
I will take notice only for R2 and R3. R1 is Jeevan Neralgi, sir. But instead of the, in cause list is shown Jeevan Neralgi, sir.
ಆಯ್ತು.
And
Learned,
My lords,
HCG.
already they have taken notice, my lords.
ಜೀವನ್ ನೇರಳಿಗೆ has taken notice for all.
No, my lords, Shishira Amarnath has taken notice.
ಸುಶಾಲ್ ತಿವಾರಿ?
Shishira Amarnath.
N. Kumar accepts notice for R2 and R3. N. Kumar ಅಂತ ಯಾರೋ ಇದ್ದಾರೆ?
and AJS, sir.
ಹಾ.
Yes, my lord.
ಸರಿ,
ಇದರಲ್ಲಿ
notice is
ಆರ್ಗ್ಯುಮೆಂಟ್
over.
ಆಗಿದೆ. ಏನಂದ್ರೆ at the instruction of the first respondent, we have cancelled their registration on the basis of fraud, the bogus ITC.
Correct. ಅದಕ್ಕೆ ಆಪರ್ಚುನಿಟಿ ಸಿಕ್ಕಿದ್ಯಾ? ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ರ?
ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಅವ್ರು ಅಪಿಯರ್ ಆಗಿಲ್ಲ ಅಲ್ಲಿ.
ಅಪಿಯರ್ ಆಗಿಲ್ಲ.
ಎಸ್ ಮೇಡಮ್.
ಅಪಿಯರ್ ಆಗಿಲ್ಲ.
ಅಪಿಯರ್ ಆಗಿಲ್ಲ.
ಯಾಕಾಗಿಲ್ಲ?
ಅದು ಅವ್ರು ಹೇಳ್ಬೇಕು ಸ್ವಾಮಿ.
ಜುಡಿಷಿಯಲ್ ಕಸ್ಟಡಿಯಲ್ಲಿ ಇದ್ರು ಅದಕ್ಕಾಗಿಲ್ಲ.
ಇಲ್ಲ, ಇದು ಈ ಕೇಸಲ್ಲಿ, ನಮ್ ಕೇಸಲ್ಲಿ ಜುಡಿಷಿಯಲ್ ಕಸ್ಟಡಿಯಲ್ಲಿ ಇದ್ರು. ಸೆಂಟ್ರಲ್ ಗವರ್ಮೆಂಟ್ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದಾಗ ದೇ ಹ್ಯಾವ್ ನಾಟ್ ಅಪಿಯರ್ಡ್. ದಟ್ ಈಸ್ ದ ಫ್ಯಾಕ್ಟ್ಸ್.
ಈಗ ವಾಟ್ ಇಸ್ ದಿ ಇಂಪ್ಯೂನ್ಡ್ ಆರ್ಡರ್ ಬೈ ಯು ಆರ್ ಬೈ ದಿ ಸೆಂಟ್ರಲ್ ಗವರ್ಮೆಂಟ್?
They approached impugned order against us.
Correct. All right. So you have passed the impugned order without hearing him. As simple as that. He
Yes.
was in judicial custody. How will he appear before you?
Then it may be remanded back to
There, that's
respond number
all.
2 and 3
To
to
con-
reconsider,
To reconsider it and pass out.
pass the appropriate order.
ಅಷ್ಟೇ.
Yes, ma'am.
Yes. Disposed. Why is the learned ASG waiting? 8, huh?
This is a writ petition challenging the search action.
ಓ ಇದೆ, 3 ದಿವಸದಿಂದ ಮೂವ್ ಮಾಡ್ತಾ ಇದ್ರೆ ಅರ್ಜೆನ್ಸಿ ಇದೆ.
ಇಲ್ಲ, ಅದು ಬೇರೆ. 3941.
Yes.
Your Honors, I have engaged senior counsel Sandeep Puligol. He is not well.
Actually, the writ petition doesn't survive. There was a direction for us to consider their application
Your Honors,
for
the second
provisional
writ
release of the gold.
Get back.
Lord, we have complied with the interim order and taken a decision. We have said that
Communicate the decision.
Communicate the decision. So they have to, if the petitioner is
Challenge,
aggrieved
Your
by
Honor,
an
the
independent
second-
writ petition, he has to challenge it.
The second writ petition in this serial number 8.1 4850, it challenges the search action itself. That survives. And the other two are subsequent actions of the first search action. So let it be heard on
All
28.
three survive?
All three survive.
ಆಯ್ತು ಮಾಡ್ಲಿ. Yes. They heard the learned counsel for the petition, learned additional Solicitor General of India, Shri Arvind Kamath. The learned ASG would submit that a direction was issued to consider the grievance of the petitioner. The grievance has been considered and communication of rejection is also made to the petitioner. If the petitioner is so aggrieved, it's so aggrieved, it is for him to file a separate petition raising a challenge to the order passed during the subsistence of the subject petition pursuant to the direction of this court. The learned counsel for the petitioner submits that what is challenged is the route, which is the search action. In that light, all the petitions would survive. List the matter on yavat haki 28th.
28th.
21st ಬೇಡ.
First ಇಲ್ಲ 28th ಅಥವಾ 4th.
28th is
Yes, list on 28th. In preliminary hearing B group. Yes.
Your Honor, let it be in the same group.
No. Yes. Orders ಅಲ್ಲಿ ಬರೋದು ಗೊತ್ತಾಗದೇ ಇಲ್ಲ. Yes. Next.
I'm appealing for the petitioner, the Lord. I filed an IA for an amendment of the writ petition.
Why? What amendment, sir?
My Lord, the peculiar facts are that I'm unable to file the appeal because all my accounts are frozen. I sought for a mandamus. Now I'm amending
Covered by
to
this?
read down, the Lordship.
Covered by this?
I'm not
Who has given this?
filed any of the decisions, my Lord.
10% deposit.
My Lord,
Appeal ಹಾಕಕ್ಕಾಗಿಲ್ಲ.
this is not applicable to me because it's only an adjudication. 10% deposit itself is not. I'm unable to pay the 10% deposit.
Notice is not yet issued. AG ಇದೆ.
Yes.
ಆಗಿದೆ. Amendment will hear it along with the main. List the matter for preliminary hearing on 20. Correct. Because account was frozen.
Yes.
Deposit ಮಾಡಕ್ ಆಗ್ತಾ ಇಲ್ಲ. No, that's all right. If someone has to file an appeal, he should make the deposit. From out of which account?
But I've also made an
You
amendment for
defreeze the
reading
account
down
only for the purpose of deposit. Yes.
My Lord, I'd also made an amendment for reading down the provision of 107(6).
Oh, ಹಾಗಾದ್ರೆ 107(6) reading down without deposit.
No, my Lord, during the freezing of the bank account, the time limit has to be extended. The difficulty would be that.
No, you take both the actions. One, you freeze the account. One, you say deposit has to be made in the appeal.
Lord, the precondition, without that they.
No, that's a precondition. That's correct. The precondition is upheld also. It's all right. No, correct. You can't do it. We will definitely do it. But how do you reconcile to this situation? Freezing and delay both. So we'll have to say freezing orders idre you can't insist on either you can't say that you can't insist on deposit because it's statutory mandate. We can only say that you should defreeze for that purpose. Yes, PML. That is the one. Same thing we will pass. Whatever just Suraj Govindra just passed. Because that their account was frozen on, as you said, under the PMLA. Yes. We'll close it then. The application is unnecessary. Don't read down provisions.
Well, the difficulty is like 3 months will be lost because hardly
No.
get 3 months.
If validity, then
My
he'll
Lord
have to file his objections, is gone.
My Lord can give sufficient
But
time.
if this order has to be followed, we'll do it. Have you seen this order?
Yes, my Lord. That
yes.
I only give.
Was not capable of making pre-deposit, so shall be excluded from consideration period limitation.
The limitation itself is excluded in that.
Even now it is frozen?
Even now it's frozen.
Illi, it was defrozen then.
My Lord, one more difficulty in GST law is that only the bank which is linked to the GST registration, that bank account has to be used to
Deposit.
make a deposit. Until unless that bank account is defrozen or the debit freeze has been lifted.
Why you need a deposit? Why do you want that only to be used for deposit?
Because the system only permits it through that account.
Correct. But this is the problem. No, I'm not talking of illegality. You should somehow, because if this is closed on account of remedy of appeal goes away because he has not deposited and cannot deposit. The impossibility of compliance, if there is something, no, you can't insist on that. Let me see. We'll have to write something, right? Huh? Vehemently opposed. Yes. We'll dispose it. We'll write it so that this problem, some solution will be there.
Yes, your Lordship. That's the reason why I asked for reading down of 100.
No, the solution will be Hem Kumar sir. Aitu, circumstances may be there where he cannot. The 107 only, he has to file an appeal, make a deposit. The other day I have said 29th, on 29th day, sorry, on 129th day, 19th day he makes the deposit. No coordination. We'll see, we'll pass some order here. Yes. Reserve, yes.
10.
Non-compliance.
What's this petition challenges an order passed under section 195(2), directing me to deduct tax at source at the rate of 10% on certain payments that I make to a Singapore-based entity. But I'm a reseller and distributor of the Google AdWords program. I sell that program to customers in India who want to advertise on the Google website. I have to then retain a certain amount of the sale price and then send the money back to Singapore. The department takes the view that this amount which I pay is in the nature of royalty for the use of equipment and for use of intellectual property. The tribunal has decided that the issue is not royalty and cannot be characterized as royalty. At that point of time when the tribunal decided the matter, the payment was being made to an Irish entity, Google Ireland. But subsequently, Google Singapore got the rights to distribute the program in Asia Pacific, but the agreements remain the same. The department has, from assessment year, financial year 2021, insisted that I deduct tax at source at 10%. Petitions were filed in this court, have been admitted, and an interim order has been passed at that stage that it should be at 6%. If my lord will just see the interim order, which is at page, my lord, starting from page 156.
Oh, there's several orders.
Right, my lords, for the respective years. And if you see the operative part of the order,
all these petitions are pending or disposed?
All these petitions are pending. But the problem is the department is not willing to proceed with these petitions, unfortunately, because really the issue
now
is...
they will. Yes.
Well,
Objections, you are appearing in all these.
I will take notice for the respondents.
Heard the, what's it?
Mr.
Name?
Pardiwala.
Learned counsel, so appearing for the petitioner. The learned counsel, senior counsel?
Yes.
A learned senior counsel would submit that identical petitions have been filed year on year, and there is an interim order granted right from 2022 in writ petition 7093 of 2022. Tag this petition along with from page 156 to 176. Have you filed objections in any of the cases?
No. Your Lordship, for memo for disposal, they had filed one, my lord. I have filed reply for that. It covers everything.
For memo, you've
For
which petition is that? so and so. Objections, if any, by the next date. List the matter on 11/9/2025.
Those could be kept for disposal with the others. My lord, I tell my lords. Because
All the
really,
matters, not this, all the matters.
my lords, in my matter, the tribunal followed an order in the case of Urban Ladder, where Urban Ladder was the advertiser.
Yes.
My lords, the appeal of the revenue against the order of the tribunal in Urban Ladder has been disposed of by a division bench, saying that
Let me
this is
see.
not royalty.
List on 11/9. The understanding is that the matters would be heard and disposed.
Lords, interim relief.
Interim relief, yes.
Same time.
Same order.
The problem is not whether it is a royalty or not, it is a question of fact. The several writ petition, ITA matters are pending before the division bench. A batch of matters in
Senior
case
counsel
of
says it
assessee.
is disposed.
No, my lord, ITA cases, it is disposed of in some other matter, but
I
facts
will
are
see. On
different in this
11/9 we'll
case.
see. Yes.
Please.
Same order, Jay. Other interim order.
Are you hearing 11?
Make please, my lords. Lords.
Yes, sir.
My lords, there are two writ petitions here, 2008-9 and 9-10. And the one that is got listed is 9-10. The other one is next. So my lords may most kindly take the 2008-9 writ petition 52319, because this is the first of the 2 years. And if this is disposed, my lords, the other one also will follow suit.
Yes.
And before I proceed, my lords, there is one IA, which my lords may most kindly consider, that the name of the petition has changed from Mindtree to LTI Mindtree.
That
IA may most kindly, my lord.
will allow that. Yes. For the reasons where the application is listed. Idea Nodi? Application. It's not listed.
Application. So filed on 1st of August.
Oh, that's
may have been
not-
missed out.
That's pretty. Order being satisfied so and so. Allowed the petitioner to amend the cost title by transposing measures Mindtree Limited to that of, so other lane is there.
Yes.
Yes. Yes, next.
Lord, this is the petition of 2019, my lords. Notice was issued, my lords, and the interim stay was granted. So my lords may most kindly dispose it today. This is on the issue, my lords, as to whether.
Beyond limitation.
Yes, my lords.
Yes.
Whether there are two issues, there are several grounds on jurisdiction. Most prominent one, my lords, is this notice barred by limitation? If my lords are with me on this, I would not burden my lords on whether it couldn't have been even within the limitation for eventually passing the order in terms of section 153.
No, if I accept limitation,
On
nothing
issue
else
of-
need be gone into.
Nothing else needs to be gone into, my lords. Now, my lords, this is the notice that was issued on 29/3/2019, which my lords will find in annexure A at page 67.
Yes.
And before I take my lords, if my lords would permit, the law of reassessment has undergone a paradigm shift from 1/4/2021 onwards. Therefore, my lords may kindly allow me to explain very briefly what is the law that existed then. My lords, wherever the assessing officer will have a reason to believe that any income has escaped assessment, my lords, he has the ability to assess or reassess such income in terms of section 147. However, my lords, 148 would require him to issue a notice. And my lords, under 148 subsection 2, before he would issue the notice, there is a jurisdictional condition that he has to record the reasons for right issue of reasons will have to be recorded in writing. Now, my lords, once the 148 notice is issued, which is basically requiring the concerned assessee to file a return of income, then my lords, the assessee would have to file a return of income. Proceedings would go on, and the eventual reassessment order would be passed. This was the position. In the meanwhile, what used to happen, my lords, is a lot of litigation started arising as to whether the jurisdictional requirements in terms of recording reasons, did the records indicate proper reason to believe, and is the issue of notice within limitation, is there a borrowed satisfaction? Several such jurisdictional grounds would arise, and therefore the petitioner started knocking the doors of the Honorable High Court. Then, my lords, different high courts handled it differently. The Honorable Supreme Court, in a decision called GK and Drive Shaft, 259 ITR, page 19, my lords, held that if a notice under 148 is issued, the first thing the assessee has to do is to file its return without anything else. Then ask for the reasons. As soon as the reasons are sought, the assessing officer is bound to issue those reasons to the assessee. Then, my lords, on the basis of reasons, the assessee will have to file a detailed objection if he chooses to so do. And if he files those objections, the revenue is expected to dispose the objections in the manner of a speaking order. This is some sort of a procedure laid down by the Honorable Supreme Court. Post 1421, it has become codified by the statutory amendment itself. I'm explaining this because my case related to prior to
the amendment.
Yes, my lords. So accordingly, my lords, in these two cases, starting with assessment at 2 and 2008-9, a notice was issued, my lords. Then, my lords, the assessee files its return. Then, my lords, assessee would seek the reasons. Then, my lords, the reasons were furnished. And after the reasons were furnished, my lords, the assessee would file its objections, which my lords will find in Annexure Q. These objections were overruled by an order in Annexure C, my lords. And thereafter, notice under 143(2) have been issued, which is in Annexure D. So, petitioner, my lords, is approaching this Honorable Court after exhausting the procedure with the Honorable Supreme Court in GK interruption. So, therefore, my lords, the petitioner seeks quashing by this Honorable Court of the Annexures A, which is a notice, my lords. Annexure B, which is reasons recorded, my lords. Annexure C is the order of the revenue overruling the objections. And Annexure D, my lords, is a notice under 143(2) proceeding to reassess. These are the four annexures. Now, my lords, the first of the most important grounds here, my lords, is that this notice that is dated 29/3/2019, which my lords will find in Annexure A at page 67.
Yes.
The assessment year 8-9, my lords, the first submission, it is time barred. For this, my lords, may have to kindly take section 149, again prior to amendment
IT code.
by Finance Act of 2021. If my lords were to kindly take the Income Tax Act,
149.
section 149, as it then existed. Lords, the extract also is given in a compilation for the convenience of my
That's
lords.
better.
If my lords are referring to Income Tax Act of 2025, my lords.
So I'll take this as the reference point. In this, which page?
Page 4, my lords.
Yes.
My lords, may most kindly notice this and allow me to read this, my lords. No notice under section 148 shall be issued for the relevant assessment year, clause A, if 4 years have elapsed from the end of the relevant assessment year, unless the case falls under clauses B and C. Then, my lords, clause B, if 4 years, but not more than 6 years, have elapsed from the end of the relevant assessment year, unless the income chargeable to tax which has escaped assessment amounts to or is likely to amount to 1 lakh rupees or more. And C, my lords, may not apply to my case here because it would apply an extended period of 16 years if the income escaping assessment is from an asset which is located outside India. That is not the case here. So therefore, my lords, my case would come under clause B.
Yes.
Which says no notice under section 148 could be issued after the expiry of 6 years from the end of the relevant assessment years. Assessment year, my lords, is 8-9. 6 years would mean, my lords, 31st March of 2015. The instant notice being dated 29/3/2019, my lords, on this premise is time barred. However, my lords, may most kindly take the next 150. Department, my lords, as my lords would see the impugned notice, has issued this notice under section 148, read with section 150.
Yes.
So this becomes important, my lords. Section 150, subsection 1. Notwithstanding anything contained in section 149, my lords, may most kindly notice this would completely override the time limit of 149. Yes. The notice under section 148 may be issued at any time for the purpose of making an assessment, reassessment, a recomputation, in consequence of or to give effect to any finding or direction contained in an order passed by any authority in any proceeding under this Act by way of appeal, reference, revision, or by a court in any proceeding under this law. Lords, if there is an order of the Superior Appellate Forum or, my lords,
The court.
order of the Honorable Court under any law for time being in force, which will have possibly a bearing on tax as well, then, my lords, no time limit of 149 would apply. If an order of assessment is to be passed, my lords, in consequence of or to give effect to any finding or direction contained in that order. Now, my lords, with this background, my humble submission, my lords, is if my lords were to take the case of section 150,
Yes.
and also, my lords, if my lords were to see as to why this notice is issued, it requires one small explanation that what happened, my lords, is in the instant case, the assessment was made in a non-existing entity's name called Aztec Soft Private Limited. Lords, the Honorable Supreme Court in Maruti Suzuki's case in 416 ITR 613 held that if an order is passed in the name of a non-existing entity, particularly when there is an amalgamation of that entity with another entity, under the Act, my lords, it's impermissible to pass an order in the name of a dead entity. And accordingly, my lords, the petitioner in this case, when an order of assessment was passed against it in the name of Aztec Limited, which was no longer the company then existing, because on 1/4/2009, my lords, appointed date, it got merged. So at the time when the impugned orders were passed, this company did not exist. It went to the learned tribunal. The learned tribunal gave an order, which my lords will find in Annexure E at page 81. Which order is dated, my lords will find it in Annexure E at page 76 rather.
76. Yes.
This order was delivered by the learned tribunal on 8/12/2017. There, my lords, inter-alia amongst various grounds, including grounds on merit, this ground of jurisdiction also was raised before the learned tribunal. So, my lords, may kindly now go to page 81, where after hearing all the parties concerned, the learned tribunal, my lords, at para 5, my lords, may kindly go to page 80 rather, para 5. Are my lords there?
I am there.
May I read this, my lords? We have considered the rival submission. We find that in the written submissions filed by the DR, the revenue has produced before. This is the main contention, that since the assessment order, along with the name of merged company, the name of the successor company is also mentioned, it cannot be said that the assessment is completed in the name of merged entity. Regarding the submission of the learned DR of the revenue, we find that in the case of Principal CIT versus Maruti Suzuki also, the assessment was passed in so and so. Hence, it is seen that in that case also, the facts are same, and still the issue was decided in favor of the assessee by the Honorable Delhi High Court. In that case, by following another judgment of Delhi High Court rendered in spice infotainment. This judgment of Honorable Delhi High Court rendered in spice infotainment was already confirmed by the Honorable Supreme Court. Hence, in the present case also, we hold, by respectfully following these judgments of the Honorable Delhi High Court,
Yes, it was in your favor.
It's in my favor.
Yes.
Then, as my lords could kindly see at the end of that para, this is important, my lords. I may just read this para completely, my lords, because this may be relevant to 150.
Yes.
Hence, in the present case also, we hold, by respectfully following these judgments of Honorable Delhi High Court, that the assessment order framed in the present case in the name of amalgamated companies bad in law, and the same is quashed, although, this is important, my lords, although we make it clear that the department may proceed for making assessment in the name of merged company Mindtree in accordance with law in terms of provisions of the Income Tax Act of 1961 as held by the Honorable Karnataka High Court in the case of Intel Technology Private Limited. Lords, what the learned tribunal did is, it did not give any finding or direction as would enable, my lords, the department to proceed. It only basically quashed the order that is passed in the name of a non-existing entity. what maximum, my lords, if I may most humbly submit, it did is to leave a liberty with the department, do what it wants to do
In accordance with law.
with law. Therefore, my lords, my most humble submission is there is no such finding or direction. These words which come in the end, my lords, could not be called as a finding or direction, because in order that it is a finding, my lords, such finding will have to be necessary and relevant for the disposal of the case.
True, even if you take it that they were given liberty to make the assessment.
Exactly.
In accordance with law in terms of the provisions of
Exactly.
IT Act. So 149 will definitely kick in.
Definitely will kick in.
Yes.
Definitely will kick in.
That's the
Crux of the matter. I would not burden my lords with enormous citations and the decisions and the precedent cases on this, unless my lords it's necessary, depending on what the learned friend has.
Hear him on that.
Yes, yes, yes.
Yes, Raviraj.
My lord, may I bring before my lordship certain facts, like originally, my lord, there was a company called Azsoft Limited. That got merged with the petitioner company, Mindtree. Then, my lord, notices came to be issued in the name of the merged company.
One clarification, sir.
My lords.
The first notice that was issued to Aztec or whatever, the company that already been merged with Mindtree.
During the original assessment.
True. Was that notice within limitation?
My lords, may I explain this, my lords? It was.
So was that notice within limitation?
I'll explain this, my lords. First of all, it was not a notice of reassessment. Therefore, my lords, section 148, 147 did not apply.
Where is that note? Where do I get that notice?
I'll come to it, my lord. Let me just explain what the law was.
1 minute. Yeah.
My lord, this was a case of an original scrutiny assessment. It was well within time. A notice was issued in the name of Aztecsoft under section 143(2). This is the first ever proceeding that kick-started at the instance of the revenue. Then, my lords, then there was something called in the course of assessment reference to the transfer pricing officer, because it did have some international transactions which would require under section 92 arm's length pricing of those international transactions, because of related parties, in order to ensure that there is no flight of the tax base. Then once the transfer pricing officer would recommend, my lord, some sort of a transfer pricing addition, then law under 144C would kick in, where, my lords, the assessing officer has to pass a draft order that will go to an authority called dispute resolution panel called DRP. Then DRP will give its directions. Then the assessing officer will pass a final order in terms of 144C13. Against that final order, there is no first appeal, the direct appeal to the tribunal. So in the instant case, there was a direct first appeal to the tribunal. Exactly. Therefore, my lords, those questions may not arise in this.
Why? To make myself clear,
Yes.
I just wanted to know whether the first notice issued to a non-existing entity, which was non-est in the eye of law, what the tribunal holds, was that within limitation?
It was within limitation.
That's all. That's
Yes.
My lord, it was
sorry,
within
I had
limitation.
to take my lords to the earlier position also of 143(2).
No problem.
Yes.
My lord, the earlier notices issued were within limitation. They were being responded to. Appearances were made. When repeated notices were issued, the fact of merger was not brought originally.
No.
Page number 78.
Fact of merger was what?
Page number 78, my lord.
Come to page 77. Thereafter, submitted that the impugned assessment order was passed by the AO on so and so much after the merger date and date of intimation.
That is
merger
not
assessment,
disputed. That is not. I'm not disputing that. What I'm saying is,
merger was brought to the notice.
That's why, later on. See, during the time, that's what the submissions before the tribunal on facts, undisputed facts, the dates of notices issued.
Just to my lords, save my lords time. All whatever my learned friend is arguing, my lords, ought to have been argued before the learned tribunal, which clearly held.
That was my next question.
Yes. And therefore, my lords, now getting to those facts which have now become found as final in terms of section 254, it has become final. Department has not challenged this. Therefore, my lords, to go back to those, would my lords.
Let me see. Chaitanya sir, I'll take, yes.
My lord, my case is, my lord, in page number 78, the facts are clearly submitted there.
Yes.
My lord, I'll start from para 4, then I'll come back to 3 at the end. It is observed that the SSC, my lordship,
Now, Raviraj,
page 78.
you have suffered this order. Now, after suffering this order, what remains with you is action in terms of the order. Whatever liberty the tribunal had granted to you, you have to exercise. The liberty is found only in 81.
Please.
In page 81, hence in the present case, from there, case also we hold respect to so and so. Although we make it clear that the department may proceed for making assessment in the name of the merged company, that is mandatory, in accordance with the law and in terms of the provisions of the IT Act. So you cannot act, you cannot issue notice dehorse law. It is only in accordance with law or the Act. Now, if 148, 149 is kicking in this, saying beyond 4 years you can't make the assessment, then how are you now making an assessment of 8 and 9 by issuing a
Shelter only
notice in
under
2019?
My lord, we are taking shelter only under section 150. My lordship holds, my lord, it's, then we are out.
No, under 150 is another thing. Now, inter partes, this has become final. The tribunal finding only in accordance. Now you have issued notice. That is why deliberately you quote it as 149, 148 read with 150, because 148 power you have lost already. So 140, 150 on what circumstances you can?
If there is a finding or direction.
Yes, sir.
My lords,
That's
is
all.
no more res integra. The Honorable Supreme Court, my lords, in Rajinder Nath's case,
150.
on 150, in 120 ITR, page 14, my lords.
You have it in this compilation?
Yes, 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 my lords. Yes, page 123, my lords. Page 123, my lords.
Yes.
This is the decision of Honorable Supreme Court, my lords, in Rajinder Nath versus Commission of Income Tax.
Yes.
In 123, my lords will find this.
Yes.
There, my lords, if my lords were to go to the para 11, para 11, my lords, the expressions finding and direction are limited in their meaning. A finding given in an appeal, revision, or reference arising out of an assessment order must be a finding necessary for the disposal of the particular case. That is to say, in respect of the particular assessee and in relation to particular assessment year. To be a necessary finding, it must be directly involved in the disposal of the case. My lords, kindly allow me to take a pause here. In this case, what is the necessary finding? That the order has been passed in the name of a non-existing entity is the necessary finding, which is necessary for the disposal of the case. Whether granting liberty thereafter was necessary for holding that the assessment in the case of hashtag soft name is bad or not, that is not a necessary finding, is what, my lords, the Honorable Supreme Court is trying to say. It is possible in such to be a necessary finding, it must be directly involved in the disposal of the case. It is possible in certain cases that in order to render a finding in respect of a finding in respect of B may be called for. For instance, the facts show that the income can belong either to A or B and to no one else. A finding that it belongs to B or doesn't belong to B would be determinative of the issue whether it can be called as A's income. A finding respecting B is intimately involved as a step in the process of reaching the ultimate finding respecting A. If, however, the finding as to A's liability can be directly arrived at without necessitating a finding in respect of B, then finding made in respect of B is an incidental finding only. It is not a finding necessary for the disposal of the case pertaining to A. The same principles seem to apply when the question is whether the income under inquiry is taxable in the assessment year under consideration or any other assessment year. As regards the expression direction in section so and so, it is now well settled that it must be an express direction necessary for the disposal of the case before the authority or court. It must also be a direction which the authority or court is empowered to give while deciding the case before it. The expressions finding and direction in so and so is not of the act but must be accordingly confined. Section 153 is not a provision enlarging jurisdiction of the authority or court. It's a provision which merely raises the bar of limitation for making an assessment under section 143. The question formulated by the tribunal raised the point whether AAC would convert the provisions of 147 into those of 153. in view of section so and so, dealing with limitation merely, it is not easy to appreciate the relevance
Yes.
or
Now,
validity of
Chaitanya
the
sir.
Yes, sir.
Now, if you juxtapose 151 and the paragraph that you are now reading, now if you come to 150
Yes, my lords.
and say to give effect to any finding or direction contained in an order passed by the authority in any proceeding under this act by way of appeal. So that is the appeal. Reference or revision by the court, that is not. Now we are restricting it by way of an appeal.
Yes, my lords. Yes,
Now, if the appeal order is seen,
yes, my lords.
liberty is reserved.
Yes.
Liberty is reserved to act in accordance with law, in accordance with the Income Tax Act. Would it not be in effect of giving taking
Direction.
the direction to its logical conclusion of what the tribunal has said?
That also is answered by the Honorable Supreme Court.
Which
If I may go to this, my lords. Para 13.
para
Para
13.
13. My lord's question is very pertinent.
Yes,
What is the meaning of direction?
that is what. If the tribunal has given certain direction, to give effect to the
Is it
direction,
a
150
direction
is.
at all or not?
That's yes.
My lord, before I would go here, one more aspect that needs to be kindly appreciated. It is not the case of the revenue that there is a direction. It is the case of the revenue that
There is liberty.
No, in the notice, and in the reasons to believe, the case is that there is a finding, and the case is not that there is a direction. In any whichever case,
If finding or a direction, 150 is applicable.
Para
Yes.
Or
13.
it says finding or direction.
That correct.
Para 13, my lords.
Yes.
It is also not possible to say that the order of AAC, Appellate Assistant Commissioner, then existing,
Yes.
contains a direction that the excess should be assessed in the hands of the co-owners. What is the direction for the purpose of 153(3)(2) of the Act has already been discussed. In any event, whatever else it may amount to, on its very terms, the observation that the ITO is free to take action to assess the excess in the hands of the co-owners cannot be described as a direction. A direction by statutory authority is in the nature of an order requiring positive compliance. When it is left to the option and the discretion of the ITO whether or not to take action, it cannot, in our opinion, be described as a direction. Therefore, my lords,
No qualm. Finding?
I'll come to my lords.
Yes.
So, my lords, I have cited this para 13 to say that there is no
direction.
Now, finding, my lords, is what?
Yes.
There has to be a finding that is necessary for disposal of the appeal. My lords, what was the appeal before the tribunal? The order in the name of the non-existing entity is bad. Now, my lords, the tribunal unequivocally held that this is an order in the name of a non-existing entity. That is the finding.
Yes.
Anything else it says, it's open to you to do what you want to do, cannot be called, my lords, in my most humble submission, a finding, because that is not necessary for disposal
So,
of the ground.
according to you,
Yes,
the appellate order has neither a finding nor a direction.
Exactly, my lords. Exactly.
So, it cannot be, the notice itself is non-est is what you say.
Any finding which is, my lords, extraneous to the core issue, that is the list before the learned court, my lords, cannot be called as a finding, because the Honorable Supreme Court in para 11, as my lords just have noticed, that it has to be a finding necessary for the disposal of the appeal.
Correct. It should have, should be
And this
correlated there.
Exactly. And this is the position, my lords, which is existing even prior to 1922 Act. In 52 ITR 335, Muralidhar Bhagwan Das case, the Honorable Supreme Court, my lords, then under the then existing law itself started this principle. It continues right till the date. It has not undergone a change even after the paradigm shift in the reassessment from Finance Act of 2021. This section remains completely unchanged and untouched. Therefore, my lords, my most humble submission is this is an order which simply annulled an illegal order, didn't do anything else. Whether or not the tribunal said so, another submission, my lords, whether or not the tribunal expressly gave the liberty always remained with the revenue. If they could have done anything under law, they could have always done. The tribunal did not have stated it.
No, they are aware they cannot do anything in law. That is why 150 is quoted.
150, my lords.
No, that is correct or not, we will write.
Exactly.
But the only shelter they had was 150 and nothing
However,
else.
my lords, it's a case of reassessment, not like regular assessment. Time limits are to be strictly adhered to. This is what, my lords, the Honorable Supreme Court in the latest decision, Rajiv Bansal, has reiterated it. Right from Calcutta discount days, 4180 or 191 in the context of section 34 of the 1922 Act. It continues even now, my lords. Limitation for reassessment is sacrosanct. Parshuram Patri case in 10680 or 1 also has reiterated it.
Yes.
So
Shana?
one submission, my lord. Whether there's a finding has to be appreciated in the background of the name of the, while completing the assessment came to be completed, the nomenclature was Messrs. Assoft Limited, now merged with Messrs. Mindtree Limited.
When was the merger?
Merger was, my lord, from 1/4/2009, approved by the this court on 9/6/2009.
9/6/2009.
2009.
Notice is issued on?
Notice is issued, my lord. I'll come to that, my lord.
In the year
Notice
2012?
Around that.
Notice
2012.
is issued on 27/8/2009,
27 after the merger.
after the merger in the name of the old company.
Yes.
An appearance is made, they make the appearance, then subsequently 140 on 9/1/2010, after the merger, the notices came to be issued in the name of Aztec Soft Limited, now merged with Mindtree Limited. Assessment came to be completed in the name of the old company, but the nomenclature was now merged with Mindtree Limited with the new address.
That is the assessment
That
made.
is so in that background, there is a finding. There was a whether it has been.
Why now merged? You should have taken the merged company itself. Why do you want to bring in and suffer an order of the tribunal? And you have not challenged that order of the tribunal. Now the issue remains, as the senior counsel said, is with regard to finding or a direction that you can use to bring in 150 in the teeth of bar under 149, 148, 149 rather, yes. Ashton will answer, yes. Heard the learned senior counsel Chaitanya appearing for the petitioner and Y. V. Raviraj reserved.
Great low blood.
ಅದು ಒಂದು ನಿಮಿಷ.
Please, my lord, we have
Yes,
somebody
sir.
to mention that item number 10. My lord adjourned it to 11th.
September.
September.
Yes.
Because the earlier years had come up yesterday.
Where?
Before
the court.
Before the court, but
Ah.
yesterday was not a tax day.
I know,
So
I have
all those-
adjourned it to 49.
So if this could also be kept on.
49. No problem. ಅದು ಬೇರೆ ಎಲ್ಲ 49 ಗೆ ಹಾಕಿದ್ದೀನಿ. 49. Yes. Yes, next. 49 ಬೇರೆ ಯಾವ್ದು ಹಾಕದ್ನಲ್ಲ ಅವ್ರದ್ದು. 49 matter to 18th. We'll see. Let it come on 49 because I've already signed those papers. 49 ಬಂದಾಗ we'll do it. We'll see on that day. Yes.
My lords,
Faceless.
yes, my lords.
We'll close it. Which is the judgment?
Judgment, my lords, batch of petitions are pending before this honorable court.
With numbers ಕೊಡಿ ಎಲ್ಲ.
I'll furnish.
Give me all the numbers.
My lords, they have not filed the response to 148 AB, my lords. Let them file a response, my lords. It's ex-parte order being passed today. Let them file a response, my lords.
See, this notification covers 29th March 2022.
Yes, my lords.
Notice is issued when?
Much later, my lords, 2023.
How could you issue the notice?
Yes.
Batch, give me all the batch matters.
I'll furnish, my lords.
Give everything. The petitioner is before this court calling in question a notice issued to the petitioner, calling in question a penalty order under section 271(1)(c).
Assessments are also.
Assessment is all subject to challenge, my lords.
Assessment and penalty orders are also.
Where is the prayer? Your prayer itself is 2 pages. 148A, B, D. Give me the numbers, all the numbers of all the petitions.
Okay.
We'll post it on 21st with all the matters. Stay ideally.
Yes, my lords.
List the matter on 21st along with all connected cases concerning concerning hyphen faceless.
Issue is pending before the apex court, my lords. My lords, that Delhi
ಅಲ್ಲ
High Court
ಇಲ್ಲಿ
is-
coordinate benches have not quashed it.
No, my lords.
Nobody has done.
My lords, in fact, Delhi High Court is in revenue favor, my lords. There are
Which is that Delhi High Court judgment?
lords, I'll give the TKS builders, my lords. I'll give the copy, my
Give the
lords.
copy.
In case, my lords, apex court, following the Telangana High Court,
My lords,
which
the
was
recent-
challenged in SLP.
Telangana High Court has held in the favor of the SSC.
Yes, my lords, that was, against that an SLP was filed. Supreme Court dismissed the SLP. my
Where are
lords.
those?
My
You
lords,
should
it's-
give everything.
my lords, those, it's been recalled, my lords. I'll give all the
Yes, sir.
orders.
Supreme Court has recalled it.
Please, my lords, it has been reached. My lords, the recent High Court, my lords, is the Delhi High Court. They've referred all the judgments, my lords. Calcutta and Delhi is in favor of revenue, my lords. I'll give all the judgments.
Please give everything. Lest we should not pass some order conflict. Yes. You should give everything, keep everything ready.
Earlier,
Either I'll dispose all these things.
My lords, during lunchtime, I'll please.
During lunch, 21st, I'll post everything. You give me everything. Yes.
13.
ಹನ್ನೆರಡು ವರ್ಷದಿಂದ ರೀಫಂಡ್ ಕೊಟ್ಟಿಲ್ಲ.
ಹಾ.
106 ಸಲ ನಾವು ಹೋಗಿದೀವಿ.
ಈಗ ಯಾವಾಗ
ವರ್ಷಕ್ಕೆ
ಕೊಡ್ತೀರಾ?
45 ಲಕ್ಷ ಅಷ್ಟೇನೆ. ವರ್ಷಕ್ಕೆ ನಾನು 6,000 ಕೋಟಿ ನಾನು ನಮ್ ಗ್ರೂಪ್ ಅಲ್ಲಿ ಟ್ಯಾಕ್ಸ್ ಕಟ್ತೀವಿ.
45 ಲಕ್ಷ ಕೊಡ್ತಾ ಇಲ್ಲ.
ಅಲ್ಲ ಬರೀ 45 ಲಕ್ಷ. ಇಲ್ಲಿ ರಿಪ್ಲೈ ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ನೋ ರೆಮಿಡಿಯಲ್ ರೀಫಂಡ್ ಇಸ್ ಡ್ಯೂ ಬಟ್ ನೋ ರೆಮಿಡಿಯಲ್ ಆಕ್ಷನ್ ಕ್ಯಾನ್ ಬಿ ಟೇಕನ್ ಅಂತ. Page 102.
Sir J, no remedial action is because the reason is that assessee has claimed less credit of TDS.
Then what I have
In the
paid.
26 years there is more. There is a difference, my lord. My lord, what I would humbly submit is, my lord, they have filed one letter to the assessing officer, which is at annexure A, A1, A2.
Correct.
This ನಾಲ್ಕು we will consider why it could not be considered is it was filed beyond 4 years time. 154 only 4 years is time is for the assessing officer to consider. So he cannot do it because it is
We'll
beyond his
direct him
power.
to consider.
Within 6 weeks we will consider that.
ಟ್ಯಾಕ್ಸ್ ಕ್ರೆಡಿಟ್ ಗೆ ಲಿಮಿಟೇಷನ್ ಇಲ್ಲ. 265 ನಲ್ಲಿ ಇಫ್ ಯು ಕಲೆಕ್ಟ್ ಮೋರ್ ದೆನ್ ವಾಟ್ ಈಸ್ ಲಯಬಲ್ ದೇ ಹ್ಯಾವ್ ಟು ರಿಫಂಡ್. ಸೊ ಯು ಕ್ಯಾನ್
ಅದಕ್ಕೆ 4 years ಅಂತ ಎಲ್ಲಿದೆ? Refund 4 years ಎಲ್ಲಿದೆ?
Refund ಅಲ್ಲ.
written.
Assessee has filed a letter for rectification of his return.
Rectification 4 years limitation ಇದೆಯಾ?
154 ಗೆ assessing officer from the end of the
Rectification,
financial
not
year 4
refund.
years is the time for it.
Anyway, shall we dispose it with the direction?
Yes, Lordship, there is a already.
There is
similar
one
matter.
more order which is produced at annexure H where rectification is already passed for assessment year 15-16. That within 2 months we will credit the amount.
Let them consider and consider it also.
The petitioner is before this court seeking a direction to the respondent to refund the principal amount of 40,79,638 along with interest under section 244A of the Act up to the date of refund on the score that excess tax was paid.
TDS.
Excess TDS was paid. ಅಲ್ಲ ಅದು ಕರೆಕ್ಟ್ ಟ್ಯಾಕ್ಸೇ. TDS ವಾಪಸ್ ಕೊಡಲ್ಲ ಅಂದ್ರೆ ಹೆಂಗೆ ನೀವು ಜಾಸ್ತಿ ತಗೊಂಡು?
ಮಾಡಬೇಕು ಅದರಲ್ಲಿ ಏನಾಗಿದೆ
ಅದು ಕ್ಲೈಮ್ ಮಾಡಿದ್ಮೇಲೆ ಕೊಡಲ್ಲ ಅಂದ್ರೆ ಹೆಂಗೆ? ವಾಟ್ ಇಸ್
because of that adu now everything is under CPC. The moment there is a difference they don't allow it. That's all.
The learned counsel appearing for the petitioner submits, despite plethora of representations being submitted by the petitioner, refund is yet to be granted of an excess TDS payment that is made. The learned counsel submits excess TDS payment cannot be withheld by them. It has to fall back to the account of the assessee. He would seek to place reliance upon the judgment rendered by the coordinate bench in writ petition so and so. The coordinate bench, while answering a similar contention, has held as follows. In the light of the issue standing answered, the learned counsel for the respondent Arvind Chavan submits that within an outer limit of 6 weeks, the representation of the petitioner would merit consideration and appropriate orders in accordance with law would be passed, bearing in mind the reason for submission of the letters, communications to the respondent, i.e. refund of excess TDS paid. In the light of the said submission, I deem it appropriate to direct the dispose the petition with a direction to the respondent to consider the communications made for the purpose for which it is made, bearing in mind the provisions of the law, and pass necessary orders within 6 weeks,
And also issue refund if
and pass necessary orders within 6 weeks, for the purpose ಅಂತ ಹೇಳಿದಿನಲ್ಲ, then I will be determining everything.
order ತಗೊಂಡು ನಾನೇನು ಮಾಡಕ್ಕಾಗಲ್ಲ. If I am eligible for refund, let
That is
them issue.
correct. So and so. And if the petitioner is found to be eligible for refund in terms of law, such refund shall be made over to the petitioner without driving the petitioner again to knock at the doors of this court. Ordered.
Lordship, one small request. Instead of TDS, Lordship may mention as tax.
ಆಯ್ತು, ಟ್ಯಾಕ್ಸ್ ತಗೊಳ್ಳಿ.
Much of that.
ಅದು ಟ್ಯಾಕ್ಸ್. ಎಸ್
14.
ಎಸ್. Then covered ಆಯ್ತು. Against you. File an appeal, sir.
My lords, your lordships may grant me 2 days time. I could not examine the judgment, my lords.
What? 107 appeal ilva?
No, 107 appeal is there. My case before your lordships is, my lords, no notice is given to me prior to the order that was passed, my lords, under 129. My lords, facts, my lords, of the case are, I would send gold bars from Bangalore to my cousin in Bombay. There is no sale transaction at all. All notices, my lords, are allegedly said to have been given to the logistics person, my lords, who was carrying my gold bars for the purpose of making jewelry for my personal use. And that too to my own cousin.
Personal use, yes to?
Gold, my lords, worth about 9 lakhs.
9 lakhs?
9 lakhs. Personal use. There is absolutely no sale transaction at all.
Copy to the logistic persons and driver of the vehicle, everyone, they have a well information. They have not, despite that they have not appeared before the authority.
It is not appeared, no notice. Put it, give me all that.
I have made a notes also.
Put it.
And judgment copy also I have produced, covered by this honorable court. Yes, my lord.
Or demand.
They're pleading now, we are innocent. We are not at all,
Our
don't know
contention.
anything.
No, my lord, our contention before your lordship.
No notice, you have not appeared.
No, my lord,
yes,
it is.
my lord.
My lord, no notice is submitted. No, my lord,
They
my
are
case
well
before.
aware.
My lord, permit me to make
This
this
honorable court
submission.
doesn't arise.
My lord,
If you want, you file an appeal if it is available in law. Notice is not issued once but twice.
No,
Thrice issued, my lord. Even
It looks
uh,
thrice, yes.
9 also passed and served
It's
to
some-
the logistic person. They are not made a party
It
to
is
him
submitted.
also in this writ petition. Cleverly drafted.
Logistic person.
My lords, I did some limited research, my lords, on this GST. Now, my lords, my very humble understanding is that, my lords, a logistic person is entitled or is, my lords, legally obligated to carry only a sale invoice and a e-way bill when he is transporting goods from place X to place Y. Now, what is the origin of these goods? What is the intended purpose of the goods that he is, my lords, taking from place X to place Y? He is not, my lords, the person who has knowledge of the same. Now, my lords, the authorities, in the event they find any discrepancy in the manner in which these goods have been transported, are obligated, my lords, to issue me a notice, because it is only me who will be, my lords, entitled to, my lords, will have knowledge about what is the purpose of the origin of these goods. My logistic person will only be, my lords, having limited knowledge to only take these goods from place X to place Y. And in this case, my lords, my case is, my lords, that this gold bar was sent for personal use. When it is for personal use, my lords, there is no
Notice
element
should
of
be
sale.
sent to you.
Notice ought to be sent to me, because
what-
there is no element of sale. Had there been an element of sale, my lords, there could have been a sale invoice and a e-way bill.
Let's look into this.
Very good. Lordship may have it
21st.
next. Very good.
My lord,
There is no stay.
want at all, let them remand back for the authority, my lord. Let them go and fresh.
We'll
make
see.
an,
21st will pass that order. He wants time. Let him.
Original.
Original ತಗೊಂಬಿಡಿ. List on 21st.
Very good. I'm so very
We
good.
should finish it. Yes.
So very good.
ಇದು file. Yes, next.
15.
I am for the petitioner in this case, my lord. This is dispute under the income tax, my lord, for the assessment year 2017-18. The ex-parte
Time you are appearing. ಎಲ್ಲ ಯಾವಾಗಲೂ ನನ್ನ appears.
I will take
Learned
notice for
Counsel
respondent.
EI Sanmati accepts notice for the respondent. We'll take it on 28th.
Please, ma'am.
Petitioner to serve set of, no copy?
No copy.
Petitioner to serve set of papers upon the aforesaid counsel forthwith. Ex-parte assessment.
Please, ma'am.
List on 28th.
Not to precipitate further till the next date. My
ಏನ್
prayer, my
precipitate
lord.
ಮಾಡ್ತಾ ಇದೆ?
Recovery, my lordship is aware that once a demand notice is there, they can attach any time the backup.
The assessment order, in the light of the allegation that the assessment order is ex parte without hearing the petitioner, till the learned counsel, AI Sanmati would go through the papers and make his submissions. The respondent shall not precipitate the matter. Yes.
16.
We need short judgment. Only yesterday night we received the objections.
Sorry, my apologies.
Learned counsel submits that objections have been served upon the petitioner last evening, date hakpadi. List the matter on 4/9. Yes.
17.
Notice not
Ex-parte
issued.
assessment order.
Notice not issued.
Notice is issued.
143.
It's the regular assessment order. They've not participated, my lords, it's an ex parte order. My lords, the assessment order is at, my lords, page 82, my lords, annexure H1.
Yes.
Lords,
We'll send all these things back.
Please.
All
So
ex
your
parte
lordships may
orders.
kindly restore, my lords, let them file reply, my lords, to the notice under 142(1). The lordships will get at page number 83.
We will read down that as notice and send it back.
Please,
My lords, lordship may send it back to 143(2) notice, my lords. It is at page 6. 143(2), my lords, is at
140?
page 50.
Page?
Page 48, my lords. 143(2).
Lords, page 84, your lordships may kindly
One
refer.
minute. We'll take both the submissions. This is 143(2) notice.
Yes, my lords.
Yes.
This we intend to challenge because there is no reason. If it is sent back, my lords, we'll file response to this notice.
Which is the first notice you got, sir?
First notice was received on 1/6/2023.
That is 140, this is 143 notice. We'll send it back to the authority
Yes, my lords.
to
140.
redo from this stage.
143(2), my lords.
A reply to 140.
Lords, at page number 84, my lords. Your lordships may kind.
48 ಯಾವ್ದು ಮತ್ತೆ?
Lords, there are multiple notices issued, my lords. In the assessment order, he makes a reference to all the notices issued.
One moment, sir.
Page number 82 is the assessment order.
Ah.
Lords, over the page, at page number 84, my lords, these are
This
the
is,
notices.
this is the assessment order, which is ex parte.
Please, my lords.
Right. Now, the notice that is issued is under 143(2) at page 48.
Please, my
We
lords.
will send it back to that stage.
Please, please.
The petitioner is before this court seeking the following prayer. In following prayer ಅಂದ್ರೆ 5 page ಇದೆ ಅದು.
ಅದಾದ್ಮೇಲೆ penalty order issue.
It's all consequent.
Consequences.
The petitioner calls in question a notice under section 143(2) of the Act and all consequential orders which culminate in an order, assessment order dated
Lords, 1st February 2024.
So many, one minute, sir. What's the order?
Assessment order, my lords, 1st February
Which
2024.
culminates in an order dated 1/2/2024. The subsequent actions of issuance of demand is made pursuant to the assessment order impugned there, pursuant to the assessment order quoted, which are also impugned in the petition. The petitioner is an assessee. A notice under section 143(2) of the Act is issued by the respondent revenue. What is this for?
My lords, this is for taking scrutiny, my lords, taking
Scrutiny
for,
assessment. Case was selected for scrutiny
For,
assessment.
yes. By which the tax of the petitioner was taken up for scrutiny assessment and further proceedings are drawn. This results in the assessment order dated 1/2/2024 determining certain penalty to be paid. The learned counsel for the petitioner takes this court through the documents appended to the petition to demonstrate that the proceedings before the assessment officer were ex parte. The order of the assessment officer also would indicate that the petitioner has not appeared before, nor a notice was issued under 143 to the 143 one adu
143(2), my lord.
143(2) for the appearance of the petitioner. The learned counsel for the petitioner submits that since the proceedings are ex parte, the matter be remitted back to the hands of the assessing officer from the stage of issuance of a notice under 143(2), and all further proceedings be obliterated in the light of the fact that the proceedings are in violation of principles of natural justice, as it is admittedly an ex parte proceeding. The learned counsel appearing for the respondent would admit that the order indicates that the proceedings were indeed ex parte and no notice was issued to the petitioner. In that light, I deem it appropriate to remit the matter back to the hands of the assessing officer to the stage and of issuance of notice under section 143(2) by reading down 143(2) to directing the petitioner appearance directing the petitioner to file his reply to the said notice, and the assessing officer regulating his procedure to take the issue to its logical conclusion. In the light of the proceeding being ex parte, all further actions taken pursuant to the ex parte assessment order would all be unsustainable in the light of it being in violation of principles of natural justice. In the light of the aforesaid reasons, the following order: the assessment order dated 1/2/2024 stands quashed. All subsequent actions taken on the strength of the assessment order would also are also to be obliterated. The matter is remitted back to the hands of the assessing officer, the respondent.
Respondent number 2, my lord.
Respondent number 2 to restart the process from the stage of issuance of notice under 143(2) with liberty to the.
They have to file reply to 143.
Stage of 143(2), which would mean that the petitioners will now have to submit their reply to the notice under 143(2). The assessment officer, second respondent, shall regulate its procedure and take the issue to its logical conclusion, ordered accordingly. How much time to reply?
We'll reply within a month.
The petitioner, adondu second clause haki, the SSC shall now submit his reply to the notice under 143(2) within 4 weeks from the 4 weeks from the date of receipt of the copy of this order. Yes.
There's only one clarification. We've attached the bank account. There are default for multiple assessment years. Only for this assessment year, my lords, the lordships are setting aside the assessment order and the demand goes for this. But for the other years where the demand has been crystallized, we've
proceedings are taken up for that.
They've not challenged the orders.
No, whatever. Quay the challenge the assessment to the assessment year in the subject petition.
Please, only for this. Please.
Stands obliterated. Quay the challenge to the subject assessment year. Yes.
I appear for the petition. Notice is awaited for R5. Date may be fixed.
24.
18.
18 ಇದ್ದೀವಾ? Yes. Lokesh. Refund.
ಅಲ್ಲ ಮಿಸ್ಟೇಕ್ ಅಲ್ಲಿ ಅವರು ಬೇರೆಯವರ ಅಕೌಂಟಿಗೆ ಕಟ್ಟಿದೀವಿ ಅಂತ ಅಲಿಗೇಷನ್. ಆ ಬೇರೆಯವರ ಪರ್ಸನ್ ಗೆ ನೋಟಿಸ್ ಆಗಿದೆ. This honorable court.
ಅದನ್ನ refund ಕೇಳಿ.
Await R5. That post immediately after service of notice upon the fifth respondent. Yes.
Date may be
19.
ಅವಾಗ ಯಾವಾಗ ಬರುತ್ತೆ ಗೊತ್ತಿಲ್ಲ. Post immediately ಅಂತ ಕೇಳಿ. Yes.
ಅಲ್ಲ ಅಕಸ್ಮಾತ್ ಬಂದ್ರೆ ವಾಪಸ್ ನಾನು at least I can take a first steps ವಾಪಸ್ ಬಂದ್ರೆ.
ವಾಪಸ್ ಬಂದಿರೋದು ಗೊತ್ತಿಲ್ಲ. ಇನ್ನು ಸರ್ವಿಸ್ registry to put up the matter immediately after, receipt of notice upon R5.
19.
This is also a case of refund.
Refund,
Refund,
same
my lords.
order,
Order may be passed.
Rectification with, my lords, in this, we'll pass rectification order within 2 weeks, my lords.
within 2 weeks, 6 weeks ಬೇಡವಾ?
Undertaking may be noted.
Yes, yes, my lords. In
ಅಲ್ಲ,
fact, they-
same, within
same.
2 weeks. ಅಲ್ಲಿ ಏನ್ ಹೇಳಿ, ಅಲ್ಲಿ 6 weeks ಹೇಳಿದ್ರೆ 2 weeks ಮಾಡಿ ಅಷ್ಟೇ.
Much obliged.
Yes. Next.
20.
My lords, demand under section 74 of GST, my lords, on.
Covered.
Please, my lords, it's covered. It's covered, my lords.
Same, where is that?
My lords.
The order of coordinate bench, my lords, wherein mineral area is been quoted. Same has been decided in the favor of assessees, my lords. And it is only that, my lords, the interest and the penalty is been waived off subsequent to, I mean, before July 2024, my lords.
For reconsideration, same thing ಮಾಡಿ.
Remanded.
Petition, prior haki, same order. Yes. Next.
21.
Lordship, in this matter, I'm seeking to set aside the order of rejection of a fresh GST registration application by the petitioner for the ground of non-filing of
Non-filing,
GST
you have suffered a penalty in the earlier registration,
No,
GST
Lord.
registration. Now to get over that, a new registration comes up.
No, Your Lordship, what has happened
That is
here
not being registered.
No, Your Lordship, what has happened here is there's an auto generation of GST during that VAT to.
Correct. What
GST
happened to the previous GST?
Your Lordship, we have, it's involuntarily generated, my lord. It's not applied and generated. That's what I'm.
No, it's all right, but
We,
now you are wanting the next application, next
we
generation to
have
be.
filed for a fresh GST registration, which has been rejected on the ground of non-filing of GST registration associated with
That
previous.
is what I'm asking you.
Yes, Your Lordship.
If, what happened to the earlier GST registration?
Lordship, we were never intimated of the situation. In the sense, we have received the emails, but there was a provisional ID generated automatically, my lord. When we were during the VAT regime, we were a VAT registration
GST
holder.
violation, penalty, all is imposed on the earlier GST
Yes,
registration.
Your Lordship.
To get over that, a new registration is now sought, it is rejected.
Lordship, that is not the issue. What I am trying to submit to this honorable court is that there was an auto generation of a previously cancelled GST registration, which was not voluntary in nature. I have not applied and it has been generated. It has been involuntarily.
How is that GST violation and penalty in the earlier auto-generated GST?
Lordship, we have not filed any returns for the auto-generated GST because immediately after the auto-generation, we have cancelled.
Take notice. Union of India.
Lordship, section 139 and rule 24 covers this aspect.
Correct. 129 and 29.
139 of the CGST Act and 24, rule 24
Rule
covers this
24,
aspect.
correct.
It says all the existing VAT registration holders would be automatically issued with GST.
That is when the regime changed from VAT to GST.
Yes, yes, Your
Correct.
Lordship, yes.
All these now what they are indicating, they are the penalties under the VAT regime.
They are not indicating for the VAT regime. They are indicating for the provisional ID issued during the VAT regime. I can point your lordship to the provisional ID issued as well, Your
Well,
Lordship.
issue notice.
Please.
Let them come up with the reply. One and three. Counsel Shri Jeevan Neralgi. 2 learned HCGP. Copy idea Jeevan? Illala. Petitioner to serve set of papers upon the aforesaid counsel forthwith. List on 11/9.
Great job.
Yes.
22.
Your Lordship, I appeared for the petitioner for serial number 22 and 23.
Refund rejected.
Yes,
Refund
Your
is
Lordship.
rejected. Yes.
Yes, yes.
Arvind.
Your Lordship, this is a recurring issue. Your Lordship has already issued notice, which is at para 177 in the lead petition, Your Lordship. Page 177.
Page 177. Para 177 was shocked.
Page
Yes.
one.
Page 1.
My apologies.
Yes, yes, not a problem. Like 200 para petition ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ. Yes, tag this petition along with both this 22 and 23. Tag with page 177. Same orders.
I'll take notice. for
Objection
2 and 3.
ಹಾಕಿದ್ದೀರಾ ಅದರಲ್ಲಿ?
ಇಲ್ಲ ಇಲ್ಲ ಫಸ್ಟ್
ಹಳೆದ್ರಲ್ಲಿ.
ಹಳೆದ್ರಲ್ಲಿ ಇಲ್ಲ.
In that matters, Mr. Unikrishnan has taken notice.
All right. Learned Counsel Arvind Chavan accepts notice for respondent, first respondent,
2 and 3.
2 and 3. One year
One
Pujappa is
Mr.
Union of
Pujappa
India.
has
is it?
filed
So 2 and 3 in both these cases, registry print the name of Arvind Chavan is appearing for the respondent. 11-9.
Please.
List on 11-9.
Lordships,
Along with,
one small correction. In serial number 23, respondent numbers 2, 3 and 4, your lordships.
all right, 2, 3 and 4 Arvind Chavan. Yes. Tag the petition along with that and list on 11-9. Next.
24.
Deeply.
Lords, 24 and 24.1.
This rectification.
Please, my lords. I'll briefly state the facts, my lords.
Yes.
SSC originally filed, before that, SSC has 2 PANs. This pertains to a PAN which has been surrendered. 14, 15, 15, 16. They filed returns for 4 years. The PAN, the fourth alphabet is F.
Objection is not required?
Objections has been filed, my lord.
Already
And
filed?
we are only praying
very
for
good.
remand.
Yes.
What has happened is, we filed the return, then realized that they are making disallowances of the entire sum as income. We obtained a new PAN and thereafter we've been filing. When this return got processed, we realized that we have claimed exemption under 1023C. We already had 12A. 12A was also mentioned, but the CPC processed it. We asked the assessing officer to rectify, saying that we already have 12A. We have inadvertently made 2 claims. For 5 or 6 years, it was not processed. Then finally, they rejected my 154, saying that there is no mistake in the return. I have filed a rectification return also. Annexure C, page 58. May I take page 44, my lords? In page 44 is my original return. And bottom of the page,
Yes.
left hand bottom corner, B and C.
Yes.
B is in respect of 1023C and C is whether registered under 12A. I have said yes for both. Now, since my PAN was F, I filed as revised return page 58. Again, bottom B and C. B I said no, C I said yes. So basically, they should have processed my return. Till date, it is not processed. My only humble submission is both the year's returns can be processed. In addition to that, my lords may take to page 86.
Return is not even processed?
My revised return is not processed. Originally, they taxed my entire receipts.
Yes, sir.
My lord, why it is not processed is the claim of the assessee while filing the returns was under section 1023C, for which the threshold limit is 1 crore. The income reported was 7 crores. So the mistake is not from the department, it is from the assessee.
ಅದಕ್ಕೆ rectification ಹಾಕಿರೋದು.
And why 154 order is rejected is 154 is any mistake apparent from record. So there is no mistake from us.
From your side, it's no mistake. It is his mistake. He accepts it.
Not an indulgence.
Now do it. That's all. Yes. The petitioner is before this court calling in question an order dated is on 4-5 order 3/3/2025 passed under section 154 of the Income Tax Act, declining to process the revised return filed by the petitioner on the score that there is no error apparent by the revenue to process the application, to process the return of income of the petitioner, revised return of income of the petitioner. The
Original return.
Original, correct. Original return of the income of the petitioner. Heard so and so. The petitioner claims to be, petitioner is said to be a charitable organization registered under section 12A of the Act. The petitioner files its return of income for assessment year 2013-14 up to 2016-17. On 27/9/2015, the petitioner filed its return of income claiming deduction of the receipts and as obtaining under section 10 within bracket 23C and Roman 3 so and so synopsis 2. The return of income was processed under section 143(1) of the Act, and an intimation in terms of a communication was issued to the assessee. The petitioner, realizing that the gross receipts offered were erroneous and further claim was made under an erroneous head, filed a rectification return on 27/1/2017. The rectification was not processed, but but the petitioner receives a recovery notice or a demand recovery notice, as the case would be. The respondents not adhering to the request of the petitioner for processing the revised return of income that is filed after rectification of the mistake committed by the assessee himself is before this court, as the matter has been precipitated further by the revenue against the petitioner while rejecting the application filed while rejecting the claim of the petitioner under section 154 of the Act. The learned counsel would reiterate the submission, reiterate the contentions or the averments made in the petition. The learned counsel appearing for the respondent revenue would submit that the order is passed under section 154 owing to the fact that there is no error apparent committed by the revenue. Therefore, no fault can be found with the order so passed, rejecting the claim of the petitioner to process the revised return so filed after such rectification. The learned counsel for the petitioner submits that the revised return was preferred owing to a mistake committed by the petitioners and not the mistake committed by the revenue. In that light, since the assessment is not processed at all, the revised return is not processed at all by the respondents, and it has been rejected under section 154 while finding no fault with the order of rejection, as there is no error apparent committed by the respondents. The error apparent is committed by the assessee. In that light, I deem it appropriate to direct the respondent to process/assess the revised return so filed by the petitioner for the assessment year
14, 15 and 15, 16.
14, 15 and 15, 16 in accordance with law and in accordance with law by passing necessary orders on the revised return so filed. All consequential actions would depend upon the revised assessment/processing of revised return that is now directed to be done by the respondent. If in the light of the aforesaid reasons, the order so and so stands quashed, the matter stands remitted back to the hands of the which respondent?
R1.
Respondent
1.
The first respondent to process the revised return filed by the petitioner, which was rectified/revised return filed by the petitioner without time limit and badala. Yes. So,
My lord, next year's A and A1 required to be quashed.
so it's A and A1 quashed.
Obliged.
Both. Adral A and A1 connected. Yes, next.
25. Lords, I appear in this matter. Lords, may I seek about 2 or 3 weeks' time? Apparently,
Correct. There is a detailed interim order granted.
interim order is there, and then now to our counter, they have filed an additional affidavit, which we have not yet, we just got a copy. So, additional statement they have just served.
Objections hakidra already.
Yes. Then we filed a rejoinder. Now they have filed an additional statement. We have just got a
You want an additional rejoinder now?
No. No. Just 2 or 3 weeks' time, if we may.
Just 2 or 3 weeks. All right.
I don't
List the
know.
matter on 11/9 at the request of the learned senior counsel. 2 or 3 weeks, 21st kagolla.
No, I'm out of station till about 26. At least 2 weeks' time. Let me see what their additional statement is. 4th, very well. No difference.
4/9. List on
Order
4/9. Heard the learned senior counsel Jaina Kothari appearing for the petitioner and learned HCGP. At the request of the learned senior counsel, list the matter on 4th in preliminary hearing. Interim order subsisting would continue till the next date of hearing.
Great.
4th, no adjournment. We'll close it. Yes.
26.
26 to 29, my lords, 4 matters. The refund applications have been rejected, my lords.
What application?
Refund applications.
Refund application. Yes. ಹಾಕಿದ್ದೀರಾ ಮಾಡ್ಬೇಕು ನೋಟಿಸೇ ಮಾಡಿಲ್ಲ
They want to go back. Then suddenly they told, let it hear on merit. Then today also morning they want to remand back. In this confusion, I didn't receive the parallel remand.
ಪರವಾಗಿಲ್ಲ.
I'll file
ಕಾಪಿ ಇದೆಯಾ? ನೋಟಿಸ್
I'll file statement.
ನೋಟಿಸ್
Because notice has been
ಆಗಿದೆ.
issued. They were supposed to file their objections by the
Learned
end of June.
HCGP seeks 2 weeks time to file statement of objections. List the matter on 11/9, objections if any by then. Yes, next. Up to 29, huh?
29 my lords. Yes.
30.
This matter is arising out of GST Act. Disputed period of assessment is 2021. The input tax rebate claimed in the return has been rejected. Similar matters are pending before this honorable court.
Input tax credit, yes. Yes, objections?
A batch of writ petitions are pending.
Gottu. La, connected numbers have the kodi.
Annexure.
Page 37.
Yes, my lord.
Tag this petition along with input tax credit. Then we'll close all that on that circulars thing.
In all the matters, 16.2 is not challenged, my lord.
In this you have challenged?
In this matter, I have not challenged 16.2, my lord.
In the page 37, that is a challenge, and 16.2 is challenge?
That is only in respect of validity of the assessment order, wherein rejection of input claim made by the assessee.
We'll take it on, we'll tag this along with this. Tag the petition along with page 37. ಅಲ್ಲ ಇದರಲ್ಲಿ ಅದೇ ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ. 16(2)C ಇಲ್ಲ, ಚಾಲೆಂಜ್ ಇಲ್ಲ ಅಂದ್ರೆ we'll take it. List on 21st, 28th. We'll close it on 28th. Same order.
ಅಲ್ಲ ಸುಮಾರು ಮ್ಯಾಟರ್ ಇದೆ, ಎಲ್ಲ 28th ಆಗಲ್ಲ.
ಎಲ್ಲರ ಜೊತೆ ಅಲ್ಲ, ಇದು ಒಂದ್ರ ಜೊತೆ ಮಾತ್ರ. Page 37 ಮಾತ್ರ. ಅದೆಲ್ಲ 16(2)C ಚಾಲೆಂಜ್ ಇದ್ರೆ we'll take it differently.
Please.
ಇದೊಂದು ಇದ್ರ ಜೊತೆಗೆ ಮಾತ್ರ. One matter. Ah, 10%, yes, that is there.
In that,
10%, yes.
In the particular.
Yesterday, what is the demand now?
It is around 3 lakh.
10%, yes, subject. Tag the petition along with so and so. Same order, subject to the condition of 10% payment. Within the next 4 weeks.
Please.
List the matter on 11/9. Along with that, yes.
31.
We are seeking a remand in this case. Assessment year 11-12. The assessment was reopened in 2018, my lords. The assessee was a non-resident Indian. Orders are passed ex-parte. He returned in the year 2020. I just explained. The original assessment order is not available on the portal. I have raised grievances. They don't have records. So now I've changed my PAN from Bombay to Bangalore. So all I'm praying is send me back to the stage of 148. I will file my return and annexures A1 to B1 may be quashed. I'll file my return and.
In fact, Malaj, I'll have to admit to the fact, Malaj, even we don't have, because it's all assessment year 11-12 from Bombay. It has been within Bombay, Malaj. It was.
Then how do you assess then?
Malaj,
how do you pass orders? On what basis have you passed?
Malaj, this orders were passed manually, Malaj, and by oversight, Malaj, it was not uploaded on income tax business.
So ilve illa.
Malaj, now we don't have the base orders, Malaj, for passing.
No, if I send it back for 148 assessment now, On what basis do you assess it?
I will file my return. My
Well, now they.
Now it has to start altogether afresh.
Yes, yes.
It's now they themselves are admitting, my lords, they'll participate in the proceedings.
Right,
my lords.
sorry.
There is a demand, my lord. I have to fight.
We don't have the base order, my lords, of assessment order.
Right,
We're not
now
able-
he has to file everything. You have to build up the file now. Yes.
It's to the stage of 148, my lords, at annexure A, my lords, let them file.
Page
file-
140, page ಏನು?
Page 40, 40.
They have to file returns in response to this notice.
They may activate the portal. We will file a return.
Yes. The petitioner is before this court seeking the following prayer. Heard so and so. The petitioner was assessed to tax for the assessment year 2011 and 12 at the time when he was not residing in the country.
Yes, my lord.
In the country. Up to 2019, the assessment that was made, particularly of the year 2011 and 12, the petitioner was not aware. On 30/3/2018, it transpires that the second respondent issues a notice under section 148 of the Act for assessment year 11 and 12, directing the petitioner to furnish a return in response to the income chargeable to tax that had allegedly escaped assessment for the assessment year 2011-12. The intimation letters were issued to the petitioner. The petitioner, as observed here and above, was not in the country. He comes back in the year 2019.
Yes, my lord.
2019 becomes aware of the fact that notices were hanging on his head and submits that. Where is the representation?
My lords, we have challenged the penalty order after we came back, but we did not have
The
original
petitioner, after coming back and coming to know of the penalty orders that were hanging on his head, raised a challenge to the said orders.
Para 11, my lords.
Before whom?
CIT appeals, NFAC.
Para?
11, my lords. Sorry, the synopsis, row 11.
Oh, synopsis. Became aware and so and filed an appeal against the penalty order before the Commissioner of Income Tax Appeals. The petitioner is said to be participating in the said proceedings in terms of what is averred in the petition. The grievance applications are also submitted by the petitioner, and seek information with regard to the assessment order. What was the 11 and 12 proceeding?
Assessment.
They seek information about the assessment proceeding of the year 2011 and 12. The learned counsel appearing for the respondent would admit the fact that the records pertaining to assessment year 2011 and 12 were inadvertently not uploaded.
Not able to dispute.
The learned counsel appearing for the petitioner submits that the portal does not contain the document of assessment of the year 2011 and 12. The learned counsel for the respondent would admit the fact that they are not able to trace the records of the assessment year 2011 and 12 concerning the present petitioner - the SSC. The learned counsel for the petitioner at this juncture would submit that he would file a return of income now for the said assessment year, and the proceedings be taken to its logical conclusion in accordance with law thereafter, which is not objected to by the respondent. In that light, I deem it appropriate to direct the petitioner to file his return of income in terms of the notice issued under section 148 of the Act for the assessment year 2011 and 12, and the assessing officer to take the issue to its logical conclusion in accordance with law thereafter. In the light of the aforesaid reasons, the orders that are impugned in the subject petition would necessarily have to be obliterated. In that light, the following order:
A1 to A5.
A1 to
A5 and B1.
A1 to A5 and D1
B1.
quashed. The petitioner is now at liberty to file his return of income under section 148, for which the assessing of
Number one, respondent number one, my lords.
respond number one. Yeah, respond number one.
My lords, because 148 notice was issued, my lords, by Bombay in the by Bombay office, my lords. Subsequently, my lords, the case
Oh, the
has been
first respondent, is it?
Yes, please.
The first respondent is directed to take the take the proceedings from the stage of issuance of notice under section 148(1) to its logical conclusion. Quash madanda. End date.
They have to open the portal because I need to file.
Yes, sir.
Lords, by virtue of your lordship, sir.
By enabling the opening of the portal for the purpose of filing of the return of income within
3 weeks, 4 weeks.
Within 4 weeks from the date of receipt of the copy of this order.
Applies.
32.
My lord, I am appearing for the petitioner, my lord. In this case, my lord, the petitioner challenged the so-cause notice, order in original and order in appeal, my lord. Because the so-cause notice was issued, my lord, considering the income tax return of the earlier year 2015-16 and for 16-17 and June 17 up to June 17, my lord.
Page 150.
Yes, my lord. So-cause notice.
Page 150.
Page 150.
Yes, my lord. 150, my lord. By considering this Kannada Chinmaya Seva Trust, my lord, the matter may be remitted back at the stage of so-cause notice, my lord.
One nimsha, wait.
Matter is covered by that judgment. But
Why do you
only
always appear on VC?
No, my lord, I had some
Fractured his leg.
injured his leg.
fracture, my lord.
All right. Take care.
Yes, order in original is of 2023 and he has even appealed before the Commissioner Appeals and that has been rejected on the ground of delay.
We will pass the same order at 150. Matte in time.
Please.
Yes.
It has to go back to the stage of show cause notice. That is annexure A.
Page, if you come to page 2 and 3, now relegated before the authority file their pleadings reasonable time zones. ನೋಡಿದ್ದೀರಾ ಚಿನ್ಮಯ ನಿಮ್ದೇ ಅಲ್ವಾ?
ಚಿನ್ಮಯ.
Yes.
Same order. ಅದು ಒಂದು ಲಾಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಲ್ಲಿ
ಏನಿದೆ? ಏನಿಲ್ವಾ?
ಅಲ್ಲಲ್ಲ annexure A is show cause notice. It has to go back to the post show cause notice 11/10/2021 is the show cause notice. Reply to the show cause notice ಅಂತ ಅದೊಂದು ಆಡ್ ಮಾಡಬೇಕಷ್ಟೇ.
Right. The petitioner, the SSC, is before this court seeking the following prayer. The learned counsel for the petitioner submits that the SSC is similarly placed like that of those SSCs which formed the order passed by the coordinate bench on 3rd July 2024 in writ petition 11154 of 2023 and connected cases. The coordinate bench, considering the entire spectrum of the issue, passed the following order. Page 212 in the 214. The learned counsel appearing for the petitioner submits that the matter be disposed in the same terms that the coordinate bench had disposed, directing a reply to be submitted to the show cause notice and the proceedings to be taken thereafter. The learned counsel for the respondent would not dispute the position in law, except the fact that the matter should be remitted to the stage of the submission of reply to the show cause notice by the petitioners. In that light, the petition stands disposed on the same terms as afore quoted, except with the rider that the petitioner shall now submit their reply to the show cause notice. Impugned.
Annexure A.
Show cause notice annexure A, and the respondent shall take the matter to its logical conclusion on the reply so submitted thereon. Ordered according.
B and C.
Annexure B and C required to be quashed, my lord. Annexure B and C required to be quashed, my lord.
B and C quash ಮಾಡಿ same order ಮಾಡಿ. Yes, sir.
33.
Much obliged.
Reply 3 weeks, 4 weeks.
4 weeks, my lord.
The reply 4 weeks. Submit a reply within 4 weeks from the date of receipt of the copy of this order.
Much obliged, my lord.
33.
As the audit concluded beyond the statutory period of limitation and also impugned proceedings also beyond the period of limitation, my lords.
GST.
This is they came from first appellate authority, my lord. Tribunal not informed, my lord. 10% direction for
10% order.
Similar matter already granted interim order.
Correct, sir. 10% kudi. Correct, madam. 10%. Then use a code pudi. Tag same order. Yes. Next. That interim order, final order alla. Adike tag 10%. Yes.
34.
My lord, in this case, there are two separate orders passed by respondent 2 and respondent 3. Respondent 2 is assistant commissioner, respondent 3 is deputy commissioner. The deputy commissioner, after passing the order, I went before the deputy commissioner and sought rectification. He rectified the order and demand is nil. Then I went before the AC, same subject matter. That is the difference between 2A and 3B. Then I went before the respondent 2, assistant commissioner, and sought rectification because there is already order.
That is rejected.
Rejected. And I went before the first appellate authority. First appellate authority says the rejection order, I mean the original order is 23, time barred. Rejection order, they should have taken that rejection order as the date of for the purpose of limitation.
The order of the deputy commissioner. Yes. No, endorsement of the assistant commissioner rejecting the claim. We'll do it. You take notice. Notice ಆಗಿದೆಯಾ? ಆಗಿದೆಯಾ? ಇಲ್ಲ. First time. The learned HCGP is directed to AGA, sorry. AGA is directed to accept notice for the respondent. 34 ಅಲ್ಲ madam ಇದು? Respondent. We'll send it back next week. List on 21st.
Yes.
Yes, in plenary hearing.
Please.
Why do you commit such simple, silly mistakes? Assistant Commissioner. Yes.
35 dispose 36.
36, I'm appearing. 36. My vehicle has been detained illegally without following due process of section 129. I have not issued any notice under section 6.
Immediately release vehicle. Prayer. Learned AGA is
2 months is over. It is detained in Beluru police station.
One ನಿಮಿಷ sir. Learned AGA is directed to accept notice for the respondents. 21st ನೋಡ್ಕೊಂಬರ್ತೀರಾ? Release ಮಾಡಿದ್ದೀರಾ?
They are not issued I have not received. Station ನಲ್ಲಿ ನಿಂತಿದೆ ಗಾಡಿ. I am supposed to receive a notice section 129 MOI 7 along with the forum number 6 MOI 6 to enable me to file an objections. This I have not
7/7/25 notice issue ಮಾಡಿದಾರಲ್ಲ?
I have not received your
order ಇದು. Notice, where is the notice?
Section 129(3), my lord, they have to issue proposed penalty or if there is any discrepancy.
One moment. Hereby directed to show cause within 7 days receipt of this notice as to why goods in so and so. This is issued on 7/7/25. 21/6. 21 served on Mohan Kumar. 21/6/2025.
I have not received it. My lord, under section 129, section 129, notice of penalty on section 129 has to be complied by issuing a form number 7 in the form number 7 along with MOV 6, giving me an opportunity to file my objections. If the objections is not, if the objections
ಅಂದ್ರೆ
is
proposed penalty ಮೇಲೆ ಕೊಡ್ಬೇಕು notice. Without confiscation, correct, yes.
There is an element of fraud in it, and they have not responded to the show cause notice. So notice issue was issued under section 130, and since there was no response, the order of confiscation is passed. This order of confiscation is.
Where is the records to show that notice was issued on 21/6, except the noting there? ಹಾ ಅಲ್ಲ ಇರ್ಲಿ, ಇದೆಯಲ್ಲ ಅದು ಕಾಪಿ ಇದೆಯಾ? ರಿಸೀವ್ ಆಗಿಲ್ಲ.
I have not received any such notices. My vehicle has been detained illegally for more than 2 months is over. It is still in Belur police station without complaints of section 129. 130, my lord, it comes only after the confiscation. I have issued a e-tax. I paid the tax. There is he has admitted there is a e-way bill. A driver can produce only that particular two issues.
Driver cannot produce anything more than e-way bill.
E-way bill, which should have been verified, cross-verified then and there itself. And without giving an opportunity, if any other order passed under section 130 or section 11, it does not valid in the.
But by interim order, there is no interim order sought. Let him come up. I'll take it on 21st. Kodi. Allah, having received the notice.
Interim application for the release of the vehicle in this matter.
Interim order release madalla, wait. This is penalty order. Receipt of the penalty order. 129. Straight away 130 if there fraud.
If there is no fraud alleged.
No, 130.
We have penalty and 129 Monday, 129 1 week, and release of vehicle under 129 1 week.
Well,
if there is an element of fraud, we go to procedural after 130.
List the matter on 21st in plenary hearing.
One small submission. Fraud anta enadru madadadrunu kuda I must be notified.
Correct, don't worry.
Adanna madilla anta.
Those are two rudimentary.
Yes. Yes. Interim order.
Interim order vehicle release ಮಾಡಕ್ಕಾಗತ್ತಾ?
2 months is over.
21st will dispose it itself. Yes. 2 months and 1 week ಆಗುತ್ತೆ ಅಷ್ಟೇ. Yes.
That opportunity has not been provided to me.
ಈಗ ಕೊಡ್ತೀನಿ ಬೇಕಾರೆ.
ಈ ಕೊಟ್ರೆ ಅದು
25% amount deposit ಮಾಡಿ bank guarantee ಕೊಡಿ. Yes. Which vehicle is this?
This vehicle.
Lorry.
Lorry. 6 ಟೈರ್ ಹೋಯ್ತು.
6 ಟೈರ್ ಹೋಯ್ತಾ?
ಟೈರ್ ಹೋಯ್ತು ಯಾಕಂದ್ರೆ it is standing with loaded.
ಈಗೇನು ಬಿಸ್ಲಿಲ್ಲ ಬಿಡಿ, ಮಳೆ ಬರ್ತಾ ಇದೆ. Yes. 21st ತಗೊಳ್ಳ 25% or 75% bank guarantee, whatever division bench has directed. Where is that order?
25% on the penalty. I have not received what is the proposed penalty at all. If the proposed penalty should have been notified to me, I should have gone directly before approaching to this honorable court.
So let me see. 21st will pass the order. We'll dispose the petition on 21st. Could a division bench order. If you want interim order now, we'll pass an order of this kind. ಇದು ಬ್ಯಾಂಕ್ ಗ್ಯಾರಂಟಿ ಕೊಟ್ಟಿದೆ. ತೊಗೊಳ್ಳಿ, you've seen this?
Interim order ಆಗ್ಲಿ.
ಇದೇ ಆರ್ಡರ್ ಕೊಡೋದಾ?
Interim order ಕೊಡ್ಲಿ.
The petitioner is before.
The vehicles for
the petitioner is before this court seeking the following. Complying with this.
Challenge ಮಾಡಕ್ ಬರಲ್ಲ ಯಾಕಂದ್ರೆ there is some other issues is there.
Sorry. The learned counsel appearing for the petitioner submits that there are plethora of issues to be decided in the case at hand, as no notice under section 129 is issued by the respondent for before determination of penalty. The notice so issued is only dispatched from the office of the respondent but has never reached the doors of the petitioner. The learned counsel for the learned AGA would dispute the position. The learned counsel for the petitioner would insist upon grant of an interim order the learned AGA submits, interim orders in such cases is to be granted as directed by the division bench. The division bench in identical circumstance where the learned single judge had granted an interim order of deposit of 25% of penalty along with indemnity bond for the remaining amount, has modified the order sustaining the 25% that was directed to be deposited, but directing furnishing of bank guarantee for the remaining amount. In that light, the division bench has held as follows, full lakpade. The learned counsel for the petitioner submits that an interim order be granted in terms of the judgment of the division bench. In that light, there shall be an interim order of stay subject to the condition that the petitioner would deposit 25% of the penalty demanded and the 75% of the penalty by way of bank guarantee in terms of the judgment of the division bench. If this stands complied, the vehicle shall be released forthwith in favor of the petitioner.
Penalty ಎಷ್ಟು ಅಂತ ನಂಗೆ ಗೊತ್ತಿಲ್ಲ. That has to be noticed to me.
ಎಷ್ಟಿದೆ penalty ಅದರಲ್ಲಿ?
The order should ನಾನು ಕೊಟ್ಟಿದ್ರೆ
the penalty amount ಆಮೇಲೆ will
order copy 11 ಅಷ್ಟೇ. 11 ಇದೆ.
ಅವ್ರಿಗೆ ಈ ಮೆಮೊ ಕೊಡ್ಲಿಲ್ವಾ ಅವ್ರಿಗೆ?
ಈಗ ಕೊಟ್ಟಿದ್ದಾರೆ. $4,67,670. 21st.
ನೀವು ವೆಹಿಕಲ್ ಓಡಿಸ್ತಾ ಇರಿ, ನಾವು ಸ್ವಲ್ಪ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಜಾಸ್ತಿ ಕೊಡೋಣ.
ಅಲ್ಲ
28th or 4th November, 4th September. Yes. ನೋಟಿಸ್ ಕೊಟ್ಟಿಲ್ವಲ್ಲ? ನ್ಯಾಚುರಲ್ ಜಸ್ಟಿಸ್. ಅದು ಕೊಡಿ, ಅದಲ್ಲ. If I am satisfied that he has received the notice, we will send him to appeal.
I'll reply to that here.
Appeal ಯಾವ್ದ್ರಲ್ಲಿ? 107 ಎಲ್ಲದಕ್ಕೂ. Yes.
ಒಂದು ನಿಮಿಷ, I'll reply to that. ಒಂದೊಂದು ಸೆಕೆಂಡ್ ಅಲ್ಲಿ ಬಿಡ್ತೀನಿ.
ನೋಡಿ ಒಂದು ಸೆಕೆಂಡ್ ಇದು ಕೊಡಿ ಮೇಡಮ್. With this condition, I can dispose it, reserving liberty to go before the appellate authority.
ಲಾಸ್ಟ್ ಇಲ್ಲದ ನೋಟಿಸ್ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಇದೆ ಅಷ್ಟೇನೆ
ಇದೆ.
ಸೆಕ್ಷನ್ 130 ನಲ್ಲಿ ಮಾಡ್ಬೇಕಾದ್ರೆ ಐ ಪ್ರೊಡ್ಯೂಸ್ ಒನ್ citations passed by the High Court of Karnataka, Punjab and Haryana, Shiva Enterprises and Enterprises. Otherwise, they cannot pass orders unless they comply section 129.
ಅದು ಕಾಪಿ ಅವರು ಕೊಡಿ ವಾಪಸ್. ಆಯ್ತು, we'll see next week. Yes.
Much of it.
10% of the amount in appeal is deposited through
appeal.
Please, my lord.
10%.
We deposited, but my lord, the appeal is dismissed on the ground that my lord, it has been deposited through electronic transfer, not by way of cash. There is a circular, my lord. The Honorable Gujarat High Court, my lord, has quashed such a condition.
ಎಲ್ಲರೂ ಪ್ರೋಗ್ರೆಸ್ ಆದ್ರೆ ನೀವು ರಿಗ್ರೆಸ್ ಆಗ್ತಾ ಇದೆ. Obviously, sir.
In the decision of the Honorable Gujarat, my lord, there is circular. That circular is extracted, my lord, at page 559, my lord.
At Supreme Court confirm madadra?
It is confirmed, my lord.
We'll close it. The petitioner is before this court calling in question an order dated 11/12/2023 by which the appeal filed by the petitioner comes to be rejected on the score that the pre-deposit amount that is necessary for entertaining an appeal is filed by electronic mode, is paid by electronic mode and not by way of cash. Not otherwise, cash ante, not otherwise. The learned counsel appearing for the petitioner submits that an identical issue comes up before the Gujarat High Court in Yasho Industries Limited versus Union of India. The Gujarat High Court goes in detail and sets aside the order of the appellate authority which declines to accept the pre-deposit pre-deposit in terms of section 1076B of the CGST Act, which was made by electronic credit ledger. The Gujarat High Court holds that the electronic transfer must be considered to be valid, and the impugned order passed by the appellate authority therein was rendered unsustainable. The Gujarat High Court has held as follows. Para mark madidini, quote ಮಾಡಿ. The subject order, the said order of the Gujarat High Court was tossed by the Union of India before the Apex Court, only to be rejected by affirming the findings rendered by the Division Bench of the High Court of Gujarat by the following order. Illi, adu mark madidini. In the light of the issue standing covered by the judgment rendered by the High Court of Gujarat as affirmed by the Apex Court, the issue in this subject case need not detain this court for long or delve any further deep into the matter. The petition deserves to succeed with the obliteration of the order of the appellate authority and the restoration of the appeal filed by the petitioner on the file of the appellate authority. For the aforesaid reasons, the following order. The order stands so and so stands quashed. The appeal filed by the petitioner, clause 2 only, the prayer clause 2 only, stands restored. The appellate authority shall answer the appeal on its merit and take the issue to its logical conclusion, ordered accordingly.
38.
Your Lordship, I appear for the petitioner in 38. I'm seeking interest on delayed refund for the refund claims that I had filed between the period October 2007 to June 2017, Your Lordship. Your Lordship, these refund claims were sanctioned to me mostly between 2012 and 2020. Your Lordship.
Seek instructions.
First time bartha.
First time bartha. Notice.
Learned Counsel Arvind Chavan accepts notice for the
2 and 3.
Respondents 2 and 3. Seeks time to secure instructions and make his submissions. List on 11-9.
Lordships under orders category, Your Lordships. Under orders category, because issue is covered, Your Lordships. That's the only.
Preliminary hearing, yes.
Deeply obliged.
Next.
39.
This is a writ petition challenging the adjudication order, wherein the appeal is dismissed in limine for a delay.
For what?
For
reason?
Delay. Condemnation of delay.
Beyond the condemnable delay.
It's filed after 45 days of condemnable period of 120 days. Over and above the condemnable period of 120 days.
What's the reason?
Your Honor, it's an ex-parte order. They hadn't come across the order, the knowledge of.
You don't know the order at all.
They hadn't come across the knowledge of the order, and subsequently after a delay, they filed the appeal.
With the penalty of
Again, appeal ilva?
Appeal
order ilva?
Appeal order dismiss madidare without condoning the delay.
Yes, madam. With cost. But he was not aware of the order. Original order you are not aware of?
Originally I was not aware of. Subsequently I came to knowledge of it and I filed an appeal. It was with
What is justification of being unaware of that order?
Your Honors, the email ID was provided by a consultant. So I have. Your Honors, I accept.
Too weak a ground.
No, I agree.
the cost of 150,000 have you obviously.
Your Honors.
Yes.
Subsequently, the directors have changed of this.
That's all right. That doesn't mean cost should not be imposed.
I agree to the cost, Your Honors, but it should be a minimalist.
Minimal. 50,000 is minimal.
No, Your Honors. This is a very small company.
Small company. But 25,000. Yes. The petitioner is before this court seeking the following prayer. The petitioner is said to be filing its, the petitioner company is said to be filing its GST returns as GST returns regularly. It transpires that the petitioner receives a notice for tax period to July 2017 to March 2018 on 13/9/2022. And the show cause notice to the subsequent show cause notice thereon on 25/9/2023. The learned counsel for the petitioner submits that he was not aware of the notices being issued or notice being issued on account of his email not functioning. The learned counsel for the respondent now submits that it would be hosted on the portal and there is no necessity to there can be no contention that the email was not email of the petitioner was not functioning, since the portal would display the notices so issued. The learned counsel, however, submits that he filed an appeal after coming to know of the order that was passed against him before the appellate authority or tribunal.
Appellate authority.
Before
First
the
appellate
appellate authority under section 107 of the GST Act. The said appeal comes to be rejected on the ground that it is filed with a delay of 45 days beyond the 90-day period that was condonable. That was
20 days.
90 days that was condonable of a threshold of 30 days. In all, the limitation that is ascribed in section 107 is that the appeal should be filed within 120 days to the maximum. Since the appeal was filed with an application seeking condonation of delay of 45 days and that delay was not condonable at the hands of the appellate authority, in the light of the statute, the appeal comes to be rejected. Therefore, the petitioner is before this court. The perusal at the averments made in the petition would indicate that the petitioner had some justification for the delay being accrued of 30 days beyond 45 days beyond 120 days, as the petitioner was not aware of the proceedings. In that light, I deem it appropriate to direct the respondent to consider the appeal on its merit that is now filed without reference to delay, subject to the payment of costs of rupees 25,000. Yarige?
Karnataka State
ನಿಮಗೆ
Legal
ಕೊಡ್ಬೇಕಾ?
Service.
Legal Service Authority. ಜಾಸ್ತಿ ಇದೆ. To the Karnataka State Legal Service Authority within, the cost shall be deposited within 4 weeks from the date of receipt of the copy of this order. In the light of the aforesaid, in the light of what is aforesaid, the following order. Writ petition is allowed in part. The order dated so and so, annexure E stands quashed. The matter is remitted back to the hands of the appellate authority to answer the appeal on its merit without insistence on the delay in the light of the observations made in the course of the order and production of the receipt of payment of costs costs as directed. Yes. Next.
He has pleaded that show cause notice has not received, opportunity not provided. It may be relegated to the matter at the stage of show cause notice to submit.
Squashing the adjudication order.
He has not challenged that only. He's only challenged the appellate authority's order.
Let it go before the appellate authority.
He has not challenged the original order against which appeal was filed, correct?
Yes, Your Honor.
ಮತ್ತೆ ಬರ್ತಾರೆ ಇಲ್ಲೇ ವಾಪಸ್ ಅಲ್ಲಿಗೆ ಹೋಗ್ಬೇಕು. You will still hold on to the ground that show cause notice was not received.
No, Your Honor, we will not hold on to that. Once
Then that
appeal is decided,
then that ground is false.
Your Honor.
Ground is false.
No, Your Honor, the appeal might be decided. It's a small issue. Let it be decided in the appeal stage itself. That's what.
Cannot be done like that. ಯಾಕಂದ್ರೆ show cause notice receive ಮಾಡಿಲ್ಲ ಅಂತ opportunity is.
ಹೌದು, that is what he is ರಿಸೀವ್ ಮಾಡಿಲ್ಲ ಅದಕ್ಕೆ ಡಿಲೇ ಅಂತ ಹೇಳಿರೋದು.
ಅಲ್ಲ, ರಿಸೀವ್ ಮಾಡಿದ್ದಕ್ಕಲ್ಲ.
ತಗೊಳ್ಳಿ so and so appellate authority, the order of the appellate, the contention of the petition, last para, the contention of the petitioner is that he has not received the show cause notice. Reply ಕೊಟ್ಟಿಲ್ವಾ?
Reply ಕೊಟ್ಟಿಲ್ಲ.
Received the show cause notice and therefore no reply was submitted. All these were projected before the appellate authority. In the light of the submission that the petitioner did not receive the show cause notice even and had not submitted his reply, the matter though would be remitted to the appellate authority as per the challenge. The matter should now go back to the stage at which the show cause notice, reply to the show cause notice has to be submitted by the petitioner, as the contention for the delay is that he was not aware of the notice at all. Equally reply. The petitioner therefore now shall submit a reply to the show cause notice within 4 weeks from the date of receipt of the copy of this order, and the authority shall pass necessary orders upon consideration of the reply to the show cause notice. All other remedies to the petitioner subsequent to the said order shall remain open. 4 weeks. Reply ಕೊಡಕ್ಕೆ ನಿಮಗೂ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡ್ಬೇಕಾ?
In that contention, the annexure B also goes, Your
Goes. So in that light, the order of the appellate authority and the other order challenge ಮಾಡಿದಾರಲ್ಲ,
Adjudication
stand
order,
quashed.
annexure B. Much of.
Matter is remitted back to the adjudicating officer. Oh, 3 months and third. Oh, yes, it's the other way around. Yes. All at all. Yes. No, that I'll correct. ಅದು ಗೊತ್ತಾಯ್ತು. ಆಯ್ತು.
40.
Appearing for the petitioner, my lord.
ಇದು ಟೀಥಿಂಗ್ ಪ್ರಾಬ್ಲಮ್ಸ್ ಆಗ್ತಾ ಇರುತ್ತೆ ನಮಗೆ, ತೊಂದರೆ ಇಲ್ಲ. ಎಸ್. Extended period of limitation is different. Well, yes. Yes, madam.
Madam, this is with respect to the proceedings initiated under Rule 86A. This is already covered by judgment. It can be kindly looked at annexure D.
Correct. Page 80. No, it's.
Page number 26, my lord.
Oh, this Government Canine Enterprise. Yes, madam. Huh? Take notice. We'll take it next week. Yes. Learned counsel for the petitioner submits that the issue in the list stands completely answered in writ appeal. So page 26. So the learned HCGP accepts notice for the respondents. Copy the madam. So list on 21st. 21st agboda.
Next week.
21st. We'll close it. Yes.
Much obliged.
Yes.
41.
This is an education order challenged wherein 17.5 ineligible ITC. This issue was decided by the Supreme Court in
Input
Safari
tax
retreat.
credit.
Yes. Safari retreat. This adjudication order, Your Honor, doesn't speak of Safari retreat. It is not considered the Supreme Court order. Hence, in that case, it should be sent back to the adjudication authority to consider the Supreme Court order.
We'll do it next week.
Your Honor,
in this case, that leading Safari case, but they have not appeared, they have not filed appeal.
Your Honor, that I agree. It's an ex-parte order. It's an ex-parte order. I agree. But they have to consider the Supreme Court order. And
Safari retreats will send it back on that.
Send it back.
Your Honor, it's already been sent.
Oh, cost. Your case all cost ivattu.
Illa, Your Honor. This, Your Honor, they have to consider that order.
That I'll see Justice Shyam Prasad.
But cost ಹಾಕಲೇಬೇಕು ಸ್ವಾಮಿ. ಅವರು ಅಪಿಯರ್ ಆಗಿಲ್ಲ, ಗೊತ್ತಿದ್ರು ಅಪಿಯರ್ ಆಗಿಲ್ಲ, ಸರ್ವ್ ಮಾಡಿದ್ರು ಅಪಿಯರ್ ಆಗಿಲ್ಲ.
ಇಲ್ಲಿ ಹಾಕಿದಾರ ಕಾಸ್ಟ್?
ಇಲ್ಲಿ ಅಲ್ಲಿ ಹಾಕಿಲ್ಲ.
ಅಲ್ಲಿ ಹಾಕಿಲ್ಲ.
ಇದರಲ್ಲಿ ಹಾಕಿಲ್ಲ.
ಅದ್ರಲ್ಲಿ ಹಾಕಿಲ್ಲ. That's an ex-parte order.
The petition, close it.
Yes.
The petitioner is before this court seeking the following prayer. An order comes to be passed by the Assistant Commissioner of Commercial Tax on 29/10/2024. The learned counsel for the petitioner submits that the said order is drawing up proceedings ex parte, as the petitioner was not put to notice. The learned counsel for the respondent would dispute the position that the petitioner, though notice was issued, did not choose to appear before the authority. In identical circumstances, the apex court in the case of Safari retreats has held that ex parte orders are unsustainable in law and has remitted the matter back to the hands of the concerned authority to hear the matter afresh after hearing the petitioners therein. Following the said judgment of the apex court in Safari retreats, a coordinate bench of this court in identical circumstance has held as follows. Page marked portion. in the light of the issue being similar, in the light of the undisputed fact that the issue being similar, the petition deserves to succeed, albeit in part, as is observed by the coordinate bench in the judgment quoted supra. The petitioner is also entitled to the same relief, same order ಮತ್ತೆ ರಿಪೀಟ್ ಮಾಡಿ. ಅಲ್ಲಿ ನೀವೇ ಅಪಿಯರ್ ಆಗಿದ್ದೀರಾ, ಕಾಸ್ಟ್ ಯಾಕೆ ಹಾಕ್ಸ್ಲಿಲ್ಲ?
ಇಲ್ಲ, ಇದು ಇದರಲ್ಲಿ within time ಅಲ್ಲಿ they have approached. They have submitted, despite submission they are not considered ಅಂತ they approach. Facts are different.
ಈಗ ವಿದಿನ್ ಟೈಮ್
Ex-parte order.
ಎಕ್ಸ್ಪರ್ಟ್ ಆರ್ಡರ್
Yes, my lord. That's
ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಕ್ಕೆ ಎಲ್ಲಿದೆ?
ಇದರಲ್ಲಿ ಕಾಸ್ಟ್
ನೋಟಿಸ್ ಬಂದಿತ್ತಾ?
ನೋಟಿಸ್ ಬಂದಿತ್ತು. ದೇ ಸೇ ದಟ್ ಇಟ್ ಇಸ್ ಅದೇ ಕನ್ಸಲ್ಟೆಂಟ್, ಎಲ್ಲರೂ ಕನ್ಸಲ್ಟೆಂಟ್ ಇಮೇಲ್ ಐಡಿ ಕೊಡ್ತಾರೆ.
On 25,000.
Your Honor, no, Your Honor. In this case, no, Your Honor. He's an individual. He's an individual who wants.
Yes, yes.
Much obliged, Your Honor.
They will take light before the authority. They will not appear only. ಕಷ್ಟ ಆಗುತ್ತೆ.
ಅಲ್ಲಿ ಬರ್ಕೊಳ್ಳಿ. In last ಅಲ್ಲಿ ಒಂದು ರೈಡರ್. In the event the petitioner would not avail the opportunity as granted by this court in terms of the aforesaid order, the authority is at liberty to pass necessary orders in accordance with law, and the petitioner will be precluded from projecting that the order is passed in violation of principles of natural justice.
Date may be fixed, Your Honor. Date and time may be fixed.
In the light of the parties represented, I deem it appropriate to direct the petitioner to ಏನು ಅಪಿಯರ್ ಆಗಕ್ಕ? ಶೋಕಾಸ್ ನೋಟಿಸ್ appearance or reply? The petitioner shall appear before the adjudicating officer.
Yes, Your Honor.
Which respondent?
Respondent number 1. It's a single respondent.
One respondent. All right. The petitioner shall appear before the respondent on 1st September. At what time? Generally 2:30. At 2:30. Yes. No separate notice be issued to the petitioner for such appearance. In the event he would not appear, the benefit of the order, the petitioner would lose the benefit of the order. That's that. Yes.
42 disposed, 43.
My lord, I appear for the petitioner in this case. Petitioner is running a bar and restaurant.
Bar and restaurant?
In Hassan.
Hassan. Sorry.
The assessment order. Based on the scrutiny assessment. Relating to assessment year.
Mike togole.
Relating to assessment year. 22-23. Was passed. Based on the high liabilities in the finance.
First time ಬರ್ತಾ ಇರೋದು.
ಇಲ್ಲ ಸರ್, it is coming.
Notice ಆಗಿದೆಯಾ?
ಆಗಿದೆ.
Oh yes.
Second year. High liabilities compared to the low income. See here, he has shown unsecured loans of around 3 crore something. And since this one is, he has proper ledger accounts and the entries in the bank statements are also available. But in the assessment order,
42 adjourned.
271 proceedings,
Penalty proceedings have commenced.
any scrutiny assessment was made and under section 69A, the penalty was imposed as unexplained money. Considered.
Correct. Unexplained money. Yes. ಎಷ್ಟು 3 ಕೋಟಿನಾ?
Unsecured loan and.
How much? 3 crores.
3 crores. Now, after adding all the interest and penalties, now it is 7 crore 89 lakh something. He has to pay.
Let them come up with the objections.
But the problem is, since he has all the documents relating to the unsecured loans, ledger account and all, I have shown in the petition itself, everything.
We'll see. Let him come. Objections haki. List the matter on 11-9. Objections, if any, by the respondent, by then.
Yes. The bank account is.
No, by interim order, I will not.
Look, they have to pay 22 lakhs for 17-18. Let them be directed to pay 22 lakh for 17-18 because we have attached, there are at least 24 bank accounts. There is absolute no money in the bank. and all the cash which is received in the hotel and restaurant and bar, it goes directly to case BCL. So we don't get any
11th
money
we'll
at
see,
all.
file your objections, we'll consider
Let the
intermodal.
22 lakh, but let them pay the
Adavut
immediately.
nod. Yes. Next.
44.
Assessing for assessing the assessment year 16-17, Lordship. This is the transaction done by the assessee for the assessment year 16-17 of nearly 60 lakhs.
Right.
It is advanced towards purchase of.
Ex-parte order, my lords. They have not participated 148 AD order. Let them file reply to 148 AB, my lords.
Send it back. The petitioner is before this court calling in question, seeking the following prayer. The heard sounds. Proceedings were taken up against the petitioner by issuance of a notice under section 148A on 7/3/2023. Proceedings have since then gone on.
What is 148 AB, my lords?
148 AB, yes, 148 AB.
25/2/2023, my lords.
25 to?
2023, page 179, my lords.
25, what did I say?
473, my lords.
For 25/2/2023. The proceedings have gone on since then and has resulted in the notice of demand now issued on 13/2/2025, all of which are challenged in the subject petition. The learned counsel appearing for the petitioner would project a solitary contention for the present that the proceedings that have culminated in the impugned order are all ex parte. The petitioner was not heard in the matter prior to the passage of the order. A perusal at the record would clearly indicate that the petitioner has not been heard in the matter, therefore the proceedings are undoubtedly ex parte. Since the proceedings which has culminated into the impugned orders are ex parte from the stage of notice under section 148AB, the proceedings are a nullity. In that light, I deem it appropriate to obliterate the orders impugned, remit the matter back to the hands of, back to the stage from which the proceedings began on 25/2/2023, i.e. issuance of a notice under section 148AB of the Act. The petitioner shall now submit a reply to the said notice so issued on 25/2/2023 and the reply be considered and procedure be regulated thereafter by the respondent authorities. In the light of the proceedings being ex parte and the admitted position being that the proceedings are ex parte, the orders impugned would necessarily stand obliterated and the matter obliterated. In that light, for the aforesaid reasons, the following order allowed in part, the so and so order stands quashed. The matter is the petitioner shall now submit a reply to the notice so issued on 25/2/2023 under section 148AB of the Act. All further action would remain as a consequence of the consideration of the reply submitted by the petitioner, and the petitioner would be left open with all the remedies thereon, ordered accordingly.
45.
The show cause notice and the consequent order of rejecting my application seeking revocation of GST registration, my lord, is challenged. My lord, the show cause notice is at page number 51. My lord, in the garb of issuing me a show cause notice, they have passed an order directing me to pay. My lord, this is in violation of page 51.
This is show cause notice for rejection of application for revocation.
Yes, ma'am.
You are hereby furnished reply in 7 days. If you fail to furnish,
Pay ಮಾಡಿ.
Ellide?
Lordship may kindly come. This has a reference to your application dated so and so regarding revocation of cancellation of registration. Application has been examined and the same is liable to be rejected for the following reasons. Any supporting documents, others so and so. As per adjudication order passed under section 73 of GST law, you are having a huge liability in the electronic liability ledger. The details of pending dues are sent to your
After
register.
clearance of all the dues, your application will be considered.
Lord,
post decisional hearing.
ಅಲ್ಲ ಅಲ್ಲ ಆಗಿದೆ
ಅಲ್ಲ
last date ಅಲ್ಲ.
ನಿಮ್ಗಲ್ಲ ಇಲ್ಲಿ ಹೇಳ್ತಿರೋದು ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾ
ಇಲ್ಲ,
ಇರೋದು.
ಇಲ್ಲ, ಆಗಿದೆ ಸ್ವಾಮಿ.
ಆಗಿದೆಯಾ?
ಇಲ್ಲೇ ಸಮಯ
ಜೀವನ್ ನೇರಳಿಗೆ ಅಂತಿದೆ.
AGA to take notice ಆಗ್ಬೇಕಾಗಿತ್ತು.
Who accepts notice now? Learned AGA accepts notice for respondents 2 to 5. Jeevan Neralgi will be only for 1.
I am appearing.
Counsel Jeevan Neralgi for the first respondent. Yes. What's the why show cause payment ಮಾಡಿದ್ರೆ ಮಾತ್ರ consider ಮಾಡ್ತಾರೆ. It's a post decisional hearing. You have decided and issued the show cause notice. Correct, no problem. You are expected to act in accordance with law. Ashte. Why did you say, oh, after all clearance of your dues, your application will be considered? That everything was fine except that sentence.
They passed an order asking me to pay. Where is the question of me replying?
Okay.
That is why I have challenged, my lord. Because I have said it is no show cause notice at all in the eyes of law.
No, that is all right. 16/1/2025. Ashte.
ಅಲ್ಲ, reply
No,
ಅಲ್ಲ,
we will-
payment ಮಾಡಿ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ.
We will obliterate these words. After clearance of all dues, your application will be considered.
ಅಲ್ಲ, we are ready to pay.
He may have justification if you decide it and then send, no use. Wordings matter, sir. Everything depends on words. No, see, the wordings may be different, Allah. The word reflects the mind of the authority. So if he is now decided that your penalty will be paid and then only it will be done, that is the mind of the authority. If he has made up his mind, where is the question of notice? No problem at all. Why did you add these words? These words is not sustainable. When you issue a show cause notice, you are not supposed to decide the issue and send a notice. No, they do that without anything.
I'll do that. I'll file.
That will do. Will permit.
Except the last word, the last line, my lord, pay.
No, we will delete those words. Treat this as notice to be replied. This is notice only, but a pre-decisional hearing. The petitioner. No, Hemkumar sir, it's not that. Now, no problem about it. When you issue a notice, you should know that you should not decide it and issue a notice. That's all. You have decided here after clearance of all dues. Now he may have a justification that he has no dues at all. That's why I said words are the most important thing. No problem. All that is fine. I will only say this to be treated as a pre-decisional thing. No decision is taken, and decision will be taken on the reply that he is going to submit. Yes. The petitioner is before this court seeking the following prayer. The petitioner is said to be a partnership firm constituted in the year 2005 and was assessed to value added tax on the GST, on the new regime, i.e. the GST coming into force. The petitioner has been diligently making payments is the averment. The issue that has driven the petitioner to this court is issuance of a show cause notice seeking to show cause as to why the application of the GST registration of the petitioner should not be revoked or cancelled on certain premise. The show cause notice reads as follows, page 51. The learned counsel for the petitioner submits that he would have submitted a reply to the show cause notice but for the reason that it depicts a post-decisional hearing and a show cause notice post-decisional hearing, as the notice indicates that his application would be considered only after clearance of all the dues. The learned counsel has justification that he has no dues to be cleared at all. In the light of the observation in the show cause notice, nothing is left to be replied, is the submission of the learned counsel for the petitioner. Learned AGA would, however, dispute the position in contending that it may be choice of words, it may be wrong choice of words in the order, but nonetheless, it is only a show cause notice. The said submission of the learned AGA would have been acceptable, but for the clear and unequivocal intention of the authority, i.e. the assistant commissioner, in issuing the notice, and the words, quote unquote, after clearance of all dues, your application will be considered. This undoubtedly amounts to a post-decisional hearing, as the decision is taken that his application would be considered only after clearance of dues. The petitioner submits that he has justification that he has no dues at all. In that light, the show cause notice, insofar as it determines the answer and seeks a question, is unsustainable in law. In that light, the show cause notice shall now be read without those words, after the clearance of all dues, your application will be considered. Those words in the order would stand obliterated. The petitioner shall now submit his reply to the show cause notice dated 12/3/2024, and the assistant commissioner, the adjudicating authority, shall consider the reply in accordance with law and pass necessary orders thereon. Hearing idea? 16/1? 16/1/2025. Show cause notice dated 16/1/2025. Correct. Ade helid nan. 16/1/2025. In the light of the aforesaid reasons, the order dated 27/2/2025 stands would be rendered unsustainable. For the aforesaid reasons, the following order. The order dated 27/2/2025 stands quashed. The indication in the notice dated 16/1/2025, the words in the notice dated 16/1/2025, quote unquote, after clearance of all dues, your application will be considered, stands obliterated. The petitioner shall submit his reply to the said notice within 4 weeks from the date of receipt of the copy of this order. The respondent authority shall take the proceedings to its logical conclusion. Ordered according.
I have to first file a reply.
4 weeks
then
ಅಂತ
they can
ಹೇಳಿದೀನಿ.
fix the date for hearing.
To submit a reply.
On 3 weeks ಆದ್ಮೇಲೆ ಕೊಡ್ತೀನಿ. At least 2 to 3 weeks.
The learned the learned AGA submits that the petitioners would appear before the authority along with the reply. The proceedings, the personal hearing also would be accorded. In that light, the petitioner along with the reply shall appear before the respondent assistant commissioner on 10th September. On 10th September at 2:30 p.m.
Great.
46.
Please, my lords. Here for the petitioner for fresh matter, my lords, coming up for the first time. Challenge is to
10%.
already paid, my lords.
Adru stay at 10%. Yes, 10% order.
Deposited, my lord. Proof is at page number 290.
Same order. Page 290.
290.
290, same order. Yes.
B group matters 47.
Hearing on behalf of the petitioner, Your Honor, the arguing counsel is held up due to some personal exigencies.
Where is Ajay? He's in Bombay.
No, my lords, no, I am not I am not the arguing counsel.
You're not the arguing counsel.
My lords, I don't do tax so much. I am not familiar with the law.
Oh.
Another person,
You
they
only-
engage their office for the
You
purpose of
only
filing.
impose tax. Yes.
Not on my lords, anybody except my clients.
Yes. Ella B group 2018. Sir.
My lords, I'll make sure that next
issue
date,
pertains to 2013.
next date,
Oh,
if it-
justification.
2013 issue.
Order sheet runs more than the petition now.
my lords, I'll get ready another. My lords, if he doesn't
Please
come,
do that. Yes.
one date ಕೊಟ್ಟು just.
21.
Sorry, sir.
ಅವತ್ತಿಲ್ಲ ಅಂತ 28.
My lords, is it possible in the week of first week of September?
4th is.
Sorry,
fourth ಎಷ್ಟು? ಅದು ಜಾಸ್ತಿ ಆಗಿದೆ. 11th. It's a list on 11th as a last chance. Yes.
48.
Revenue set. File the miscellaneous, against the miscellaneous order, may not file this repetition. Tribunal order is Manoj at page number 75.
What's the matter, madam?
Manoj, the That's tribunal, basically the ITAT had disposed of, there were cross appeals of the revenue and the SSE. ITAT had disposed of the appeals. In the revenue's appeal, their contention is some of the grounds were not considered and adjudicated. So they filed a miscellaneous petition for which there is a provision under the Act. The ITAT has dismissed the miscellaneous petition on the ground that it is barred by time because it was filed 6 months from the end of the month in which the order was passed. Their contention is it should be from the date of, you have to consider it from the date of communication of the order. That's the only dispute before my
That's the
lords
only
today.
thing here?
Please.
Why are you here?
Manoj,
He's the
petitioner. It's department's petition. The department's
What?
Manoj, we had filed 260
Yes, sir.
appeal, Manoj, that got Manoj, that Manoj,
Hmm.
the division bench gave us liberty, Manoj, to challenge the order before.
Where's the order of the division bench?
Manoj, it's page 94.
90?
94.
Date of the order? 21st January 2019.
Please,
Ada.
please.
What was the time fixed?
Manoj, liberty was granted, Manoj, to the appellant to pursue such.
You
remedy as-
withdrew the
Please.
appeal. Withdrawn, liberty is granted to pursue such remedies as available in law.
Manoj, against that order, Manoj.
Now, even if you take it as 21st January 2000,
That is not the impugned order, Manoj.
Then?
The order, Manoj, is at page number 90. This is the order which we have challenged.
no, that's all right.
Miscellaneous petition order is at page number 90. This is the order, Manoj. which we have
Undisputed
challenged.
limitation miscellaneous application from the end of the month. Yes, sir.
Manoj, the original order was passed on 31st.
Correct, 31/10/2016.
Manoj, it was received only on 2nd January 2017, Manoj.
You mean to say 2.5 months later?
Manoj, your lordships will get.
Where do you get that?
Manoj, your lordships will get at page number 75, Manoj. This is the order, tribunal original order, Manoj. Lordships will get the seal on right hand side, Manoj. This is the date when we received the order, Manoj. The
No.
2nd January 2017.
254(2), what does it say?
Manoj, from the date of passing order is it says, Manoj.
6 months from the end of, order was passed.
Please. Manoj, but it was received, Manoj, on the defective date is, Manoj. Have to be date of communication. I concede without recording my concession, lordships may allow the.
If the order is kept with them without communicating, then where do they know to
Proof of
file an appeal?
communication. Our seal ಹಾಕೊಂಡಿದ್ದಾರೆ.
ಅಲ್ಲ,
But
correct.
ideally they have to provide a communication certificate from the ITAT. Manoj, this is the date, Manoj, we've received.
No, we should read saying that it is, if the order is passed, it should be communicated. From that day, 6 months.
Please, Manoj, this was communicated. This was the date it was
I
communicated to
thought
us.
we'll pass an order in your favor. We'll revive the appeal proceedings.
The MP proceedings.
Yeah, miscellaneous proceedings. Correct.
Please.
All right.
And all contentions kept open.
Those, yes. I'm not deciding any contention. The petitioner revenue is before this court, aggrieved by an order dated 13/9. ಇದು ಇಷ್ಟಕ್ಕೆ ಪೆಂಡಿಂಗ್ ಇದೆಯಾ 7 ವರ್ಷದಿಂದ 2019 6 years ಇಂದ ಅವಾಗಲೇ ಹೇಳಿ ಮುಗಿಸ್ಬೇಕು ತಾನೆ. The petitioner being aggrieved by an order dated 13/9/2017 passed in income tax, passed in miscellaneous petition.
123,
ಇದು
123 and 124, Bangalore 2017. Manoj,
ಪೇಜ್ ಏನದು ಒಂದು ನಿಮಿಷ.
Page number 90, Manoj.
90.
90.
In so and so, ಇದು ಚೇತನ್ ನೋಡ್ಕೊಳ್ಳಿ. Is before this court. The issue is from what date the period of 6 months should be reckoned for preferring a miscellaneous petition before the tribunal on an appeal. The concerned court by the following order has rejected the case of the revenue on the score that the appeal is miscellaneous petition is preferred beyond 6 months and is contrary and beyond 6 months and is not entertainable in terms of section 254(2) of the act. The learned counsel Dilip M appearing for the revenue would submit that the order, though was passed on 31/10/2016, was communicated to the parties only on 14.
On 2nd January 2017, my lords.
Where do you get that?
My lords, page 75.
2nd January
17.
2017, as could be gathered from the seal affixed on the appeal. Therefore, it can be safely considered that the communication of the order so passed on 31/10/2016 has happened only on 2nd January 2017. If the revenue or the person against whom the order is passed has to prefer a miscellaneous petition within 6 months, it cannot be without knowing what the order is passed. It can ostensibly be only from the date on which the communication, the date on which the order is communicated. Admittedly, the order in the case at hand is communicated on 2nd January 2017. Therefore,
I don't know. It is their contention.
Their contention. I have not said you have accepted. Therefore, the order is communicated only on 2nd January 2017. The period of 6 months would kick in only from the date on which the order is communicated, as without knowing the order, no person can prefer a miscellaneous petition or an appeal, as the case would be. In the case at hand, it is the revenue preferring the miscellaneous petition within 6 months from the date of communication of the order, but not 6 months from the passage of the order. The passage of the order is on 31/10/2016, the communication of which was made on 2nd January 2017. Therefore, the appeal, the miscellaneous petition was preferred was well within time. In that light, in the light of the aforesaid reason, the order of the tribunal rejecting the miscellaneous petition so and so impugned in the subject petition is rendered unsustainable. The unsustainability of which would lead to its obliteration. The so and so allowed, quashed. The matter is remitted back to the appellate tribunal to consider the miscellaneous petition on its merit, and pass necessary orders in accordance with law thereon. All contentions of both the parties shall remain open. Yes.
Publish.
49.
May I please, Your Lordship? The challenge in this writ petition, my lord, is to the
Continue in the afternoon. Madhyanam. Afternoon, I'll take the second list first and then come back to
Would
this.
your lord,
One request.
would your lordships then kindly take it next week? I can appear physically also.
All right.
My lord,
If anybody wanting adjournment, just call.
my lord, serial number 50, my lords.
Wait.
Page-wise.
Page-wise, I'll call. Wait.
Page-wise adjournment. Page 8, 49 to 51.
My lord, serial number 51.
1 minute. VC, please wait. Yes. 2019.
Date may be fixed, my lord. We are ready, my lord. Date.
Yes, Ravira. 28 September. August ಇರಲ್ವಾ ನೀವು?
No, it's a small issue, my lord. Small issue.
Small issue. Small adjournment. ಅದು small ಅಲ್ಲ, ಅದು large adjournment. Yes. List on 29th, 28th.
That's 29th.
29th. Tax day. ಪ್ರಿಪೇರ್ ಆಗಕ್ಕೆ 15 days ಇದೆ ಇವತ್ತಿಂದ. ಆಯ್ತು 4th. 49. ಯಾವ್ದು 49 also same.
My lords, 49.
Surnaran sir. 49 will take it
49
on
next week, my lord. It is a very short matter.
then 21st. Yes.
Page 9,
Great.
52 to 57. Page 10, 58 to 64. Page 11, 65 to 72.
Ah,
My lord, 6.
all right.
My lord, 69, I am for the petitioner, my lords.
Ah.
My only request is if it can be kept on 21st, there's such significant refunds which are stuck, my lords.
Madam, wait. Learned at the request of the council, EI Sanmati, list the matter on 4th. 69 and 71 both. Eradu refund, huh? All right, yes. Next.
Page 12, 73 to 79. Page 13, 80. Page 14, 81.
Second list, take it at 2:30.
Cause list 2, my lord.
Ah.
Serial number 17, my lord. I appearing for
Adu
respondent.
Karthibidi, madam.
List number 2. Page 1, 1 to 3.
Serial number 1, if I could seek for Monday.
Being spoken to.
Being spoken to.
Why?
Well, that certain clarifications required, because there are factual mistakes in the order. Because they're both.
Ayt madhyana tagonti.
Page.
Afternoon, I have personal inconvenience.
Ayt, we'll take it on Tuesday.
Tuesday.
My lord, serial number 2, my lord.
1 minute. I'll finish one.
Yes, yes.
Yes. The learned counsel, at the request of the council appearing for the respondent Keshav M. Datar, list the matter on Tuesday.
Please.
In the same stage. Number 2.
Serial number 2, my lord. The trial court advocate has refused to take the notice, my lord.
Where's the affidavit? Affidavit and beda.
The
The
affidavit
petitioner shall serve the respondent by way of hand summons and file an acknowledgement of such service. Interim order, yeah?
No, my lord.
List the matter on 29th. Hand summons kodi alva. Yes.
Page 2,
Much of
4 and 5. Page 3.
By special order, madam. 3. I don't know. Let me see. Yes.
Page 3, 6 to 11. Page 4, 12 to 18.
Serial number 17, my lord.
First 13 on Nimsham. Respondent.
It was granted as finally.
Lokesh ಹೇಳಿದಿರಾ?
It was granted as finally.
ಆಯ್ತು ಸರಿ. Yes. List the matter on 9th September as a last chance. If no objections are filed, it shall be construed that there are no objections to the petition. Yes. Interim order subsisting will continue to the next date of hearing.
17, my lord.
17.
17. I appearing for respondent number 1 to senior is out of station for personal inconvenience. Petition also there. Petition also there.
Yes. List on interim order, yeah? List the matter after 2 weeks at the request of the council appearing for the respondent. Interim order subsisting will continue to the next date of hearing. Next.
Page 5, 19 and 20.
19 is something. Serial number 19. Sometime.
19 CRP.
Santosh Ram.
List on a list after 2 weeks at the request of the council appearing for the petitioner. Interim order subsisting will continue to the next date of hearing. Yes.
Serial number 20.
20.
20.
Interim order, madam.
20, my lord, it's a date matter, even last date out to my name of has taken date.
Then wait. Objection either wait. Yes. Afternoon.
Please.
Page 6, 21 to 24. Page 7, 25 and 26.
Madam Bantakshna.
Lords,
Yes, sir.
my lords, cause list number 1, serial number 50, my lords. I'm for the petitioner. I need adjournment, my lords. Senior is not available.
Not available.
I mean,
it's adjourned already. Yes.
My lord, serial number 51, my lord. Today some inconvenience.
interim order may be extended, my lords.
Yes. ಅದು ಯಾರು ನೋಡ್ಕೊಂಡು ಕೊಟ್ಬಿಡಿ ಮೇಡಮ್.
My lord, serial number 51
at 2:30. ಅದೇನು ಅಡ್ಜರ್ಮೆಂಟ್ ಕೇಳ್ತಿದ್ದಾರೆ?
Next week we'll argue the matter.
21st ಹಾಕಿ ಅದನ್ನ. Yes.
Please, my lord.
ಈ ರಿಕ್ವೈರಿಂಗ್ ಬಾಡಿಗೆ ಇಷ್ಟು ಕೋರಿಕೆ ಕೊಟ್ಟಿದೀವಿ ಅಂತ ಈಗ ಅವ್ರು ಡೈರೆಕ್ಟ್ ಪಾರ್ಟಿಗೂ ಜಮಾ ಮಾಡ್ಬೇಕಿಲ್ಲ ನಮ್ಗೂ ಜಮಾ ಮಾಡಿಸ್ಬೇಕು ಸರ್ ಅವರು ಗೌರ್ಮೆಂಟ್ ಇಂದ ತರಿಸ್ಕೊಡ್ಬೇಕು ಸರ್ ಕಾರ್ಪೊರೇಷನ್ ಅವರು
ದಟ್ ಈಸ್ ವಾಟ್ ಐ ವಾಂಟೆಡ್ ಕಾನ್ಫರೆನ್ಸ್ ಅಲ್ಲಿ ಮಾತಾಡಮ್ಮ ಅಂತಂದ್ರೆ ನೀವು ಮಾತಾಡೋದಕ್ಕೆ ಅಷ್ಟೇ ಎಜುಟೇಷನ್ ಮಾಡಿದ್ರೆ ನಾನು ಏನ್ ಹೇಳಿ
ಇಲ್ಲ ಸರ್ ನಾನು ಒಂದ್ಸರಿನೂ ಮಾತಾಡಿಲ್ಲ ಸರ್ ಬಟ್ ತಾವ್ ಹೇಳಿದಿರಂತ ಇನ್ನ ಹಾಕ್ತೀನಿ ಸರ್ ಅವರು ರೆಸ್ಪಾಂಡ್
ನೀವು ಅದನ್ನ ತಗೊಳ್ಳಿ ನಾನ್ ಬೇಕಾದ್ರೆ ಲೈನ್ ಆಗಿ ಇರ್ತೀನಿ ಇವಾಗ ಅವ್ರ ಲೈನ್ ಆದ ತಕ್ಷಣ ನನಗ್ ಕೊಡಿ ನಾನೇ ಮಾತಾಡ್ತೀನಿ ಈಗ ನಾನ್ ಲೈನ್ ಆಗಿ ಇರ್ತೀನಿ ತಗೊಳ್ಳಿ
ಸರ್ ಒಂದೇ ನಿಮಿಷ ಸರ್ ತಗೊಳ್ತೀನಿ ಸರ್
ಹಾ
ಲೈನ್ ಆಗಿ ಅದೇನಾಯ್ತು
My request, my lords, on Monday to furnish the list, my lords.
Monday?
I'll furnish the list of those matters. Connected matters list on
Kodi.
Monday.
But if I may make a mention, my lords, of list to serial number 34, but it has to be connected, my lords, with another matter.
List to?
Serial number 34. Lords, it has to be connected, my lords, with another matter. There is a direction, my lords, in that matter, but it's not being listed, my lords.
482.
482. Because, my lords,
Which is the other matter?
Lords, criminal petition 5694 of 25. Lords,
No,
accused number,
that won't come here.
That's because there is an order, my lord, to be connected here.
Who has passed that order?
My lords, the coordinate bench.
This is Sachin Magdumara.
No, my lords.
Then?
Remanchanan order, my lords. Justice Remanchanan.
Let's see. We'll see. Yes.
One submission, my lordship. Yesterday, I moved the memo, my lordship, pertaining to Lodha committee, my lordship. Your lordship has given-
Monday or Tuesday ಹಾಕಿಸ್ತೀನಿ.
Please, that given by the 23rd, the date is given for that.
23rd ಬೇಕಾ?
But there is a special bench for lordship.
That we'll see. 23rd ಇಲ್ಲ ಅಂದ್ರೆ 22nd ಬರುತ್ತೆ ಬೆಂಚ್ ಇದ್ರೆ. All right. Madam, 2:30 matter ತಗೊಳ್ಳಿ. Raviram Kumar sir.
My lord, the serial number 55 of list 1, my lord. I pray for a short accommodation. A week's time may be
No,
granted.
we'll grant. Don't worry about it. Yes. It will be either on the 21st or 28th. All Thursdays.
Number 2, my lord. Serial number 60. On Shata computer.
Intermodal ಇದೆಯಾ?
Intermodal.
CRP.
House.
ಆಯ್ತು. List on 29th at the request of the council appearing for the response. Till Jeevan Neralgi ಅವರು. This was specifically at 2:30, sir. 2015 matter. Ask him to come. Or ಬಂದ್ಬಿಡ್ಲಿ ಬಂದ ತಕ್ಷಣ ತಗೊಂಡು. Yes, Jeevan. Yes, sir.
List 181.
Yes.
The last occasion I gave a short note.
Yes.
On the number of notices served on us. I just request the court to kindly permit me to refer to
file.
that.
Get the file.
Yeah, I have another.
ಅಲ್ಲ ಇದು ಫೈಲಲ್ಲಿ ಇದೆ, ಫೈಲ್ ಬಂದಿಲ್ಲ. It is here.
Please. Petitioner is a statutory board, Industrial Areas Development Board. All the duties and functions are statutory functions. And the first notice that was served was for the period 1/10/2005 to 31/3/2010. Now that is not the subject matter of this writ petition. So far as that matter is concerned, the department held against us.
That is pending before the division bench.
Yes, we filed an appeal and the appeal was allowed. And the matter has been, the assessment order has been set aside in
The
its
appeal is
entirety.
allowed? Appeal is allowed?
Appeal is allowed before the tribunal.
Tribunal?
Before the tribunal, sorry, before the tribunal. And now the matter is pending before.
Division bench.
So what I wanted to emphasize is, all our contentions have been accepted, including the contention that what powers are exercised by the board are in the nature of sovereign powers and they are not amenable to tax. Now that is the subject matter of a division bench matter. So far as the next this thing, serial number 2, this relates to 2 periods.
2010, 11,
2010,
11,
11, for which there is a levy of 584 crores.
Yes.
Tax, and 2011-12, 660 crores.
Yes.
Is the levy. Totally 1,245.44 crores is the subject matter of those 2 periods.
Yes.
And the third notice is in the connected writ petition.
Yes.
For the period 2012-13 for a sum of 1,545.58 crores. And that is the subject matter of the. So far as the fourth one is concerned, I should bring it to the notice. What contentions we have raised here, the department has now realized that that is the correct position. So they corrected themselves for the subsequent period, that is April 2013 to September 2014. They have scaled down the service tax levied on us to 640 crores.
Scaled down?
Sorry, 6 crores. 6 crores, 6 crores. And
6 crores 40 lakhs. Yes.
And we have accepted that notice, and we are, it is being adjudicated. The no writ petition is.
So the issue is with regard to the prior period.
Yeah.
11 and 11, 12, 12, 13.
10, 11, 11, 12,
12, 13.
and 12, 13. That is the pending matter. For the subsequent period also, again, notice is given, which we have not questioned because
10 crore 42 lakhs.
Yes. That's all. Now, the basic questions that arise for consideration is, now the substantial amount of tax levied is, there are 6 heads, if I may say so with respect. There are 6 heads under which the levy is made. The first one is renting of immovable property. This is the major head under which we are taxed. Now, renting of immovable property, what they construe is, after acquisition and formation of the industrial area layout.
And allotment is considered to be rent.
Yes, plots are allotted. While allotting, we take the consideration, instead of calling it a sale, we call it lease cum sale.
Yes.
So that is over a period in order to ensure that they set up the industry and to ensure the organized.
That's condition of allotment.
Yes, that is a condition of allotment. Now that 10 years is the lease period, at the end of which a regular deed will be executed and sale deed will be executed. That they bring it under the head renting of immovable property, and that is the major head under which we are taxed. Now, then The second head is construction of commercial complex, which is again an industrial infrastructural development.
Yes.
Which is part of the project conceived as industrial area. And the third one is the business support services, which they say, they claim that we are giving these services and therefore we have to be taxed. And the fourth one, management, maintenance and repair services of the industrial area, which is incidental to the main project of developing the industrial area. And the last but not the least is works contract services, which are basically the services which are rendered for maintenance.
Yes.
So these are the heads under which we are taxed. Now the primary objection to these notices is that we are performing statutory functions, and performance of a statutory duty cannot be brought under the definition of a service to be taxed, taxable service. It cannot be brought under this. As a matter of fact, our contention has been accepted by the central board. They have themselves issued a circular. May I straight away draw the attention?
Yes, page. (1812-2006) page. Is annexure D.
Obliged, not annexure B.
D.
Yes.
Applicability of service tax collected by public authorities.
103.
That's the one?
Yes.
Yes.
10. May I be permitted to read that?
Yes. A number of sovereign public authorities.
A number of sovereign public authorities, namely agency constituted or set up by the government, perform certain functions and duties which are statutory in nature. These functions are performed in terms of the specific responsibility assigned to them under the law in force. For example, the regional reference standards laboratories undertake verification, approval and calibration of weighing and measuring instruments. The regional transport officer issues fitness certificate to the vehicles. The Directorate of Boilers inspects and issues certificate for boilers, or Explosive Department inspects and issues certificate for petroleum storage tank, LPG/CNG tank in terms of provisions of the relevant laws. Fee as prescribed is charged, and the same is ultimately deposited into the government treasury.
This important words are such activities purely in public interest, and it is undertaken as mandatory and statutory function. Therefore, no service tax is leviable on such activities.
I go down to that. That is the crux of the
circular
directive issued in this circular. Now, in the teeth of this circular,
yes,
and the nature of duties performed by us, the short question is whether we are liable for service tax at all. Now, my preliminary contention is, so far as the rental of properties is concerned, may I request the court to kindly permit me to show from the Constitution of India that
Constitution. Yes. Article.
Now, the Service Tax Act comes under
list. You're talking of list.
Yes, entry 97. So far as sale of land or land proper is the subject matter of list 2, kindly permit me to show 2 entries.
State list.
State list. List 2. Serial number 18. Land, that is to say, rights in or over land, land tenures including the relation of landlord-tenant, collection of rents, transfer and alienation of agriculture land, land improvement, and agriculture loans, colonization. So
Yes.
this is the subject matter of entry 18. Then come to 49. There is a specific entry on taxes on lands.
List 2.
Yeah, list 2.
Yes.
Taxes on lands and buildings is the specific subject under 49. So if there is a sale of land, it is taxable under this provision and not under the central list. And therefore, it is our very respectful submission that there cannot be a levy for sale of land in the name of service tax. And that is wholly without jurisdiction is the preliminary contention raised. Then the second contention raised is that the functions discharged by the board are in the nature of statutory duties and sovereign functions and for a public purpose. What is very important is it is for a public purpose. And this is not a commercial activity. There is no consideration for the functions that are performed by this board. What is collected by way of the consideration for lease cum sale is essentially the expenditure incurred for purposes of forming the industrial plot and
Acquisition, maintenance, and all
yes,
this.
yes, it is only for that purpose. Therefore, it is not a commercial activity and it is not a service as contemplated under the Service Tax Act. And therefore, being a sovereign function and for a public purpose, it is not taxable. Is the next contention that is advanced.
Yes.
Then I also would request the court to kindly permit me to show that the scheme of the act. I request the court
Which act?
IADB Act.
KADB Act.
Yeah. Yes. I would request the court to kindly permit me to show the nature of duties to be performed.
Yes.
Yeah.
ನೀವು ಓದಿ ಸರ್, ಅದಿಲ್ಲಿರಲ್ಲ, ಓದಿ.
Yes.
ಇದೆಯಾ? Yes. Yes, sir.
Kindly permit me to show from the statement of objects, the preamble to the
I am
act.
there.
Preamble.
Yes.
To the act. Yes. An act to make special provisions for securing the establishment of industrial areas in the state of Karnataka and generally to promote the establishment and orderly development of industries therein, and for that purpose to establish an industrial areas development board and for purposes connected with the matters aforesaid. Whereas it is expedient to make special provision for acquiring, for securing the establishment of industrial areas in the state of Karnataka and generally to promote the establishment and the orderly development of industries in such industrial areas, and for that purpose to establish an industrial areas development board and for purposes connected with the matters aforesaid, be it enacted by the Karnataka state legislature in the 7th, etc., etc. Now coming to the scheme of the act, I request the court to kindly permit me to show from section 3. The state government may by notification declare any area in the state to be an industrial area for the purposes of this act. Every such notification shall define the limits of the area to which it relates. Then section 4 deals with the alteration. I will not trouble the court.
Yes.
Then our constitution, etc. and
Section 13.
Yes, section 13.
Functions and powers of the board.
Yeah. Section 5, may I trouble the court with section 5?
Yes. Establishment.
Establishment. For the purposes of securing the establishment of industrial areas in the state and generally for promoting the rapid and orderly establishment and development of industries and for providing industrial infrastructural facilities and amenity in industrial areas in the state of Karnataka, there shall be established by the state government by notification a board by the name Karnataka Industrial Areas Development. The said board shall be a body corporate with perpetual succession, common seal, and may sue or be sued in the corporate name, and shall subject to the provisions of this act and the rules made thereunder, be competent to acquire, hold, and dispose of property, both movable and immovable, and to contract and do all things necessary for the purpose of this act. Section 6 is very important. I request the court.
Constitution.
Yes, Constitution. Kindly permit me to show it is essentially a government body. How does it?
No, there is no doubt about it.
Yes, all are officers of the government, ex officio directors of the.
The issue is whether they can impose service tax on the functions of the board.
So to show that what we are performing is essentially a governmental function. What the government ought to have performed in its power of eminent domain, we are authorized to do it in the name of the board.
For a specific purpose of development of industrial areas.
Development of industrial areas. Now, I'll not trouble the court with other this thing. Kindly come to section 13.
13.
Yes, 13. Functions of the board.
Yes.
The functions of the board shall be generally to promote and assist in the rapid and orderly establishment, growth and development of industries, and to provide industrial infrastructural facilities and amenity in industrial areas, and in particular and without prejudice to the generality of clause 1, 2, A, develop industrial areas declared by the state government and make them available for undertakings to establish themselves. B, establish, maintain, develop, and manage industrial estates within industrial areas. C, undertake such schemes or programs of works either jointly with other corporate bodies or institutions, or with the government or local statutory authorities, or on an agency basis, as it considers necessary or desirable for the furtherance of the purposes for which the board is established, and for all purposes connected therewith. And I would very respectfully submit, there is not a whisper in the entire notice. It's a very lengthy notice that we have done anything outside the statutory functions and duties assigned to us. And then powers of the board, section 14. And how, having acquired the land, the government hands over the lands to us. How is it to be handled is regulated by section 18.
19 is board's fund.
Board's fund.
How you receive, how do you spend?
Yes, yes.
Expenditure is at 23.
Yes. All property,
yes,
fund and other assets vesting in the board shall be held and applied by it, subject to the provisions and for the purposes of this act. So it is circumscribed.
Your funds are audited by the government.
Statutory audit. Statutory audit. And therefore, that is precise. And so far as the acquisition is concerned, kindly come to section 28.
28, yes.
28. So I'll not trouble the court that yes, essentially the government which
day in and day out will be 628, 1, 2, 3, 4. Yes. And 29, result of 28.
20, yes.
From out of the funds of the board itself.
Board, yes.
Yes.
Now I have placed the entire statute on record at Annexure C for ready reference. Page 86.
Yes.
Yes.
ಅಷ್ಟೇ
ಅಲ್ಲ
ಇನ್ನೂ ಇದೆಯಾ
ನೋಟಿಸ್ ತೋರಿಸ್ಬೇಕಲ್ಲ
Annexure A.
Annexure A, page 43.
Yes.
The second para, I request the court to kindly notice one last sentence. In response, the assessee submitted the balance sheets. Kindly mark it.
Yes.
Balance sheets for the period 11/1/2013. On scrutiny of the balance sheets, in line with the show cause notice issued by the DG, the following issues were observed. 2.1, this is the lease cum sale which is covered, and a sum of 7,743 crores is levied.
Now, if you come to page 44,
Please.
After the extract,
Please.
in view of the above statutory definition under the Service Tax Finance Act, activities of KIDB appear to fall within the ambit of taxable service. ನಿಮಗೆ ಡೌಟ್ ಅಲ್ಲಿ ಇದ್ದೀರಾ?
This requires an adjudication.
What adjudication?
This is a show cause notice. I've issued.
It's all right. You yourself, you are not sure of whether it falls under taxable income or not. Service tax leviable or not. But issue a notice saying 7,000 crores, 8,000 crores, 10,000 crores. Sorry, 1,000 crores. Sorry. ನಾನು ಒಂದು ಸೊನ್ನೆ zero ಜಾಸ್ತಿ ಆಡ್ ಮಾಡ್ಬಿಟ್ಟೆ. 1,500.
We have to wind up the board. We just cannot survive if we.
To levy. Purpose of adjudication. No. If they are statutory boards and performing government statutory functions, sovereign functions, we will see. Performing statutory functions. How are you levying service tax on them? If it is a public in nature. What that has to be, circular is issued by you in the year 2006 itself, saying that it cannot be. They are all exempt from service tax. Nodi. Yes, sir. 103.
103.
3 na 1 na?
Annexure D.
103.
103.
ಆಯ್ತು ಹೇಳಿ 103 ನ ಕಂಟೆಂಟ್ ಒಂದೇನೆ ಹೇಳಿ.
Second para, the issue has been examined. The board is of the view that the activities performed by the sovereign public authority under the provision of law are in the nature of statutory obligations which have to be fulfilled in accordance with law. The fee collected by them for performing such activities is in the nature of compulsory levy as per the provisions of the relevant statute. And it is deposited into the government. Such activities purely in public interest. It is undertaken as a mandatory and statutory. These are not in the nature of
such activity of what? Collection of fee and performing certain activities by those statutory authorities. For illustration, the RTO, the Directorate of Boilers. Correct. Illustrations is there. On those illustrations, what is the duty performed by those authorities or boards, or as the case would be, are statutory, mandatory statutory function. Therefore, no service tax is leviable. If no service tax is leviable, why should one undergo the rigmarole of process? However, if performs service,
performs a service which is not in the nature of a statutory activity, and the same is undertaken for a consideration, not in the nature of a statutory fee or a levy, then in such cases service tax would be leviable if the activity undertaken falls within the ambit of tax. So here is another major renting of an immovable property for a commercial purpose.
Renting of immovable property for commercial purpose. Yeah, who rents it?
KIDB, that is the
Well, rental allotment. Allotment ge they charge allotment fee.
Allotment charge ಮಾಡ್ತಾರೆ ಆಮೇಲೆ ಇಂಡಸ್ಟ್ರಿಯಲ್ ಏರಿಯಾ ಡೆವಲಪ್ ಮಾಡಿ ಮತ್ತು ಅದನ್ನ
ಏನು ಲೇಔಟ್ ಡೆವಲಪ್ ಮಾಡ್ದಂಗ ಇದು ಇಂಡಸ್ಟ್ರಿಯಲ್ ಏರಿಯಾ ಡೆವಲಪ್ ಮಾಡ್ತಾರೆ ಆಸ್ ಎ ಫಂಕ್ಷನ್ ಆಫ್ ದ ಬೋರ್ಡ್, ಸ್ಟ್ಯಾಚ್ಯೂಟರಿ ಫಂಕ್ಷನ್ ಆಫ್ ದ ಬೋರ್ಡ್, ಅಂಡ್ it is for the development of industry, correct? Yes. Development of industry in furtherance of the objects and reasons of constitution of the board and its powers and its functions. How is it taxable service? Service taxable service. What's the definition of service tax?
Service tax ಅಲ್ಲಿ 65B. Any
Odi.
activity for the consideration from one person to another person.
ಹೌದಾ? Now what is the what is the concept?
ಈ ಪೀರಿಯಡ್ ಅಲ್ಲಿ ಆ ಡೆಫಿನೇಷನ್ ಇತ್ತು ಎಲ್ಲ ನೋಡ್ಬೇಕು ಸರ್.
ಆಯ್ತು ಒಂದು. ಆಮೇಲೆ 2013 ಆದ್ಮೇಲೆ why wisdom dawned on you?
They also accepted
ಎನ್ನ?
our demand after 2013.
Correct, demand 10 crores.
On what account? That's a lot.
ಅಲ್ಲ, in the same manner you have charged? How can it be the same manner? 1500 crores ಅಲ್ಲಿ 10 crores ಅಲ್ಲಿ. How can it be the same manner of assessment? It can't be.
It may not be the same manner.
But it can't be.
There is some element of a service on which service tax was proposed to be.
Now the learned senior counsel, 1 minute. Learned senior counsel said notice is issued on principally 4 heads.
6 heads.
6 heads. Out of that, 6th head is with regard to maintenance and other things. Their service tax they have accepted. Not allotment fee and other things. That isn't. You 1500 ಕೋಟಿಯಿಂದ you come down to 10 crores. It is only one head that is accepted.
They have accepted some portion of their activity.
ಕೊಟ್ಟಿದ್ದಾರೆ. So all the other earlier notices should go then. No, earlier notices that were issued.
This is one of such notices.
Hello, ಈಗ 2013-14 ಅಲ್ಲಿ ಚೇಂಜ್ ಮಾಡಿ ಅಲ್ಲ, ಆಮೇಲೆ 13-14 ಅಲ್ಲ, ಅವಾಗ ಚೇಂಜ್ ಮಾಡಿದ್ದೀರಾ. So all the earlier things that you have issued should necessarily go. How can you sustain? Board function same, board allotment same, allotment fee same, ಎಲ್ಲ same. 1500 crore ಇಂದ 10 ಕೋಟಿಗೆ ಬಂದಿದ್ದೀರಾ. ಅದ್ರ ಕಾರಣ ನಿಮಗೆ ಗೊತ್ತು ಯಾಕೆ ಅಂತ. ಈಗ ಅದು ಹೆಂಗೆ ಸಸ್ಟೈನ್ ಆಗುತ್ತೆ ಹಳೇದು?
Some element of service is there in.
ಕರೆಕ್ಟ್, ಆ ಎಲಿಮೆಂಟ್ ಆಫ್ ಸರ್ವಿಸ್ ಕೊಡ್ತಾ ಇದ್ದಾರೆ ಅವರು. ದಟ್ ಇಸ್ ಮೇಂಟೆನೆನ್ಸ್ ಅಲ್ಲಿ ಸರ್ವಿಸ್ ಇದೆ, ಸೊ ದೇ ಆರ್ ಗಿವಿಂಗ್ ಇಟ್.
Even earlier to that, this was there.
What was there?
Prior to 2013.
ಎಲ್ಲ ಎವ್ರಿಥಿಂಗ್ ನೆರಳಿಗೆ ಸರ್, everything remains the same. Their activity, your assessment, everything remains the same. The whole problem is your earlier assessment method led to 1500 crores. When you accepted their reply, you brought it down to 10 crores, noticing that it was statutory, sovereign or not, we'll see. Statutory functions, government functions, so you will not levy service tax on that. What is leviable, they have paid. Only on that ground, all your prior activities should go. Why amendment banta avaga? ಮತ್ತೆ ಅದು ಬೇರೆ ಅಮೆಂಡ್ಮೆಂಟ್. No. ಆಮೇಲೆ wisdom dawn ಆಗಕ್ಕೆ was there an amendment? No. Everything remained the same except your wisdom, which gets dawned in 2014 and corrective measures are taken.
Onwards, this is my lord for a period prior to 2011. 2005.
ಅಲ್ಲ, what is the difference in the period? Activity is the same. ಏನು ಚೇಂಜ್ ಇಲ್ಲ. ಫ್ರೆಶ್ ಡಿಟರ್ಮಿನೇಷನ್ ಏನಿಲ್ಲ.
ಅಲ್ಲ, ಇದನ್ನಾರ ಡಿಟರ್ಮಿನ್ ಮಾಡಬೇಕಲ್ಲ.
ಡಿಟರ್ಮಿನ್ ಮಾಡಕ್ಕೆ ಏನು ಉಳಿದಿದೆ ಇಲ್ಲ.
my lord, at least some part of the my lord of their activity.
Part of the ಕೊಡ್ತಾ ಇದ್ದಾರೆ, they have accepted.
It is only after 2013 and 14.
ಯಾಕೆ ಅಮೆಂಡ್ಮೆಂಟ್ ಬಂತ ಅವಾಗ? ಇಲ್ವಲ್ಲ.
Amendment ಇಲ್ಲ.
ಮತ್ತೆ
ಅಲ್ಲ, they are disputing the my lord the prior.
ಸರ್, prior 1500 crores ಕೊಟ್ಟರೆ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡೋದು. 10 crores they have paid.
ಅದು ಇನ್ನೂ ರೇಸ್ ಆಗಿಲ್ಲ, ಕ್ರಿಸ್ಟಲೈಸ್ ಆಗಿಲ್ಲ ಡಿಮಾಂಡ್.
If you have accepted that it is statutory function at a later point in time, except for a particular item, then you can't go back and say what 1500 crores for the whole thing will not. Prima facie.
Even in this impugn show cause notice, that element of service is also there, which they have accepted for subsequently.
Correct. ಆ ಎಲಿಮೆಂಟ್ ಅವ್ರು ಡಿಸ್ಪ್ಯೂಟೇ ಮಾಡಲ್ಲ.
So, at least
ಈಗ ಮೇಂಟೆನೆನ್ಸ್ ಅವ್ರೇನ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಸರ್, ಯಾವ ಹೆಡ್ಗೆ ನೀವು ಒಪ್ಕೊಂಡಿದ್ದೀರಾ 10 crores?
That is being adjudicated. We are not questioning the jurisdiction to issue that.
Jurisdiction always. I am also not on jurisdiction. Now you have paid 10 crores.
ಇಲ್ಲ. That is being adjudicated.
Oh, that's not yet paid, is it?
It is under adjudication.
It's under adjudication. We have We have filed our
So that is
reply.
why he's saying this also should be
No,
adjudicated.
we have paid our, I mean, we have given our reply and contesting it on merits of the.
What has happened? 2015 I'll got a reply.
Now, my lord, if they say that it is, they are accepting it as a service, then only dispute is with regard to quantification. In principle, if they apply.
No, that also they are contesting that also. They are contesting that also.
We are contesting. Now what they have done is, may just demonstrate. Kindly come to page 104.
Yes.
104. This is the balance sheet.
Administrative expenses, water charge, special other charges.
Yes.
Ah.
Now kindly come to the next page, 105.
Notes of accounts.
Yeah. The balance sheet.
Yeah, I'm there.
Yeah. Now the first column gives the amounts that were collected prior to 31/3/2010. So cumulatively, we have brought all the deposits that were made and total it up to 17,953 crores, 20 lakhs, etc., etc. Now this figure they take and levy, they have levied service tax on this figure.
Not at levied.
Notice.
Notice.
And 10 ವರ್ಷದಿಂದ why is this pending for even a notice? Oh, it's 2015 petition. Why is it pending still?
ಅದು 2-3 ಸಲ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಆಯ್ತು. If I may say so with respect, very same queries were asked. Why are you still persisting with these notices when you have yourself realized the folly of issuing such notices? More importantly, the balance sheet cannot be the subject matter. They have taken the figure given in our balance sheet, and so mechanically they have whatever deposits were there, they say you pay service tax on.
All right, we'll pass out. ಇನ್ನೇನಿಲ್ಲ
Authorities ಕೊಟ್ಟಿದೆ government.
Give it. Heard the learned senior counsel, Professor Ravivaram Kumar, appearing with the petition, Jeevan Neralge, reserved.
Compilation you lost.
Kudi, sir.
One latest judgment which is not part of the compilation. This is 2022 SEC online. Assistant Commissioner of Income Tax versus Ahmedabad Urban Development Authority. Para 4 may kindly be page 4. The question is raised. What is the question taken by the court? Para 4.
Yes, and there.
In these batch of appeals and special leave petitions, primary question which falls for consideration is the correct interpretation of the proviso to section 215 of the Income Tax Act introduced by amendment with effect from 1/4/2009. It is necessary at this stage to notice that the IT Act visualized 3 kinds of charitable purposes: medical relief, education, and relief for the poor, which are described hereafter as per se purposes. To this list, Parliament has by amendments added other categories such as preservation of environment, including watersheds, forests, and wildlife, and preservation of monuments or places or subjects of artistic or historic interest, and yoga. The last or the residual purpose included by the definition is advancement of any other object of general public utility, hereafter referred to as GPU category, which is the subject of interpretation in the present case. I'll straight away draw the attention of the court to page 67. After an elaborate review of the entire case law, the summation and conclusion at page 67. last but 3, para 267.
Yes.
Will not trouble the court with the first one. Kindly come to B, capital B. Authorities, corporations or bodies established by statute. The amounts are any money whatsoever charged by a statutory corporation, board or any other body set up by the state government or central government for achieving what are essentially public functions or services such as housing, industrial development, kindly markets,
Yes.
industrial development, supply of water, sewage management, supply of food grain, development and town planning may resemble trade, commercial or business activities. However, since their objects are essential for advancement of the public purposes or functions and are accordingly restrained by way of statutory provisions, such receipts are prima facie to be excluded from the mischief of business or commercial receipts. This is in line with the larger bench decision of this court in Rantanu Cooperative Housing Society versus and NMDC Supra. However, at the same time, in every case, the assessing authority would have to apply their mindset separately.
Because illustration at paragraph 202.
202.
B2 my lord, that is
Illustration paragraph 202 to 210.
202 to
210.
210.
The illustration of what public duties are and why it cannot be said to be, it cannot be charged.
Please.
They are statutory regulatory authorities.
Yes.
ICAI's illustration is taken.
Yeah.
And they are statutory regulatory authorities, what is said. And the conclusion, what you now read.
And may I also refer to one other paragraph, para 155 at page 38.
I am there.
Fee, cess and any other consideration has to receive a purposive interpretation.
Yes.
In the present context. If fee or cess or such consideration is collected for the purpose of an activity by a state government or entity which is set up by statute, its mandate to collect such amounts cannot be treated as consideration towards trade or business.
Tax, yes.
I repeat, it cannot be considered as consideration towards trade or business. Therefore, such amounts cannot be treated as consideration towards trade or business. Therefore, regulatory activity necessitating fee or cess collection in terms of enacted law, collection of amounts in furtherance of activities such as education, regulation of profession, etc., are per se not business or commercial.
No, your answer lies in para 194 and 195.
Please.
Noida Industrial Development Board.
I
Yes.
put on. Thank
Now, Greater Noida Industrial Development Authority, and what the Supreme Court has said in that.
Please. In this context,
Para 195, it was held that the activity done by those two boards not carried on commercial lines with the profit motive in mind, but the body is assigned an administrative role having regard to the objects control exemption cannot be denied. There it was a case of exemption.
yes.
Exemption cannot be denied on 1046.
Yes. The case of Yamuna Industrial Development Authority is also on similar lines.
Yes.
And
267.
Industrial Areas Development Board was a party to this.
KDB also.
It's in the context of income tax.
Income tax,
I agree.
exemption of tax.
267.
Mm.
Will also mechanically summation of truths.
Yes.
Then will also mechanically come to bottom of the B1.
Mm.
Then B2 will also mechanically. They stopped at B1. However, at the same time, in every case, the assessing authorities would have to apply their minds and scrutinize the records to determine if and to what extent the consideration or amounts charged are significantly higher than the cost and a nominal markup. If such is the case, then the receipt should indicate that the activities are in fact in the nature of trade, commerce or business, and as a result would have to comply with the quantified in the proviso to section. In clause B of so has the same meaning as trade, commerce, business in section 2 of the IAI. Therefore, sums charged by such notified body, authority, gold trust or commission, by whatever name called, will require similar consideration. Whether it is at a cost with a nominal markup or significantly higher to determine if it falls within the issue of commercial activity. However, in the case of such notified bodies, there is no quantified limit in section 12. Therefore, the central government would have to decide on a case-by-case basis whether to what extent exemption can be awarded to a bodies that are notified.
Exemption and section 10.
That is for the members who are entering the institutions who are entering the public activities. And in that context,
Context, yes, the decision is rendered on the context, but the senior counsel is wanting to refer to what are statutory functions and statutory duties of the creation under the act.
general functions can't be construed as the statutory functions.
General functions.
That is the general functions of the
Consideration ಎಲ್ಲಿದೆ? Allotment ಮಾಡೋದು industrial development.
The entire exercise is to find out what is there.
In fact,
we will find out if something
such
is
a
there.
detailed notice has been given. There is not a whisper that we have carried on any activity of commercial nature or we have carried out any activity which is not.
ಇದು ಡಿಟರ್ಮಿನ್ ಮಾಡಿ ನಿಮ್ಗೆ 1500 ಕೋಟಿ ಇಂಪೋಸ್ ಮಾಡಕ್ ಬಿಟ್ಬಿಟ್ರೆ ನಾಳೆಯಿಂದ ಅಕ್ವಿಸಿಷನ್ ಸ್ಟಾಪ್, ಇಂಡಸ್ಟ್ರಿಯಲೈಸೇಷನ್ ಸ್ಟಾಪ್.
Hello, now we have to
apprehension.
Forget about the forget.
1500 ಕೋಟಿ ನೀವು 1500 ಕೋಟಿ ಸರ್ವಿಸ್ ಟ್ಯಾಕ್ಸ್ ಆನ್ KIDB ಹಾಕಿದ್ರೆ ಅಲ್ಲ ಆಯ್ತು 1500 crore ಸರ್ವಿಸ್ ಟ್ಯಾಕ್ಸ್ have imposed upon KIDB now. I mean want to impose ಆಯ್ತಾ?
If I may say so with respect, in respect to the first notice, they had levied the same amount, whatever they had demanded, they had levied the same amount. To file an appeal, I was asked to deposit.
Yes, you have to deposit the amount.
350
Yes.
crores. We never had that kind of a money. We had to wind up the board. And then I came before this honorable court when the court threatened to pass a judgment on merits to say that they have no jurisdiction. They came round and said, all right, let them pay 25 crores. 350 crores was to be paid for filing the appeal.
That is the statutory mandate.
Statutory mandate before the. Therefore, one last submission. While interpreting the entries, particularly when there is an apparent conflict between the central list
1 and list 2.
List 1. Because 97 is what they'll be. Only one paragraph I'll read. After an exhaustive.
Repugnancy ಏನಿಲ್ವಲ್ಲ ಇಲ್ಲಿ?
ಇದೆ.
Repugnancy ಇದೆ.
ಇಲ್ಲ.
Repugnancy ಏನಿಲ್ಲ.
ಇಲ್ಲ. Repugnancy. We are not. We are only saying that service tax does not enable or give jurisdiction to levy tax on lands. Now kindly see para 82 at page 40. This is BSNL case.
Yes.
2006 3 SCC page 1. Para 82 at page 40. Only one sentence I'll read. It's a beautiful statement of law. Being aware of the dangers of 81, therefore, the deemed sales included in entry 54 list 2 would also be subject to the limitations of 286, etc. Being aware of the dangers of allowing the residuary powers of Parliament under entry 97 of list 1 to swamp the legislative entries in the state list, we have interpreted entry 54 list 2 together with article 366(29)(a) without whittling down the interpretation by referring to the residuary powers. So this is the crux of the matter.
Yes.
Compilation lost my kind of
ಈಗಲೇ ಬೇಕಾ? ಕೊಡಿ.
On interpretation of article 289. Income and property of the state. Supreme Court has interpreted.
Which judgments?
My lord, the first judgment you lost my kind of take my lord on the Industrial Area Development Authority of the Union of
Yes, sir.
So I extracted the relevant portion in the next paragraph.
Yes. Para 10, 11.
Yes, 10, 11 of this judgment. Then my lord, the second judgment is Andhra Pradesh State Court Council. 64 Supreme Court 1486.
Yes.
The scheme of article 289 appears to be that ordinarily the income derived by states both from governmental and non-governmental or commercial activities shall be immune from income tax levied by the union.
Shall be immune. Shall be immune antane.
That's what, well, exceptions are given.
Yes, yes.
Exceptions are given. 289(1) and 289(2 is an exception to 289(1) and 289(3 is exception to 289(2). Unless and until a specific exemption is provided under these articles or by virtue of a statutory definition or contained in the statute, not a definition, statute. There cannot be any right for vested right in making an exemption, giving an exemption on the ground that it is a statutory. General functions of the contained under the statute cannot be termed as a sovereign function. That's my point.
Yes, general function cannot be construed to be a sovereign function. We'll see. Yes.
Statutory function.
Statutory function is different from sovereign function. We'll answer. Yes.
Statutory function. One more, I would add, that my interpretation. Statutory function is that function, the non-performance of which attracts some consequence. That alone could be construed as
no. Only only penal consequences will not determine as function to be statutory or otherwise. No. That we'll see. Yes.
It is allowed to.
Oh,
in one of the general functions of the under the daily guide. They are allowed to rent, lease, pay, and whatever.
Rent, lease, sale ಏನು ಇಲ್ವೇ ಇಲ್ಲ. Lease come sale ಮಾಡ್ತಾರೆ, allot ಮಾಡ್ತಾರೆ, allotment.
Rent is also is permissible.
Where is permissible?
Under the general functions of the daily guide.
All right, we'll consider. Yes.
So that.
Lord, we'll see.
No.
Yes.
Because some element of service is involved on some item. If the entire show cause notice is required, then that will.
ಮತ್ತೆ ಅದನ್ನ you should, part of it should be sustained, is it?
At least I am allowed to find out.
We'll see.
Whether any activity falls within
prima facie
the tax domain.
We'll see. Yes.
Because subsequent years they themselves say that we have scaled down and they are contesting on merits, etc. That is also if this honorable court shuts the door. Now, that it will have a bearing on the even subsequent years. My concern is that.
I know. Yes.
To have
we'll see. Yes.
Judgments may
that you don't worry. Every argument of yours and judgment will bear consideration.
One more thing is that PMTC, KSRTC, they are all providing this utility service, public utility service. And
you are charging them service tax on what basis? On their balance sheet, is it?
No.
Then?
They also.
No. How do you charge them?
No. For example,
on individual services that they undertake, correct? Then why are you charging?
BMTC also some kind of commercial activity, allowing the companies to exhibit their
exhibitor?
Advertisements.
Yes.
Their places, etc. On that, service tax is being charged. If all statutory functions by all statutory bodies not amenable to tax fees.
We'll see. We'll see.
They perform the functions.
No, I am aware of the ramifications, so we'll answer it accordingly. Yes.
Some portion is that element of service is there in the activity. And they contend that it falls within 97 article, 1897 state list was that all the matters to be examined during the course of an adjudication. If my lord puts the parameters in which my lord the adjudicating authority, accordingly my lord will follow. But shutting out the entire passion to my lord, even earlier it will have an impact on the earlier demands and the future demand. That's my concern. I'm not that. It's not that I'm not conscious about the functions of the JD.
Let's see.
Other ramifications about that.
Yes, reserved.
One judgment I wanted to point out.
Which judgment?
Because the issue is no longer res integra.
With regard to what?
Levying tax on the functions of an industrial area development. In Maharashtra, it is there in
the compilation.
Yes. Page 8 may kindly be referred to.
Nasik versus Maharashtra Industrial Development.
Please,
Yes.
Justice Okayasi then was
Hmm.
the division bench ruling.
Hmm.
Kindly come to the page 11, page 10, para 5.
Yes.
We have given careful consideration to the submissions. Firstly, it will be necessary to note what is set out in the circular dated 18th December 2006, bearing number so and so, class 2 and 3 of the said circular read thus. The same circular which I brought to the notice of the court. It has been extracted.
Yes.
Thus, the activities performed by sovereign or public authorities under the provisions of law, which are in the nature of statutory obligations, are covered by clause 2, which provides that the fee collected by such sovereign or public authorities for performing such activities is in the nature of compulsory levy only if such authority performs service which is not in the nature of statutory activity, and the same is undertaken for consideration which is not in the nature of such statutory fee. Service tax would be leviable if the activity undertaken otherwise falls within the ambit of taxable service. Going by the show cause notice, the allegation is that the respondent MIDC has collected service charges from the plot owners or the plot allottees in consideration of having provided them various facilities including maintenance, management and repairs of the facilities of the MIDC area. As stated earlier, reliance is placed on clause 64 of section 65 of the said act. As pointed out earlier, MIDC is already registered under the category of renting of
Para 12 and 14.
Yes, directly. Not a whisper that we are carrying on any activity outside the provisions of the statute. And this, the department has accepted this. They did not take it in this thing.
Yes.
These submissions I.
Yes. ಇದರಲ್ಲಿ paragraphs mark ಮಾಡಿದ್ದೀರಾ?
ಇದೆ paragraphs.
Para ಇದೆ. Yes.
But I'm not able to, my lord, make a statement at this stage now. But this is an
What statement?
My lord, indirect tax. Whether they have collected the service tax separately from their allottees or, my lord, customers, clients, my lord, cannot. That's my lord, that's one aspect. Because
that's a jurisdictional issue.
Because if they have collected it and dispute the liability, my lord, then it becomes, my lord, a contentious issue. That also has to be, my lord, has to come up in the adjudication.
We spent 1 hour on this.
No. One more submission. In the GST, my lord, I can certainly say that, my lord, they have collected the, my lord, the tax from there. GST is nothing but, my lord, continuation of the old.
This is the earlier regime.
This is the earlier regime. My lord, GST is, my lord, then not much of a, my lord, fundamentally, my lord, the concept is the same. Service tax and the GST. Where it is a service, my lord, here it is a supply. My lord, in the GST regime, my lord, KDB has collected the service tax. If the same has been followed was followed in the, my lord, earlier years, my lord, then there cannot be any escape from taxation.
Yes.
That is the, my lord.
The question is with regard to whether you can flex your muscles to that kind. That's all.
No, as a matter
My
of
lord,
fact,
whether I can hold an inquiry whether, my lord, it is taxable or not.
No.
Some parameters can be laid down, my lord, because otherwise, my lord, it will have a bearing on, my lord, all in future assessments.
You should have been explicit in your show cause notice.
What, my lord?
Why you are wanting to levy on what head?
My lord, that's, my lord, is very lengthy show cause notice, my lord. He
That's
discusses all these aspects.
Yes.
Maybe, my lord, his reasoning may not be this thing.
the GST, I dispute this statement. We are not paying any GST, no registration and no notice also.
Registration illde GST.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದು ಡಿಸ್ಪ್ಯೂಟ್ ಪೆಂಡಿಂಗ್ ಇದೆ. ಕಲೆಕ್ಟ್ ಮಾಡಿದಾರೆ ಅಂತ ನಮ್ಮ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ನವರು ಹೇಳ್ತಾರೆ ನನಗೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. have collected ಅಂತ ವಿಥೌಟ್ ರಿಜಿಸ್ಟ್ರೇಷನ್.
Without registration, GST collection.
Collect ಮಾಡಿದಾರೆ ಸರ್.
They should have slapped a notice.
Sir, my lord, they have given me a calculation which I don't want to make it a part of it because that's
ಸರಿ. Yes. Yes. Entry mode ಇದೆಯಲ್ಲ?
ಇದೆ.
That's absolute.
ಇಲ್ಲ, it has to be continued.
The entry mode subsisting would continue to the disposal of the petition. Yes, next. Second list.
List number 2, seal number 1 and 2 adjourn, seal number 3.
I'm hearing for respondent number 16, my lord. This is in connection to that.
ಏನ್ ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ ಯಾವ್ದು ಮೇಡಮ್ ಇದು?
Earlier, my lords, it appears his lordship appeared for one of the party.
Oh.
Not before me, man.
Yes, sir.
So I need some weeks.
What's the matter?
Lords, this is with regard to, my lords, the same person, my lords, so who violated the, my lords, the matter went up to Supreme Court. The same person, my lords, is before my lords with the vacating stay application. Lords, channel itself was, my lords, initially blocked. My lords, initially I filed suit in the year 2023. Injunction order was granted. Lords, he continuously violated the injunction order, and then, my lords, I filed the writ petition before this court. In this, my
ಯಾವ್ದು ಅಣ್ಣ ಬಾಂಡ್ ಅಂತ ಇದೆ?
Anna bond alla, idu
Illa. It is Kudla Rampage.
Kudla Rampage, my
Oh,
lords.
that matter.
Same matter.
That matter, there are 3 writ petitions are pending, my lord. In by
ನೀವು
way
ಯಾರಿಗೆ
of
ಮೇಡಮ್?
She represent, my lords, Kudla Rampage.
Kudla Rampage plus.
Now, my lords, Kudla Rampage buzz.
I have filed.
ಹೌದು, 3 ಮಾಡಿದ್ದಾರೆ ಈಗ.
ಆಯ್ತು ಸರಿ.
ನಾನು ಎಷ್ಟು ಮಾಡಿದ್ರು ಇವರು ಡಿಲೀಟ್ ಮಾಡಿಸ್ತಾರೆ ಅದನ್ನು ಒಂದು ದಿವಸಕ್ಕೆ. ನಾನು ಏನ್ ಮಾಡ್ಬೇಕು? ಐ ಆಮ್ ಅ ಯೂಟ್ಯೂಬರ್ and 3-4 members are working under me,
My lords,
and I have filed stay vacation
You'll come
application.
up with another channel, don't worry. Yes.
6 months back I have filed vacating, and the interim order is modified against
So it's come up for the first time before me.
ಇದು vacating ಬರಲ್ಲ ಈಗ, ಆಲ್ರೆಡಿ ಇನ್ನೊಂದು ಹೊಸ ಚಾನೆಲ್ ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲ ತಮ್ಮಂದೇನು ಬಂದಿತ್ತು ಒಂದ್ಸಲ.
ಮುಂಚೆ ಬಂದಿತ್ತು.
ಬಂದಿತ್ತು.
ಹೌದಾ, ಇದು ಬಂದಿಲ್ಲ.
into it ಅಂತ.
My lords, I
3 and 3.1 ಮಿಲೋ.
ಇನ್ನೂ ಒಂದಿದೆಯಾ?
ಇನ್ನೊಂದಿದೆ, 3 ಇದೆ ಟೋಟಲ್, 3 writ
ಅದು
petition.
ಇನ್ನೊಂದು ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ ಇವತ್ತು.
3 and 3.1 ಇದೆ, ಇನ್ನೊಂದು ಮ್ಯಾಟರ್ has not been listed today.
ಅದು ಟ್ಯಾಗ್ ಮಾಡಬೇಡ.
ಅದು ಟ್ಯಾಗ್ ಮಾಡಿ.
My lord,
ಅಲ್ಲ ಈಗ
ಡಿಬೇಟ್ ಮಾಡಬೇಕಾ?
already interim order is modified against one of the respondents.
ಅದರಲ್ಲಿ ಅಫಿಡವಿಟ್ ಹಾಕ್ಲಿಕ್ಕೆ ಹೇಳಿದ್ದಾರೆ, ಅವರು ಅಫಿಡವಿಟ್
I have-
ಹಾಕಿಲ್ಲ ಇನ್ನೂ ಕೂಡ.
I have filed my
Respondent number 13 is not filed.
ಇಬ್ರು ಹೇಳಿದ್ರೆ ಹೆಂಗ? ವಾಟ್ ಇಸ್ ದಿಸ್?
I'm sorry.
ಹೇಳಿ.
waiting since 6 months I am waiting, and
ಮೇಡಮ್, ನಾಟ್ ಬಿಫೋರ್ ಮೀ. ವೇಟ್, you ಬೇರೆ ಇಲ್ಲ, ನಮ್ಮ ಹತ್ರ ಬಂದ್ಮೇಲೆ ಮುಗಿತು.
3.1
ನೆಕ್ಸ್ಟ್ ವೀಕ್
ಇದೆ.
ಮುಗಿಸ್ತೀನಿ.
3.1 ಬಂದಿತ್ತು.
ಹಾ ಹೇಳಿ. 3.1 ಕೊಡಿ.
ಬಂದಿತ್ತು. It is I am respondent number 10.
3.1 ಸಾಹೇಬ್ರ ಮುಂದೆ ಬಂದಾಗ
ಏನ್ ಸ್ಟೇಜ್ ಟೇಕನ್, ಸ್ಟೇಜ್ ಗ್ರಾಂಟ್ ಆನ್ ವಾಟ್ ಗ್ರೌಂಡ್?
My lords, now they have been continuously violating the court order and also the observation made by this honorable court in one of the writ petition. Then, my lords, interim orders are continuously
violating the court order. And which court order?
This honorable court's order.
Which orders?
My lords, Justice Devada's order, my lords. And then, my lords, they went on to make allegations against, my lords, the judges also, this honorable court judges also. We have pointed out that the very same channel, my lords. And, my lords, I would like to point out.
I may submit, my lord. The allegations, whatever they have produced before this court, that has been made by one other respondent, my lord. They are confusing with that. Respondent number 12 is the person who has made the
I
statements.
will not in this stage. We'll post it for preliminary hearing and dispose it.
My lord, already modify ಆಗಿದೆ ಒಬ್ಬರೇ against R30.
ಏನ್ modify
Affidavit
ಆಗೋದು?
ಹಾಕಿದ್ರೆ it will be open ಮಾಡ್ತೇವೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
Which date order?
My lords, if I may.
183.
Wait, madam.
23/7/20.
You're on VC. You should wait.
27/3 ಇದ್ದ order.
27/3/2025.
ಹೌದು. ಅದರಲ್ಲಿ respondent number 13.
ಅಲ್ಲ, ಯಾವ ಪೆಟಿಷನ್ ಅಲ್ಲಿ ಕನೆಕ್ಟೆಡ್ ಅಲ್ಲ ಇದರಲ್ಲಿ?
ಇದರಲ್ಲಿ 15/183 ಅಲ್ಲಿ.
15/183 ಅಲ್ಲಿ
ಅಫಿಡವಿಟ್ ಹಾಕಿದ್ರೆ ಅವರ ಚಾನೆಲ್ ಓಪನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಅವಕಾಶ ಕೊಟ್ಟಿದ್ರು.
ಅಫಿಡವಿಟ್ ನೀವು ಹಾಕಿದ್ದೀರಾ?
ನಾನು ಹಾಕಿದ್ದೇನೆ, 6 ತಿಂಗಳ ಹಿಂದೆ ಹಾಕಿದ್ದೇನೆ. I said I will comply with I will not pass any defamatory statements ಅಂತ ನಾನು ಹೇಳಿದ್ದೇನೆ. I will comply with the orders ಅಂತ. And moreover, my lord, the interim order and the final prayer, interim prayer and the final prayer is same, my lord. 3.1 ಅಲ್ಲಿ ನೋಡಿದ್ರೆ.
ಅಲ್ಲ, ಈಗ ಅಫಿಡವಿಟ್ ಹಾಕಿದ್ರೆ ಮಾಡಿ ಬೇರೆ ಬೇರೆ ಆರ್ಡರ್.
23/7 ನೋಡಿ, ಇವರು ಮಾರ್ಚ್ 25 ಇದು ಹೇಳ್ತಾ ಇದ್ದಾರೆ. 23/7/2025 ನೋಡಿ in the companion petition, because that my lord would indicate, my lord, this very case number
23/7/2025.
WP number 15/183. That's my lord the where Mr. Rajshekar appears.
21/7.
Companion petition ಇದೆ ನೋಡಿ.
23/7 ಯಾವ್ದು ಕೊಡಿ? 23/7.
WP number
Justice Sunil Dutt Yadav.
Correct. Sri so and so learned counsel appearing on behalf of so and so submits.
It is clarified that the undertaking without prejudice to the rights to challenge the orders passed.
Correct.
Respondent number 19 direct unblock ಈ ದಿನ
He was, my lord, required to, my lord, file an affidavit. That he has not filed.
ನಾನಲ್ಲ.
ಅಲ್ಲ ಈಗ ನೀವು ಹಾಕ್ಬೇಕಲ್ಲ.
ನಾನು ಹಾಕಿದ್ದೇನೆ. I have filed it.
ತಿರ್ಗಾ violate ಮಾಡಿದ್ದಾರೆ ನೋಡಿ.
ಇಲ್ಲ I have filed the affidavit in the month
ಹಾಕಿರೋ
of
ಸ್ವಲ್ಪ ನೋಡಿ ಆಮೇಲೆ my lord, if still
February 2025 in one of the petition 35-158 ಅಲ್ಲಿ my affidavit may be perused.
ಈಗ ನೀವು ಒಂದು ಕೆಲಸ ಮಾಡಿ, ಒಂದು ಫ್ರೆಶ್ ಆಗಿ ಅಫಿಡವಿಟ್ ಸೋಮವಾರ ಹಾಕಿ,
ಆಯ್ತು,
ಮಂಗಳವಾರ ನಿಮಗೆ ಅನ್ಬ್ಲಾಕ್ ಮಾಡು.
ಆಯ್ತು.
Permission ಕೊಟ್ರೆ same order may be passed.
I will pass an order directing you to file an affidavit by Monday. I'll take this on Tuesday.
27-25ಕ್ಕೆ ಏನ್ ಹೇಳಿದ್ದಾರೆ ಅಂತ ಸ್ವಲ್ಪ ತಾವು ನೋಡಿದ್ರೆ ಯಾವಾಗ ಹಾಕಿದೆ?
ಅದೇ ಇನ್ನೊಂದು ಕೇಸಲ್ಲಿ ತೋರಿಸಿದ್ರಲ್ಲ ಅದಲ್ವಾ?
Absolutely. ಅದು
that is by respondent number
ಸ್ವಲ್ಪ
12.
ಆದ್ರೂ I
by
don't want to
respondent
say
number
it is
12
virtually, my lord, a clear case of absolute contempt. ಇನ್ನು ಇದಕ್ಕಿಂತ ಹೆಚ್ಚು ಬೇಕಾಗಿಲ್ಲ.
That is the statement made by other respondent, my lord. Respondent number 12 ನಾನು ಮೀಡಿಯಾ
ಇವರ ಚಾನೆಲ್ ಅಲ್ಲಿ
ನನ್ನ ಚಾನೆಲ್ ಅಲ್ಲಿ ಬಂದಿದೆ ಅಷ್ಟೇ.
ಟೇಕ್ ಡೌನ್ ಮಾಡಿ.
ಅಲ್ಲಿ ಮುಂದೆಯಿಂದ ನಾನು ಅವ್ರದ್ದು ನಾನು ಇಂಟರ್ವ್ಯೂ ಮಾಡೋದಿಲ್ಲ. ಅವ್ರ ಇಂಟರ್ವ್ಯೂ ನಾನು ಮಾಡೋದಿಲ್ಲ.
ಅವರ ಇಂಟರ್ವ್ಯೂ ನೀವು ಮಾಡೋದಿಲ್ಲ.
ಬೇರೆಯವ್ರದ್ದು ಮಾಡಿ ಇದನ್ನ ಇದೇ ತರದ್ದು ಹಾಕ್ತಾರೆ.
Defamatory statement.
Well, let the affidavit come.
Please, my lord.
The coordinate bench in terms of the order dated 23/7/2025 permitted directed unblocking of a particular unblocking of channel run by YouTube channel run by respondent number 19. The petitioner is which respondent?
16.
The respondent in the case at hand is 16, who is now seeking a similar order on the score that an affidavit in the month of February is already filed. The learned senior counsel Shri Uday Holla, appearing for the petitioner, submits that after the
in this case I have filed it on 16th July 25. In the 3.1 I have filed it in
ಇನ್ನೊಂದು ಹಾಕ್ಬಿಡಿ. Yes.
ಅಲ್ಲ ಫೆಬ್ರವರಿ ಅಂತ ತಗೊಂಡ್ರಿ.
ಫೆಬ್ರವರಿ ಇನ್ನೊಂದರಲ್ಲಿ ಫೆಬ್ರವರಿ ತಾನೇ ಹಾಕಿರೋದು.
ಹೌದು.
And in the ಇನ್ನೊಂದು ಯಾವತ್ತು ಹಾಕಿದ್ರೆ 16 ಜುಲೈ.
Yeah, first one case
ಅದು ಯಾವ
16
ಕೇಸಲ್ಲಿ
July 2025. ಇದು 15-183.
ಇದರಲ್ಲಿ ಹಾಕಿದಿರ ಆಲ್ರೆಡಿ?
ಹೌದು.
ಹಾಗಾದ್ರೆ 16 ಜುಲೈ ಆದ್ರೆ ಇಟ್ಸ್ ಕ್ವೈಟ್ ರೀಸೆಂಟ್. ಐ ನೀಡ್ ಇನ್ನೊಂದು ಅಫಿಡವಿಟ್ ಬೇಕಾಗಲ್ಲ.
ಅದಾದ್ಮೇಲೆ 20ಕ್ಕೆ ಮತ್ತೆ ಮಾಡಿದ್ದಾರೆ. 16ಕ್ಕೆ ಅಫಿಡವಿಟ್ ಹಾಕ್ತಾರೆ, 20ಕ್ಕೆ ಹೋಗ್ತಾರೆ, ಜಡ್ಜಸ್ಗೆ ಬೈತಾರೆ.
ನಾನಲ್ಲ ಬೈದದ್ದು. ನಾನು
ಇವರ ಚಾನೆಲ್ ಅಲ್ಲಿ.
I don't know, my lord. I can only say this. I don't want to, my lord, blame anybody. But then, my lord,
this affidavit
court,
may be
my lord,
considered.
today, this is the only institution where, my lord, the people have faith. If, my lord, that gets eroded, then nothing remains, my lord, in this.
Now,
ಅಷ್ಟೇ.
Before that, you are an officer of the court.
Yes, my lord.
All of your responsibility is to protect the institution.
Absolutely.
So first file an affidavit. Ask your client to file an affidavit on Monday with regard to whatever affidavit the others have filed, that you will not interview or whatever, defamatory or derogatory, whatever, of matters that are sub judice already.
The
All right?
contents are same, my lord. This affidavit also. I said I will
ನೀವು
not
ಅದಕ್ಕೆ 20ಕ್ಕೆ ಮತ್ತೆ ಮಾಡಿದ್ದೀರಾ ಅಂದ್ರೆ
ಅದು 12
ಅಲ್ಲ,
respondent
ಅದಕ್ಕೆ ನೀವು ಒಂದು ಕೆಲಸ ಮಾಡಿ, ಮಂಡೇ August 18th ಒಂದು affidavit ಹಾಕಿ, ಆಮೇಲೆ ಏನು ಮಾಡಿ, I will direct unblocking, because there is an identical order passed by the coordinate on so and so. The learned senior counsel for the petitioner submits that the said affidavit that is filed on 16 July 2025 has also been breached subsequently, which is disputed by the counsel representing the respondent number 16. Be those submissions as they are. In the light of the order passed by the coordinate bench on 23/7/2025, quoted supra, I deem it appropriate to direct the respondent number 16 to file an affidavit afresh as the affidavit filed by respondent number 19 list by 18th August 2025, list on Tuesday in preliminary hearing.
My lord, in W35158
ಅದನ್ನ ಡಿಲೀಟ್ ಆದ್ರೂ ಮಾಡ್ಬೇಕಲ್ಲ, ಅದು ಮಾಡಿಲ್ಲ.
ಇನ್ನೂ ಇದೆಯಾ?
First I have deleted. ನಾನು ವಿಡಿಯೋ ಡಿಲೀಟ್ ಮಾಡುವಾಗ ಅವ್ರು ನನ್ನ ಚಾನೆಲ್ ಡಿಲೀಟ್ ಮಾಡಿದ್ರು. Other matter I will respond in number 16.
My lord, I appeal respond number 7 in WP3515.
Why are you on VC?
My lords,
come on Tuesday. Yes.
Same order for
interim order subsisting.
3.1 also same order.
Same order. ಎರಡರಲ್ಲೂ same order.
ಅದರಲ್ಲಿ ನಾನು respondent number 10.
ಆಯ್ತು. 16 and 10 ಇದರಲ್ಲಿ ಒಂದು respondent number 16 ಒಂದರಲ್ಲಿ, respondent number 10 ಇನ್ನೊಂದರಲ್ಲಿ.
10 ಫಸ್ಟ್ ಮ್ಯಾಟರ್.
ಅಲ್ಲಿ ಕುಡ್ಲಾ ರಾಂಪೇಜ್ ಅಂತ ಇರುತ್ತೆ, ಅದು ಯಾವ ರೆಸ್ಪಾಂಡ್ ನೋಡ್ಬಿಟ್ಟು ಅದನ್ನ ಇನ್ನು ಇನ್ಯಾರಿಗೂ ಅನ್ಬ್ಲಾಕಿಂಗ್ ಕೊಟ್ಬಿಟ್ರೆ ಕಷ್ಟ. Yes, next.
Number 4.
My lords, I pay for the petitioner.
8 lakhs.
My lords,
Not possible.
My lords, I'll pay. Today I'll pay 2 lakh.
2 lakhs.
Within a period of a week, my lords, I'll pay the.
Then we'll vacate the interim order.
My lords, one submission. My lords, in addition to that,
As a last chance, I've already said there should be some sanctity to the orders passed.
My lords, in that respect,
Misplaced sympathy cannot go on.
I'll deposit another 2 lakhs over that, whatever the 12 lakhs it's ordered. My lords, there is a property is about to get it sold.
What to do, sir?
My lords, a week, my lords. I'll pay additional 2 lakhs over the.
No, sir. What 4/8/2025 order.
My lords,
12 lakhs in the next 4 weeks. Yes, Nandish.
2/7, my lord, the order passed by this honorable court, my lord, to deposit 12 lakhs. Their claim, my lord, as on today, more than 50 lakhs.
That is 45 lakhs. I already paid the principal amount, which is.
Your judgment at all.
14.
Yes, my lord.
Nice. The petitioner, this court on 2/7/2025 had passed the following order. A interim order of stay of all proceedings in execution was granted subject to the condition that the petitioner would deposit 12 lakhs within 4 weeks, which would be on or before August the 1st, 2025. The matter was listed on 4/8/2025, on which day this court passed an order, owing to the fact that the petitioner had not deposited. ಏನು ಕೊಟ್ಟಿಲ್ಲ,
4 lakhs
not deposited a rupee even on the said day. Today, the learned counsel for the petitioner submits that he would hand over a demand draft of rupees.
My lords, 4 lakhs already been deposited in the court.
Where? Which court?
This court itself.
ಯಾವಾಗ?
On 4/8, I have deposited 4 lakh.
Where? No. Oh, illide, yes, 1 minute. Received 4 lakhs in State Bank of India, so and so. It's Chara. Yes. 4 lakh ತಗೊಂಡು ಒಂದು ವಾರ ಕೊಡ್ಲಾ?
ಅಲ್ಲ, ಇಲ್ಲಿ ಏನಾಗಿದೆ,
I'm further depositing another 2 lakhs.
Kindly turn to ink page number 56. My lord, as on the date, my lord, the 2020, January 24 itself, my lord, the demand is 43 lakhs 37,000. As on today, my lord, it
you
will
will transmit,
50 lakhs.
then we'll permit him to withdraw this amount also. Let the,
One submission.
no, I would already see, as I had indicated, this court on 4/8/2025 had clearly indicated that it would be a last chance. The last chance, in the event the entire amount would not be deposited, the interim order would stand automatically vacated. In that light, the interim order has not been complied in its entirety except the deposit of 4 lakhs. There is breach of the interim order. In the light of the said breach, the interim order stands vacated, reserving liberty to the petitioner to seek its restoration on compliance with the interim order in its entirety. Yes, next.
5.
I'm appearing for the
respondent
respondent
number
number 1, my lord.
2 and
Now,
2 to 4, my lord.
In the execution petition, my lord, court sale was conducted, spot sale is completed. The respondents, the petitioner's contention, my lord, his offer is for 1 crore 18 lakhs. Now in the public auction, my lord, a sum of rupees 4 crores 18 lakhs. Now already spot sale was conducted. Now what he says, my lord, it is less than the market value. Now if he is to deposit 4 crore 18 lakhs, my lord, we have no objection. For the past 35 years, my lord, he is prolonging this matter.
Pass over. If
An award is sought to be.
Pass over. If he doesn't come, I'll vacate the interim order.
Yes.
I've already indicated.
My lord, last date of hearing, yes, misrepresented saying that the execution was filed after 14 years delay. Actually, there were appeals pending, my lord, that he has suppressed, my lord.
It's all it anyway.
2001.
Pass over. If he's not there, I'm vacate the.
Yes.
Yes. Next.
6.
There are for the petitioner, my lords.
Council submission. Yes, sir. Order 6, Rule 17.
Yes, sir. My lord, this is suit for specific performance. The petitioner is the respondent number.
Where is the impugned order?
Impugned
Page
order is-
44.
Yes, my lords.
That is not 617.
Page 44, my lord.
That is not 617, sir.
Alla, adu.
Reopen the case, recall DW2.
Yes, Your Honor. 44, 45. I mean, ಅದೇ 3 IA ಇದೆ, 3 IAಗೂ ಒಂದೇ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ.
ಒಂದೇ ಆರ್ಡರ್?
ಹೌದು ಸ್ವಾಮಿ.
What's the stage of the proceeding?
It is
ಯಾರ್ಯಾರು ಯಾವ್ಯಾವ IA ಹಾಕಿದ್ರಿ? Plaintiff ಯಾವ್ದು, defendant ಯಾವ್ದು?
defendant. The defendant has filed 3 IAs. One to reopen. And
ಒಂದು
to
amendment?
not amendment, to additional documents. ಅಷ್ಟೇ ಸ್ವಾಮಿ, ಅದು ಹಾಕಿರೋದು. That has been rejected and the matter is posted for judgment day after. The reason why you want.
You are the one who filed the applications. Yes, sir.
I filed the application to produce a document on record at the time of arguments, no doubt. That I filed at the time of arguments at the on merits. And I was able to secure the document only on an affidavit till here is,
23/7/24.
14/3/2025.
In document?
Yes, sir. The Honorable Court please to permit.
What is the date of the document?
The date of the document is, it is a.
When did you file your written statement?
Oh, that is in the year 2010, Your Honor.
All right.
The document which I wanted to produce is a copy of another suit filed by against the plaintiff in the same court. Yakandre, the plaintiff is a very powerful man seeking specific performance of an agreement which was not entered for the purpose of selling the property. It was a hand loan. For that, I have laid evidence. I have given all the documents on record. There was a bank loan which the defendants had to repay. That bank on a bank loan repay madodike, they have sought for a loan from the plaintiff. But it was a hand loan. The rate of interest was too high. The defendants sought for a lower rate of interest. The plaintiff on a condition that ನೀವು ನನಗೆ ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡಿಕೊಟ್ರೆ interest kadame ಮಾಡ್ತೀನಿ.
ಅದೆಲ್ಲ ಸ್ಟೋರಿ ಅಲ್ಲಿ ಹೇಳಿದೆ.
Yes, all that is done. The document which I wanted to produce is a suit filed against the plaintiff, wherein it says that the plaintiff, that is in OS.
By whom? By third party.
By a third party.
All right.
And in the.
How does that have a bearing to your case?
Because in the during cross-examination of the plaintiff PW1, the plaintiff, there was a question to the plaintiff whether is there any other suit filed by you against any person in this court. He denied. At that point of time, a document was confronted. That is again a suit for specific performance filed by the plaintiff. ಅವರೆಲ್ಲರಿಗೂ ಸಾಲ ಕೊಡೋದು, agreement ಮಾಡ್ಕೊಳ್ಳೋದು, and specific performance ಹಾಕೋದು.
All right, you serve on the council.
I have already served.
ಯಾರಿದ್ದಾರೆ?
ಅಲ್ಲ, ಅಲ್ಲಿ ಕನಕಪುರ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಡ್ವೊಕೇಟ್ ಆನ್ ರೆಕಾರ್ಡ್ ಸರ್ವ್ ಮಾಡಿದ್ದೀನಿ. I have already served.
First time ಬರ್ತಾರೆ. Why did you serve?
ಅಲ್ಲ, ನಾನು just to be a little careful.
Very careful.
Extra cautious. I have already served. ಅದು presentation copy ಇದೆ ಇಲ್ಲಿ.
Petitioner to serve the respondent by way of hand summons or the counsel for the respondent before the concerned court. List the matter on 22nd. Further proceedings before the concerned court till the next date shall remain stayed. Next.
7.
Your Lordship, I am appearing for the petitioner for 7 and 7.1, Your Lordship. With regards to the office objection, if 2 days time may be given, I will comply with the office objection.
Counsel for the petitioner seeks 2 days time.
For humble submission, if Lordship can pay a kind attention towards my interim prayer.
What is the problem, madam?
Your Lordship, here the petitioner was in unauthorized cultivation of 4 acres of land in survey number 3. The same he has given a darkhast application to the Tahsildar and he got for the regularization, and the same had been regularized by the TC, which has been further confirmed by AC. Further, what happened, Khata got transferred in my name. We have got the Sagovali cheat issued in our name. We paid the upset price. Consequently, respondent number 1.
When did all this happen?
Lordship, 1969, we were given everything in our name. All of a sudden, in 1999, respondent number 1, state of government has transferred the entire land to, with regards to 38 acres and 31 guntas.
You are
to-
still in possession?
We are still in possession, but what happened is KIDB has issued executed a lease deed in favor of NECE, who is respondent number 6 herein. They have come down to my property and they
Nandi
have.
corridor.
Lordship, it is nice matter. Accusation, they are challenging
PV
notification.
Chandrasekhar. Counsel PV Chandrasekhar is directed to accept notice for respondent.
If Lordship directs, I would furnish the copy regarding.
Yeah,
the-
KDB library.
KIDB is there, Your Lordship. Respondent number 5 is KIDB.
Oh, 5 is 1, 2, 3, 4. AGR.
One, I am.
Oh, you need sorry. Yes. One alla ella neeve.
No, my lord.
Deputy
Only for
Commissioner.
state. Rest of the panel.
1 to 4 state.
Please, my lord. I'll.
1 to 4 Ravindra Reddy, 5 PV Chandrasekhar, 6 Nitin Prasad, 6 and 7 Idyavud Bangalore Mysore Corridor Planning Authority.
Yogesh Nayak.
Yogesh Nayak 7.
Lordship, furnish the
Co-
copies. I've already furnished the copies.
Photo tegibeka.
Illa, just
ಮತ್ತೆ
for a
wait,
humble
yes.
submission.
The petitioner to serve set of papers upon the aforesaid council, if not already served, list the matter on Tuesday. The petitioner, if in possession today, shall not be dispossessed till the next date.
This did
Huh?
This did transfer.
ಗೊತ್ತಿಲ್ಲ. If in possession today.
8.
The petitioner, my lords. My lord, this is a fresh petition that we have filed, challenging.
Fusion
the
of
order-
sound.
Uh, My lord, this is a fresh petition. We are challenging IA number, orders on IA number 1 and a subsequent order that was on the memo of clarification that we had filed on the orders on IA number 1. The order is dated.
Now, what is the commercial code done, madam?
My lord, the suit is for eviction and for recovery. We are not in the premises anymore. We have vacated.
It's
on
only
30
recovery of money now.
It's only recovery of money, my
Yes.
lords.
Hmm.
So the plaintiffs had filed an IA for deposit of arrears of rent of about 56 lakhs, my lord. And the honorable court has passed an order asking the defendants to deposit an amount of deposit the admitted rents for the period of January 2024.
What are the admitted rents?
My lord, that was the confusion in the order, my lords. Thereby, we submitted a memo for clarification, wherein we also calculated the amount that we might have to pay in case if we were to pay the admitted
No,
rents.
you tell me, according to you, what is the admitted rent? Admitted arrears.
My lord, no, we haven't admitted how much the rent is. We have only admitted that we haven't paid the rent from the period January to July.
January 2025.
January 2024, my lords.
On what strength? On a lease deed, is it?
Yes, my lords.
Ah,
There was
what
a
does the lease deed
but the
say
lease
about
had
the rent?
expired in 2023, my lords. So we were a tenant on month-to-month basis from then on.
Month to month basis.
Yes, my lord.
On what basis? Rent.
Rent was paid as per the invoice that was raised by the plaintiff.
What is one invoice you have here?
Yes, my lords. We have
which is
produced that on page number
Hmm.
83, my lords. 83 is the invoice that was raised in the month of December 2023.
One moment. That is 3,85,000.
Yes, my lords.
All right. 3,85,000 you have not paid?
December we have paid, my lords.
From
December.
January, why you stopped payment?
Because if you may peruse on page number 85, my lords, this is the invoice that was raised in the month of January.
Hmm.
And it is 5,40,000.
Hmm.
That was the dispute. We didn't, it was about 40% increase
So
in the
if this
rent.
is, this amount is directed, you will pay?
My lord, no, my lord.
3,85,000?
3,85,000. We had calculated based on that itself, my lord.
You deposit 3,85,000 into
lords,
4 or 5 months.
The other reason why we are not ready to pay is because we have a security deposit also. That is
How
of
much
the
is the
plaintiff.
security deposit?
21 lakhs, my lord, which the honorable trial court has failed to
Heard the learned
has
counsel
observed but
appearing
has
for the
failed to
petitioner. The
consider.
petitioner to serve on the counsel representing the respondent plaintiff before the commercial court on or with requisite set of papers on or before the 21st of August list the matter on, what's the next date?
My lord, the matter is listed on 18th.
List
Yes,
them, 1 minute.
but
List the
then-
matter on 29th in preliminary hearing. Further proceedings before the concerned court shall remain state till the next
One
date.
submission, my lord. The matter is on 18th, and we have been required to pay the amount of 30 lakhs. Else our defense will be struck off, my lords.
What have I done now?
Kindly grant an order of stay, my lord.
Granted, madam.
Oh, sorry. Apologies, my lord.
Yes.
Much appreciated.
I thought you're, the way you were arguing after stay was granted, I thought I should not have granted stay.
Obliged, my
Yes.
Preliminary hearing 9.
My lords, yesterday my lords had asked about the suits, my lord.
Ah.
I have a.
Will I will give. That's,
He is not producing
That's
the
a
suit
filing
filed
of-
by him. He had filed a suit for partition in which this property is not there before. And that suit is dismissed for non-prosecution.
But I will submit. With regard to filing of suits by the first respondent son, still the, so 2 suits are pending. That's all the 2 suits have been filed for partition and separate possession. We are the parties in these suits.
This is the matter where after final notification,
Not final, not
After
with
final-
regard to this.
after this court's order,
After this court's order, after
That's
this court's
interim order
order,
was granted, knowledge of this interim order granted by this court, the land acquisition officer dispersed the compensation amount in favor of the first respondent. So far as this property is concerned, it's a joint family property.
which is that partition which was filed earlier?
My lord, let me just
Which
take
is
my
that?
note.
Son
My-
of the
I
first
have filed
respondent.
1 minute, 1 minute, 1 minute. You're first, you ಕೇಳಿದ್ದೆ that. Which is that partition?
But it's kindly the first.
OS
suit,
89 of 2019.
2089/2019, filed by the first respondent son.
ಆಯ್ತು.
We are the parties, we are the defendant.
What
number.
happened to this suit?
But still it is pending. Still it is pending. That's in respect of few properties, the suit came to be filed. That is survey number 30.
1 minute. The suit schedule properties in this 2019 suit
Yes,
is the same that is now acquired?
no, that's the different properties.
Yes.
Insofar as, once again, he has filed another suit.
No. Now, first suit is over now.
Not
So these
filed
are
by
not the
first
property.
respondent son, that's contention is,
2019 suit, ali suit schedule properties are not the same that are acquired. Admitted fact.
these properties have also been acquired.
ಇಲ್ಲ ಅಂತ ಈಗ ಅಂದ್ರೆ
Allala, properties, the subject matter of the properties, one survey number to the extent of 4 acres, 20 guntas.
ಅದಕ್ಕೆ ನನ್ನ synopsis ತಗೊಂಡ್ರೆ ನನ್ನ synopsis ತಗೊಂಡ್ಬಿಡಿ ಸ್ವಾಮಿ.
page
2 minutes.
36 ಅಲ್ಲಿ suit schedule properties ಇದೆ.
Yes,
In that suit schedule properties, which are the ones that are now subject matter of acquisition?
that's all the properties.
All the properties.
All the properties. They have received half of the compensation. We have received the half of the compensation. That's in respect of survey number 65/2, 65/3. All the properties have been acquired.
My lords, that is.
Then, no, one second.
ಆಯ್ತು, 1 ನಿಮಿಷ ಅಜಯ್. I'll get
Then
back.
the next suit filed by the very same person. 12 of 2017. That's in that suit,
What happened to, both suits are pending?
still pending.
Partition.
Partition. Let's in this suit, we are the defendant number, that's the 5 to 7.
All right, yes, Ajay.
12/2000.
1 ನಿಮಿಷ.
My lords, may just take my synopsis. 2 ನಿಮಿಷದಲ್ಲಿ I'll explain.
ಯಾವ synopsis?
2 page note ಈಗ ಹಾಕಿನಿ.
Yes.
My lords will see there are 2 properties which have been acquired.
Survey number 1 and
Survey
65.
Survey number 1 is the suit schedule property in this particular writ petition. Survey number 65, my lords, was granted to our grandfather. That is mine and the petitioner's grandfather. We are first cousins. We are first cousins. Our grandfathers are grandfather granted. Now, my lords, 65 stood mutated to 65/1, which is standing in the name of father of respondent number 1. 65/2, which is standing in the name of petitioner. 65/3, which is standing in the name of petitioner's sister. Now, my lords, first suit which my friend is referring to, OS 12 of 2017, it is filed by my son, in which survey number 65/1 of the acquired land is there, which is the land which is standing in my name. His land is not there, nor is the present suit property land. My own son has filed a suit. In that suit, it's not there. In which, my lords, he is not a party. Then, my lords, there is one more suit which was filed, OS 5/25/2017, which was between the petitioner and petitioner's sister.
Compensation amount deposit ಮಾಡ್ಲಿ ಬಿಡಿ.
One ನಿಮಿಷ, I'll just explain. My lords, now what has happened is that 65/1 ನಲ್ಲಿ there was an interim order. Both of us have filed affidavit before the SLAO and taken the compensation in respect of 65/1.
ಇದರಲ್ಲೂ ಅದೇ ತರ ಮಾಡಿ.
My lords, the thing is this: we have each taken our respective shares. My lords, just one minute, my lord.
Yes.
My lords, none of the suits relate to this particular. Most important thing I want to point out: he had already filed a suit for partition. He had filed a suit for partition, which is 777 of 2020. In that, my lords, he's saying against me, in which this property suit was not part. It was not a part. Now that suit is dismissed for
Now,
non-prosecution.
1 minute. In pending suits,
Yes.
any of the pending suits between the parties, this suit schedule property which is now subject matter of acquisition is a suit schedule property or not?
Why, my lords, reason is why we have not included that property, my lords, because of that reason, that question would arise, my lords. Recently, my lords, 2020-23, my lords, the revenue records have been affected. That's the subject to the order of the Assistant Commissioner, revenue records have been affected.
You told me
Immediately, the first respondent, without the knowledge of other family members, he has started, my lords, trying to receive the compensation. Immediately, my lords, the suit came to be filed. Let's we have stated in the suit, because there are so many litigations are pending between the family members. Because of the document stands in the name of the first respondent, my lords, entire compensation amount, whether he is entitled or not, my lords, immediately suit came to be filed and sought for the interim order.
Yes, we'll decide this.
My lords,
ನಾಳೆ ನಾಡಿದ್ದು release ಮಾಡಬೇಡಿ ಏನು.
my lords, the difficulty is, my lords, I'll tell my lord, my lord, that is the problem.
Actually,
I am today in contempt.
Let's
I am-
19.
I am-
let's
one
19,
minute, sir. 1 minute. My lords,
19th, let's
Really, sir.
please.
my lords, my lords, I'm in contempt. What has happened, my lords, is that in this writ petition which was served.
Contempt ಹಾಕಿ, oh, correct, contempt
That's
ಇದೆಯಲ್ಲ.
contempt.
Yes,
19th,
my lords,
my lord,
what-
after
that
19th,
is-
any
that is-
date may be given.
My lords,
After
my lords,
19th.
19th I'll go to jail.
My lords,
19th I will go to jail
my lords,
because I'm in contempt. I'll go to jail.
No,
Then,
no,
my
no,
lords,
no,
my friend will.
not, that is not, let's 19th date has been given, let's the contempt. Let's after 19th, any date may be given. Let's.
Very good. Yes.
Actually,
Compensation ಬರುತ್ತೋ ಇಲ್ವೋ ಕಂಟೆಂಪ್ಟ್ ಅಂತೂ ಆಗ್ಬೇಕು.
ಅಲ್ಲೇನಾಗಿದೆ ಅಂದ್ರೆ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇದ್ರು ಕೂಡ let's we have brought to the notice of the special land acquisition officer.
List on 18th at 4 PM. Monday.
It's after
We'll
19th.
pass.
Lords.
No, sir.
20th, let's
No,
kindly have it
no.
on 20th. Lords.
You undertake that you will take adjournment there.
We will not take adjournment.
Then I will not grant adjournment. Yes.
20th at least.
No,
Lords.
no.
20th.
18th.
Yes, affidavit is.
ಏನು ಕೊಡಿ ಅದೇನಿದೆ ಕೊಡಿ.
My lords, there was an interim order in respect of his property. He has filed an affidavit and taken. There was an interim order in the suit filed by my son in respect of his property in which he has taken
That's
compensation.
actually what has happened. 65/1 standing in their name, 65/2 standing in our name.
Now what will
First they
happen?
have taken the
No,
compensation.
now what will happen is on 17th both of you will sit and settle the issue.
But always we are ready, lords.
That is why 18th at
Last
4
even
PM.
lords for the last 3 days, we are requested the other side. It's a family dispute. Parties are.
ಆಯ್ತು, ನಿಮಗೆ ಬಿಟ್ಟಿದ್ದು. 18th I will pass orders.
Suits are pending.
18th I will pass orders. Your contempt will become infructuous.
Not that, lords, because already, lords, with 19th, lords, the date has been given in the
No
contempt.
18th,
Please.
4 PM. Only for passing orders, no arguments.
So I have to explain with regard to other
No explanation,
properties
sir.
are concerned.
No,
Why
no.
this property, lords, we have not included.
I will
why-
only tweak the interim order.
Let's few sentences, let's few points, let's have to address arguments. Insofar as the grant is concerned, they have to explain it is an individual grant. We have to let's explain it on behalf of the joint family. He is the elder person in the family. The land has been granted in his favor. All of a sudden when documents are stands in his name, entire compensation almost.
ಆಯ್ತು, ನೆನ್ನೆ ಅದೇ ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ದೀರಾ.
Correct.
ಇನ್ನೆಷ್ಟು ಹೇಳ್ತೀರಾ ಅದು?
ಅಲ್ಲ ಇಲ್ಲೇನಂತಂದ್ರೆ from 1986 in case if the property stands in his name or this property is exclusive possession, there was a partition among the two brothers, then I have absolutely no right in respect of this property is concerned. Still, one of the son of this first respondent filed
ಈಗ ಎಷ್ಟು ಕೋಟಿ ಬಂದಿದೆ ಕಾಂಪನ್ಸೇಷನ್?
4,67 lakhs.
67 lakhs ಅಷ್ಟೇ.
ಅಲ್ಲ 4,67 lakhs.
467. All right.
My lords,
Monday.
only one aspect, my lords.
Monday.
Sorry. No
Adjournment
arguments on
ಆದ್ಮೇಲೆ
Monday.
argument.
No arguments on Monday.
Yes.
There was a common grant to 3 people who are none of us are family members of
All
this
right,
person.
all right. Yes.
ಅದರಲ್ಲಿ one of the grantee 10 years it ಸಾಗುವಳಿ ಚೀಟಿ ಕೊಟ್ಟಿದೆ. 10 years. That person is aged about 10 years. The land has been granted. That to first respondent sister son.
You were in the same family till now. Why you did not raise a
But we are
ಈ compensation ಅಲ್ವಾ, ಅದಕ್ಕೆ you want all the.
We are all in joint position. ಬಂದ್ರೆ ಅವ್ರಿಗೆ ಬಂದ್ರೆ ಎಲ್ಲರಿಗೂ ಬರುತ್ತೆ ಅಂತ. But ಎಲ್ಲ
Yes, yes, all right.
documents ಇದ್ದಿದ್ರಿಂದ.
Rest your case. Yes.
Number 10.
Appear for the petitioner, my lord.
Gave it a respond number 4, my lordship.
The order passed in MA has been called in question.
ಇದೇನಿದು? Mandate ಕೊಟ್ರದ?
And it was given by Kotal foreman. Last time Kotal foreman.
List on 2nd September. Yes, next.
11.
ಅಲ್ಲೋಗಿ ಡೇಟ್ ಎಲ್ಲ ಹಾಕೊಂಬಂದು ನಾನು ತಗೊಳಲ್ಲ. ಎಸ್.
Total 4 ಬಂದಿತ್ತು. Total 4 has given.
ಆಯ್ತು. 11.
My lord, I pay for the issue.
Special order.
Yeah, my lord, his lordship Justice Shyam Prasad was disabled in this matter.
Yes.
It's a very short issue, my lord. 2012, scrutiny notices are issued to us by the ROC.
Oh, company. Yes. Then scrutiny notice and the tax act.
Scrutiny notices
Yes,
are
yes.
issued with respect to certain entries in the balance sheet. We respond to it. Nothing happens. 2024, after I file an application to transfer my registered office, I get a compounding notice.
Compounding notice.
Compounding notice to compound those offences which are supposed to have been committed in 2012, which may not have ended. 2000, then and they say they therefore will not transfer my registered office from Bangalore to Haryana. I'm sorry, to Gurgaon. Therefore, my lord, I come before this honorable court. This honorable court stays my lord immediately those compounding notices and then also directs them to consider my application for transfer of registered office without reference to it. The issue is only this much. After 12 years, my lord, I'm being told that I have to compound an offence. The offence is punishable with imprisonment of 6 months and fine, which anyway is barred by limitation in terms of, my lord, the
468.
468 Criminal Procedure Code. Then of course, that's all. I don't know, have anything else to say in this case. All these offences, we filed written submissions, all of that. In this case.
It had come before me earlier.
Not before your lordship, my lord, but it's come once. It's come once, I think, before my lord.
Oh, only for extension of entry.
Extension of entry.
Yes, sir. Ashtana?
Lord, please look at the prayer. To set aside the compounding notice at annexure A. Lord, I'm having WP 19080.
It's same. What happened, Lord, is I filed one writ petition, intermod was granted. After that, they sent a second compounding notice.
Okay, anyway, is your lordship having 19080?
Both the same compounding notice.
Prayer heli.
Okay, my lord, the prayer is to set aside or quash the compounding notice at annexure A. Now, please have a look at the notice at annexure A, page 41. It says, para 2, whereas provisions of section 211(1) and 2 of the Companies Act stipulates, so and so, that every balance sheet should give reference. So, number para 3, whereas during the course of inquiry under section 2064 of the Act, in respect of the financial statement as on 31/3/2011, it is noticed that the managerial remuneration has increased by 34,14,704 when the company is incurring losses for the past 2 years and the managerial remuneration as per schedule so and so is nil, whereas under note so and so relating to director remuneration and other information, the total remuneration paid to directors excluding sitting fees is rupees so and so. The company has replied that the managerial remuneration of so and so has been included in the employee remuneration benefit figure of so and so. We have inadvertently missed to show the amount separately under the head managerial remuneration. The company has admitted the omission.
When did you inadvertently miss it?
No, not me.
Yourda reply.
Reply. I have extracted their reply. As again, please have a look at.
When did they submit that reply? Now?
No,
Then it was submitted then.
Then andre yavaga?
2011.
2011. What is this notice now in 2024?
2024 notice, may read para 5. Now, therefore, an opportunity is being given to the company and officers in default to file compounding applications within 7 days from the date of this notice. Attention is invited to section 441 of the Act, which provides for compounding of the offence by the competent authority, failing which prosecution will be launched. The notice may be served to all directors also. So 7 days time was given. The petitioner had choice of either compounding by paying 10,000, 10,000 rupees by paying the compounding fee, or to just leave it at that. The petitioner has not caused any reply. So therefore, this compounding notice has spent itself. So therefore, there is no occasion to quash this, is my respectful submission.
6 months, sorry, compounding notice reply kottilla anta it has spent itself. No,
reply kotru.
ರಿಪ್ಲೈ ಕೊಟ್ಟರು ಆಮೇಲೆ ಏನ್ ಮಾಡ್ಲಿಲ್ಲ ಅಂತ ಕಾಂಪೌಂಡ್ ಮಾಡ್ಕೊಂಡಿಲ್ಲ ಅಂತ It has spent itself.
Yes, it has spent.
2011 ಇಂದ ನೀವೇನ್ ಮಾಡಿದ್ರಿ ಹೇಳಿ? 6 ತಿಂಗಳಿಗೆ you are saying it is spent itself. For 14 years, what did you do?
True. Between
Nothing.
Between 2011 to 2024.
24, what did you do,
About
sir?
13 years, my lord, there's some, they sent it to the wrong. No, but then, no, the ground on which it is challenged is that the compounding did not arise.
No, sir, that's not the way central government should function. 13 ವರ್ಷ ಸುಮ್ಮನೆ ಇರದೆ.
No, what is challenged is
No,
only.
you are now saying we
question
want to
is-
give you an opportunity for compounding of a notice that was issued in 2011 by issuing this in 2024.
No, they have not compounded. Should it not end there? They, Lord,
Should have ended there only.
No, I have.
Or you should have woken up then only.
I have given 7 days time for compounding. Since they have not
What is
compounded.
the offense, sir?
The offense is non-declaration of the managerial remuneration.
Correct. How do you register a complaint of non-doing so?
No,
Before
now
the-
if there is no compounding, then my lord, we have to decide whether or not to initiate prosecution.
Correct.
And that stage we are not reached.
Now you.
No, that stage we are not
That
reached.
stage is not yet reached,
Yes.
true. But the of compounding is like the offense is 6 months.
No, but it is compoundable before the competent court. Before the competent, in fact, 441 begins with a non-obstante clause. It says notwithstanding.
No,
So there is no
notwithstanding-
limitation for it.
Not.
No, but then,
ಹಾಗಾದ್ರೆ 25 years ಬಿಟ್ಟು ಮಾಡಬಹುದು.
Agala, that if not may
I am
submit
required
this.
in law to
No, may
maintain
submit,
documents only for 8
Lordship
years.
asked me, it's my turn. Please wait. The compounding we have not
Yes, yes, sir.
initiated.
Wait. I'll wait, Lord. If my friend Arvind tells me to keep quiet also, I'll keep quiet, no problem.
We have not initiated the prosecution. Assuming that we decide to initiate prosecution, then we have to present an application before the competent magistrate. The competent magistrate has got the power to condone the delay if a case is made out. Lord, can we prejudge those issues is my respect submission.
The very fact that you have kept quiet since 2011 after issuing a notice and did not take it
No, but
forward
then-
for 14 long
No, the
years.
question is this notice has spent itself. Within 7 days.
Your notice then also has spent itself.
No, fine, then where is the question of challenge?
No, because you have initiated now this one.
That means there's an
No,
existence
I have
of an
not yet
offense.
initiated
The
prosecution.
issue, my lord, is
No,
not that. Issue is existence of an offense.
No,
then.
in fact, long back I saw a movie, I think Tom Cruise, one of the actors there, a futuristic movie where even before the crime is committed, the police go and prosecute him because they had the technology then to know that he has committed the crime. So this guy, we have not yet reached that stage. It is not known whether.
See, what he said was 468 will not become applicable here. At best,
Why?
delay may become applicable. But 468 bar will not operate because complaint is yet to get registered.
Let me take your lordship through 460.
It is not the date of cognizance, but date of.
No, 441 says
offense.
notwithstanding anything contained in any other
That
law.
does not mean.
No, 468, Lord, is with respect to registration of an offense. That presupposes existence of an offense.
No, please have a look
It's
at.
not yet, it's compounding. still.
If you issue a compounding notice, it
please have a look at
presupposes existence of an offense.
441 of the Companies Act says compounding of certain
No,
offences.
notwithstanding anything, that
Yes,
I am aware.
notwithstanding
it's all
anything.
right. ಅಲ್ಲ ಹಂಗಂತ
Therefore,
if that is left 25 years afterwards he'll issue a notice for
So
compounding.
should not the magistrate, if I decide to initiate prosecution? Lord,
Sir,
it should,
delay defeats justice both and equity
no,
both.
in which proceeding should the delay be considered?
No, in the
Delay-
folly of the respondent in keeping quiet for 13 long
No,
years.
delay in what, my lord? Delay in
No,
what?
delay in now compounding notice is issued.
Yes,
All right. They did not come forward to compounding.
yes.
You should have initiated proceeding
Oh,
immediately.
fine, my lord, then, my lord, this is an argument which the petitioner has to raise before the appropriate court. Now, my lord, my respectful submission is, where is the occasion to quash a notice which has spent itself? Not, why would your lordship
Notice
even
has not,
consider quashing?
why would notice spend itself? There was,
Because
then, if the same,
because the petitioner has decided not to
if the same
compound.
analogy is taken, there was no occasion for you to wake up after 13 years and tag the notice that was issued in the year 2011. That had already spent itself.
No, no, I'm just trying to understand. I mean, would
No,
your-
there is no limitation, I
Is your
understand.
lordship considering quashing the compounding notice alone as it is?
Everything
Without making any observation on whether or not I can proceed to prosecute or not?
No, that I will not go into at all. This is because,
Then there is no difficulty, madam.
see, 2011 in the 2024 orage, You should have completed that notice, taken to the notice to a logical conclusion
If you are,
then.
if you are,
That is all.
if your lordships are not going to make any observation on.
No observation on what? Why are you surprised?
I'm surprised with the submission. The central government is making saying, don't make any observation on the fact as to whether I can initiate prosecution on the basis of the compounding
No,
notice.
the compounding notice itself will go. Where is the question of prosecution?
Correct.
No, but my right to initiate prosecution will be notwithstanding this compounding.
No, that is independent of the compounding. If you have a right, you can do it.
Yes, my lord. Yes, which is why I'm saying, if your lordships are not making any
Now
observation.
I will quash the compounding notice.
Very well.
And consider my shifting application. Shifting application has been considered in 15 days. It's 2 years now, my lord. They're not considered, despite an interim order granted by your lordships. They've just refused to consider. The whole idea was I wanted to shift. They did not want to, for various reasons, my lord, pass an order. When I insisted, then, my lord, 2 notices come. Compounding, what? There's nothing else. So they go back to 2011, find something, and then say, I'll now not allow your application for shifting. And on that basis, my application shifting is left like that for 2 years. I'm not. I thought the AG would come and say, I'll at least consider the application for shifting. In his usual fairness, my lord. But I don't know why he's not so in this case.
No. That's, see, ultimately he came down to that fairness. That can't go out of him.
Yes, of course, I know. That's why
Yes.
I'm confident if I appear against him, Lord, I'll at least have some fairness from the central government.
Yes, Kamath sir will answer the notice, but not prosecution. I cannot to forestall prosecution, and if there is
Even
challenge
there,
it.
my lord, I have a very uphill task there. I mean, what is preventing me here will prevent me there. I mean,
actually,
that's a different thing. That is for him to
on the
agitate.
principle that I'm saying.
Prosecution,
for the
I'm not
time
going, because I'm not going to pronounce upon prosecution here, because it's not the issue here.
Yes,
It is with regard to notice of compounding not being taken to its logical conclusion.
Yes.
That's all. Our ground dash. Prosecution, how will I?
I have a second prayer, my lord, to consider my shifting application.
Yes, AG sir.
Lord,
Shifting
that-
application ideyantala.
Howದು ಅದನ್ನ that was kept pending because this issue was unresolved. Whether there is compounding, whether there has to be some prosecution or not.
Even
No, we will take a, after this notice is passed, we'll take a decision whether we are initiating prosecution or we are
No,
just
I'm
dropping.
cannot direct. I will only say consider. That's all.
Not to transfer. Direct them to consider within a time-bound manner.
Yes,
The law
yes,
requires
sir,
15 days.
transfer application.
Yes,
Law requires 15
lordship
days.
made in a time, 4 weeks time, Lord, may be given to consider.
Ashte.
Great.
Or he is appearing for the government. He has to make his point.
No, of course, I don't dispute it, Lord, but
No problem.
Very well.
Then I will not pronounce upon prosecution at all.
I'm grateful.
Monday I will pass.
I'm grateful.
Yes.
both matters.
Both
two matters.
already, yeah.
Yes.
Both matters.
Both
Yes.
are identical matters. Great.
But you should ask your officers not to sit quiet like this for 13 years.
I've had a discussion on
Not
this.
correct
Lord.
at all.
Yes. Whatever be the
If
reason,
only in 30, ಅವಾಗ್ಲೇ ಮಾಡಿದ್ರೆ ಇದಕ್ಕೆ ಇದೇ ಬರ್ತಾ ಇರ್ಲಿಲ್ಲ. To get over that, ಈಗ notice issue ಮಾಡೋದು ಸರಿ.
No, in fact, this matter has been going on for about a year and a half. I mean, between my office and the
correspondence. No, you should.
I've been trying to push an early closure on this.
Yes. Wherever there is delay like this, it should. Yes.
I'm grateful.
Monday will pass the order.
There are some citations, bro. May I just leave it with your lordships? They cover each of these specific provisions.
But I'm not going to pass anything on prosecution.
I understand. Yes. So far as even compounding is
As the AG said, nothing on prosecution. Yes, sir.
Would your lordship be continuing with the list? Item 33, there is this or third matter.
Yes. AG, where is the AG? Error?
VC.
He's on VC. All right. Just give me, I'll take it at 4:45.
Very well. Very
Sharp 4:45.
In this serial number 11 interim order.
That'll it.
Well,
Where's that? Nagaran sir's matter was there yesterday's.
35.
Nimde yavdu? Next matter is it?
12, my lord.
1 minute. Oh, yesterday's problem.
Sure.
What's the issue?
My lords, I appear for the petitioner. My lords, the petitioner was formerly employed by the respondent. There was arrears of salary that was due to him. I filed a summary suit before the trial court on 30/8/2024. On 15/1/2025, my lords, here the defendant was served as per Form 4 Appendix B, summons for summary suit, and he was placed ex parte. Thereafter, I lead my evidence, and on 11/3/2025, the defendant appears. He files application under Order 9 Rule 7 to set aside the ex parte decree, and under Order 8 Rule 1 permission to file written statement, my lords, which comes to be allowed. As per Order 37 Rule 3, my lords, in a summary suit, the defendant has to first file application for leave to defense, and the court has to undertake the exercise to ascertain whether there is valid defense made out
on the respondent.
Sorry, my lords.
Serve on the respondent.
Surely, my
The petitioner to serve on the counsel represent. What's the next date there?
16th, my lords.
Petitioner to serve on the counsel representing the respondent in the trial proceedings and file an acknowledgement by the 19th. List the matter on 22nd. Further proceedings before the concerned court shall remain state. 22nd, 25th. Yes. Oh, sorry. 29th. Yes. Now take that matter. ಮುಗಿಸ್ಬಿಡೋಣ 2:30 ಮೂಡಿದೆಯಾ ಮುಗಿಸ್ಬಿಡೋಣ 2 ಮುಗಿಸ್ಬಿಡಿ
13 adjourn 14.
Deletion order has been passed, my lord. I'm challenging the order of deletion. Lord, suit has been filed.
Deletion of what?
Deletion of the party, my lord. 1 rule 10(2). 1 rule.
Oh, 1 rule 2. Yes.
Yes, my lord.
Who are you?
I am for the plaintiff, my lord. I sought for a declaration, my lord.
No, who is now deleted?
The deletion has been effected, my lord, with respect of different number 2 to 5, my lord.
Oh, this is that
Yes, my lord.
employees.
Yes.
He is undertaking, he will give everything.
But I have sought for the relief of declaration, my lord. It is not just restricted to the damages. And my submission is that, my lord, whenever a mala fide is alleged and the officers against whom the allegation has been made, even if he is a minister, he should be implicated in the proceedings.
Where is
And
minister?
in this particular case, my lord, I have sought declaration. It is under section 34 of the specific relief act. Then, my lord, the third prayer is as against this particular defendants also, jointly and severally. When a specific prayer has been sought for, then, my lord, they are proper and necessary party. They are not only proper, they are necessary party.
Lordship, may kindly see the
Prayer itself has not been taken into consideration. Now, my lord, those defendants who have been deleted, they have not filed the statement of objection. And the defendant number 1, he has filed the statement of objection.
That is Infosys.
Yes, my lord. Saying that we will, whatever the order is passed, we will implement. That is not the question. I have sought for the relief of declaration. To decide the relief of declaration, their presence is required.
Declare that every one of them have harassed you.
Yes, my lord. That is what I have sought for. And that is how I have sought for.
So obviously, that's what you will seek for.
Yes, my lord. When I have specifically made allegation in the plaint, whether even if it is at this moment, it may look that I should, if it is observed that this is how I have sought the relief, but still they are proper and necessary party to decide the relief what I have sought for.
Where a praise, sir?
51.
My lord, page number
51.
51, my lord.
You're all retired employees.
R5 is retired. 2 to 4 are in service.
R5 also you want?
My lord, he was there in the service when
In
he
fact,
harassed me. And
harassed
for that
you?
reason,
In fact,
I have sought the relief.
Writ petition says especially R5. Writ petition says especially R5. But I'm saying there was some context. Some meetings were held. I did not get satisfactory answers. He submitted a resignation. Let me assume for a minute that I nudged him to, coerced him to, let me assume for a minute. I consider it as, I'm saying, I've said in affidavit, I consider this an act that 2 to 4 performed in, 2 to 5 performed in course of their employment. Reinstatement, not maintainable, 7 rule 11 is pending. He is a managerial employee. Contract, 3 months notice, I've given him pay, I've given him ex gratia, he has to go. That apart, if he succeeds in this suit, notwithstanding 7 rule 11, etc., reinstatement I have to give. Alternate prayer of arrears of
everything you have to do.
I have to give.
No.
10 lakhs, kindly see, my lords.
No, no,
He
1
wants-
minute, Aditya.
My lords,
Everything you have to give.
yes.
Except satisfaction of his egos.
That
They
not,
will have to.
not justiciable. That is not justiciable. Let him show me one source of law
There.
that says
It's
satisfaction of
not the
ego.
ego, my lord.
Indian.
The reason is that.
Everything
why-
you want
why I
from
have-
Infosys, but you want other employees who have
I have
retired also
arrayed
to
them
come
as a
in.
Party is, my lord, to prove the allegation and to prove the. no,
Iga,
let me-
now,
That, my lord.
1 minute,
Yes,
you resigned and you went away.
Yes, sir.
All right.
Yes,
Now tomorrow resignation is held to be a nullity.
Yes, sir.
You will reinstatement or whatever you seek or damages. Reinstatement, tell you that it's only damages.
Yes, sir.
Damages.
Now to seek that, to decide that particular prayer, my lord, I have arrayed them as a party. If I have arrayed them as a party, I have to, if they have already filed the written statement. When they have filed the written statement, now either they have to step into the box. If they won't step into the box, if they won't step into the box, the allegation what I have made against them remain uncontroverted. In such a situation, my lord, the arraying them as a party is necessary.
You may take
Then
it, my
they
lord.
would become proper and necessary party.
You may take it, my lord. 2 to 4 will
My
not
lord.
step into the box.
My lord, I will refer to few judgment, my lord, with respect of these type of a situation where the declaration relief has been sought under section 34 of the specific relief act. Though the contention is that I am not related, I have not coerced, I have not forced. In such situation, my lord, how the courts have considered, I will explain.
Kodi.
Yes, sir.
Now, where is your prayer? That is what
Yes, my lord. Prayer 51, my lord.
Page 51 is it?
Page number 51. I will just read it, my lord. To declare that the action of compulsory seeking the resignation of the plaintiff, the relief is declaration, my lord, of the plaintiff by the first defendant, basing on the investigation report by one agency, seventh defendant, is bad in law and not binding on the plaintiff. That particular work also has been outsourced.
That is defendant number 1.
That is defendant number 7, my lord.
No.
The investigation which has been conducted by defendant number 7. Then, my lord, this is the declaratory relief, my lord. This declaratory relief.
Allah, defendants 2 to 4.
Yes, my lord.
Are employees.
ಅವ್ರ ಬಗ್ಗೆ ಏನ್ ಹೇಳಿದ್ದೀರಾ?
ಹೇಳಿದ್ದೀನಿ ನಾನು. Plain ಆಗಿ ಹೇಳಿದ್ದೀನಿ. I will just show you, my lords.
Lordships may kindly take my statement.
No,
of
let me
objection.
complete, my lord.
I've extracted.
Wait, Aditya.
Yes.
I've extracted. That's
Yes.
the only reason.
Yes. In para number 3, my lord, I have explained when I have joined the service. Para number 4, my lord, how the investigation started, alleging that there is a whistleblower complaint, my lord. That has been explained. How the inquiry has been conducted, that I have explained. In continuation of para number 4, my lord, each of the allegations have been made against all these defendants, emails, everything I have referred to. Kindly consider, my lord, para number 5, above para number 5, 4 lines, my lord. As per the orders and instruction of his higher ups, that is defendant number 2 to 6.
That is your ground.
Yes.
They have acted on the dictate of defendant number 1, correct?
No, acted on the premise of the defendant number 2 to 6.
Sir, every one of the defendants that you have arrayed as defendants in this suit have acted on the dictate of defendant number 1. And all the relief sought is against defendant number 1, correct? That's the prayer, sir. That's what you have sought.
I have sought the third prayer as against all the defendants. If the relief, the way in which I have sought the relief, jointly and severally, that relief I have sought as against all the defendants.
Prayer number 4, your lordships may see.
Difficult.
I will try to explain, my lord. Kindly take, my lord, then para number 6, my lord.
Again, intermodal ಇಲ್ಲಿ.
There is no intermodal.
Well, here your trial to convince next date.
My lord, the judgment what I am referring to is that.
ಕೊಡಿ
my
ಎಲ್ಲ
lord.
ಕೊಟ್ಬಿಡಿ. Yes.
Kindly take page number 8, my lord.
We'll see.
Yes,
we'll go through it. We'll take it on Wednesday. Wednesday beda. Tax is correct. Take it on Friday, 22nd. Which is the, which date did I adjourn the other matter where you are the petition?
ತಾವು ರಿಸರ್ವ್ ಮಾಡಿದ್ದೀರಿ.
Oh, reserve ಆಯ್ತಾ? ಸರಿ. Oh, that stamp duty penalty. Yes. 22nd, yes.
15.
For the petitioner, my lords, this matter is coming before my lords because earlier occasion.
482.
This is coming before my lords because earlier order was passed by.
Oh, successive rate. Huh?
Yes. My lords, may I just request my
This
lords
is
to see
successive writ or a successful writ then?
successive writ?
Oh, all right, yes.
Yes, it was earlier withdrawn.
Ah.
May I just request my lords to see the POXO Act?
POXO Act.
POXO Act, just some 1 or 2 provisions if if the court officer can kindly give a copy. Section 22, my lords. Yes. My lords can see 1 or 2 provisions if I can just hand over. Kindly see, my lord, section 22.
No, what have you challenged?
My
Judge?
lords, the mother had filed a petition, a complaint under the POXO Act against the respondent father.
Husband?
Yes.
Ah.
For having, for offenses under the POXO Act for touching the private parts of the minor child based on her statement.
Whose statement?
On the child's statement.
Hmm.
Thereafter, this
How old is the child?
my lords, the child has now in August turned 8 years old.
8.
8. When this was last year, this was in fact in 23, when she was about 6 years old. Now, my lords, I just want to make a submission. That petition, that order was,
What happened to the matrimonial disputes
they are
between?
all hanging. Matrimonial disputes are all hanging.
Who has the custody of the child?
Custody I have. There are some visitation orders passed that I should show. Now, my lords, subsequent to my complaint, my lords, can I just show, my lords, for a moment, section 22. After my complaint under POXO was quashed by this honorable court, quashed it. He challenged it. It was quashed.
Which one? Which is that?
My lords, that
order?
is at page 138. May I take, my lords, at page 141, relevant portion?
My order.
No, my lords, that's not my lord's order. That's Justice Chandan Gowda's order, my lord.
140?
141. The basis on which it was quashed, my lords may see para 6, page 141.
What happened to this? Become final?
This was quashed. I have not yet challenged it in the Supreme Court.
Not yet, Chandra?
Yeah, no, my lords, the idea of the mother is not to put the man behind bars by hook or by crook. That is not the idea. The complaint was filed because the minor child made the statement. And in fact, subsequent to this, the court referred her to NIMHANS. NIMHANS has given a report also wherein they've recorded the child has said this. May I point out to the NIMHANS report, which is a June 25 report.
Now what is under challenge?
Now, my lords, what is under challenge is after the POXO petition complaint was quashed, the husband files a section 22 complaint against me for false information. And that is why I want to refer to section 22. 22 is not just a false complaint per se. It has a 2 category requirement.
No, that has become final, the order. Justice Hemant Chandan Gowda's order.
As of now, it is final. As of now, it is there. Now, my lords, may I just refer to section 22 for a moment? 22 says, any person who makes a false complaint or provides false information against any person in respect of an offense committed under sections 3, 5, 7, and 9, solely with the intention to humiliate, extort, threaten, or defame him shall be punished with an imprisonment of 6 months. It is a conditional thing. The allegation is that I should have done it solely to humiliate, defame, threaten, or distort. Now, my lords, after this, kindly see, my lords, the NIMHANS report. NIMHANS report has been issued. Kindly see, my lords, at page 218. This is dated June 2025. It starts at
report
page,
is here. Page?
Sorry. Page 218. The report starts earlier. I'm coming to the relevant extract of the report. 218. This is in June 25. The NIMHANS counselors, they have recorded every session with the child. Session 11, 5/5/25. Kindly see the next page, my lords. Page 219. Page 219, nearly about 15 lines from the top of the page. They state, the exploration continued regarding the nature of discomfort. My lords found that?
Yes, yes.
Page 219. The exploration continued regarding the nature of discomfort, and the child described an incident at the clubhouse where her father picked her up and held her upside down, and she demonstrated it in the session using a doll. She also expressed how her father had touched her on her bottom. Her feelings were acknowledged. Then the rest of the thing. Then, my lord, same day, next page, my lords, page 220. 220, the top of the line, top of the page. The therapist then inquired about the frequency of the event that the child described, and she responded that the incident involved being turned upside down occurred only once, and the bad touch may have happened twice. The therapist gently offered that at times parents may engage in physical or playful interaction with children. The child replied, "I don't know." It was also inquired whether an incident like this had happened at other times, to which the child responded that it had happened only during the 2 clubhouse visitations, where she says it was a bad touch. In fact, this honorable court in the guardianship visitation proceedings also called the child. Kindly see, my lords, at page 172. The child has stated this even to this honorable court. 172, my lords. In fact, it's an order of this honorable court in writ petition proceedings. Page 172, my lords. May I just refer to?
Yes.
Page 172. This is order dated 12/6/24, my lords, in writ proceedings. May I just read para 2 about the 4th or 5th line in para 2. Today, when the court has interacted with the girl, my lords.
I'm there. Tell me.
Today, when the court has interacted with the girl informed the court what has transpired on the day of visitation on 9/6/24. It is also stated by the girl on that day that the father was touching her private parts. My lords, that this is at page 172.
Yes, yes.
Yes. When this court assured that nobody can take her away from the mother, then the girl said that what she had stated about the father touching her private parts is not correct. From the conversation with the girl, it appears that she's living under a constant threat and apprehension that she may have been taken away by her father in the light of the disputes between the mother and father. And then thereafter, a lot of other observations are there. In all those proceedings, the honorable court referred her to NIMHANS. Now, my lords, I have a short submission. The complaint made, the section 22 proceedings is if somebody has made a false complaint solely to defame or humiliate or threaten the person. The complaint made by me is on the basis of what the child has told me. In fact, section 19 and 20 is mandatory reporting of
Now, visitation is stopped or continues?
Visitation, in fact, matter when the NIMHANS report also said she has to be admitted. We challenged the admission because she's only an 8-year-old child to the Supreme Court. Supreme Court stayed it and has said that every Saturday for supervised visitation for 2 hours.
Who should supervise?
Third parties. They have said both sides should have third parties. Supervised visitation in the father's house for 2 hours or 3 hours every Saturday, which is what is going on. And the visitation and issues are now before the Honorable Supreme Court. My lords, the mother cannot be prosecuted like this. When the minor child has stated it 2-3 times, not just to me, to NIMHANS, to this honorable court, and she's a child who, to the best of her capacity, who's undergoing all this, has stated it. Can I be prosecuted for this under a false complaint? Now, my lords, the section 22 proceedings are going on. Section 22 proceedings are going on, and there in this is a vindictive way of ensuring that the mother is now put behind bars.
What did you do earlier?
No, ultimately, my lords, under
Same
section,
thing.
if a daughter,
What goes around has come around.
my lords, if a 6-year-old child tells me that he has touched her private parts,
yes, let's see.
if
Not
the
quashed anyway.
Lord,
that is quashed. But should I be subjected to the section 22 proceedings?
That we'll see.
I have a
That is the
preliminary
only-
objection regarding the maintainability of the writ petition. I think Leonard Senior Counsel has not addressed one issue. A writ petition was filed earlier before your lordship. Challenging the very proceeding which is challenged in this writ petition now.
produced my lord's orders.
Withdrawn. Yes, very same proceeding.
Produce my lord's orders. That
Kindly
is why
see
it's
the
come
order dated
before
3rd
my
of December 2024. My lord, may
No, it is produced.
Lord, I don't have the copy. I'm
No,
not
no,
being
it
served
is
with the
there at
copy of
page
the
143. I have produced it.
page number 24 in the
It is in page
compilation here.
143. It is in page 143. I have
After arguing the matter at length.
I have produced it.
One moment.
It's at page 143. That is why it is before my lords, because it is a successive petition. It was withdrawn.
But page number 35.
Page 144. the
Same 144.
Yes, yes, I have.
Read.
Yes. After arguing the matter at length, learned counsel appearing for the petitioner seeks leave of this court to withdraw the petition and urge all contentions urged in the present petition before the concerned court.
Which was that? Where was it pending then?
No, it was before the special court.
Special court.
Special court.
Lord, trial is concluded, arguments are concluded. Now it's posted for defense
Now,
arguments.
my lords,
They
The
have
Nimhan's
evidence
report is a subsequent one. It is in June 25, 13 June 25.
That will not give them a cause of action. No, my lord, to reinstate an issue
My
has already been
lords,
closed.
in the Nimhan's report, if the child has stated again to a counselor that he has touched her on her bottom, does it show that it is a false complaint?
You will get acquitted.
My
don't
lords,
worry.
my lords, I have in fact made an application to produce that. But my lords, my submission is even the taking of the
Why did you
cognizance.
file it now? The trial is at the concluding stage.
My lords, trial may be at any stage. Of course, if I'm in the hands of my lords, trial, if my lords throughout this petition, of course, I have to go ahead with the trial. My lords, I'm asking the question to myself. Was even cognizance taken without the ingredients of the offense being made out? Ingredients of the offense are twofold.
And that's a different thing.
One is a
This is-
false
one
complaint.
minute.
Yes.
When you filed this petition in 2024,
Yes.
what was under challenge?
My lords, the
Entire
complaint was,
proceedings in special case 628 of
complaint was
2024.
under challenge.
Complaint or what?
The
Charge
proceed,
sheet?
no, there's no charge sheet because this
Yeah,
is.
or 22, not charge.
Okay,
Correct.
there is no charge
The
sheet.
entire proceeding.
Yes, now this was
Entire
withdrawn.
proceeding was under challenge.
This was withdrawn.
Withdrawn then.
Yes.
ಮತ್ತೆ
Now, my
ಎಲ್ಲ
lords, it was withdrawn. Now, my lords, the two observations I showed, my lords, are subsequent. They are subsequent. My lords, kindly see. The Nimhan's report, my lords may see.
Today, latest judgment.
But I have
Second petition not maintainable.
My lords,
all of the
the
compilation
Nimhan's
I have
report-
produced, page number 37.
My lords, the
This is
Nimhan's report.
This is CS
In
You
fact,
produce it there, madam.
my lords,
You will get acquitted.
no, my lords, kindly see even there the order of taking cognizance. The issue of the sole intention is not at all addressed.
That's been challenged in the earlier writ petition. Cognizance also, page number 20. It is submitted to the petitioner being aggrieved by the order taking cognizance in PCR and the proceedings.
My lords,
Cognizance
in
also was
fact,
challenged. But
if a
page
matter
43,
has
para
been
8.
withdrawn, it has been withdrawn. It is
It has
now.
been withdrawn.
The
If there is,
council
if
withdrew
there is a
it,
change in circumstance only.
that is what.
Not you securing a report elsewhere will become change in
I have
circumstance.
not secured it. It is based on the court's direction.
It's all right, maybe that
My
will,
lords,
you
kind-
produce it before the concerned court.
My lords, kindly see for
That
a
report is
moment.
challenged before the Honorable Supreme Court.
kindly
Which report?
see.
That report, Nimhan's report, my learned friend is challenged before the Honorable Supreme Court.
I have not challenged the Nimhan's
Where,
report,
where,
sir.
where is
Kindly
convenient
don't,
to the petitioner,
kindly
my lord,
don't
the
make
report
false
gets challenged.
submissions. My lords may just see
Yes,
the
madam.
Nimhan's, my lords may just see for a moment.
Where
Nimhan's
is the
report.
latest judgment, sir?
Sorry, I have,
Rendered last week.
sorry, my lord, I have the 1987 ES,
Let
Justice
me
ES.
take
Sarguja
it on-
transport.
Then
Yes,
let me
sir.
take it on Monday,
8
my
and
lords.
9.
Even I'll produce those judgments. Let it be taken on Monday.
What is it?
I'm sorry.
The transport
On Monday.
1987
How?
they're producing.
Let it be taken on Monday.
I'm sorry, I'm thinking.
Last week there is a judgment
I will
saying
just check.
second 482 petition. ಇಲ್ಲ ಇದಾರೆ ನೋಡಿ. Yes.
So let it be taken on
Second
Monday.
482
because even
petition
I
is
will-
not maintainable
My lords,
at
I will-
all.
I
Once
will-
you have withdrawn the earlier petition on the same stage.
On the issue of subsequent developments, my lords.
Not
raised that.
development at all. Subsequent development under every stage is a development in crime. That you can't come and do
Lords,
it.
it
No,
is not a
madam.
development as in a development from my side, based on.
That
court
will not give a
direction.
cause of action for a second 482 petition.
My lords, the finding has been recorded by Nimhan's, wherein the
You
child
will
has
get
stated-
acquitted.
My lords,
You produce it
ultimately-
before the court at the
But-
stage of trial. Where is the interference under 482?
Ultimately, the child has stated before
No, madam.
multiple
That-
proceedings.
Let the child state
Let
it
me-
there.
Give me the liberty, my lords, on 18th, I'll submit on the judgment.
Not necessary, madam.
My
Close
lords, let
it.
me submit on those judgments.
No, not necessary.
My lords have raised that issue.
No, I will withdraw that
Ah.
issue. Don't worry. Yes.
No, my
Nothing.
lords, can I just at least show
No,
my lords
madam,
the
that's
Nimhan's
not-
report?
No, there should be some limit of entertainment of petitions. See, I had not seen this order. You have withdrawn it.
No, I have therefore.
Withdrawn it at the
therefore,
same stage. It was not at the complaint stage or whatever. Entire proceedings are called in question.
The proceedings were called in question. Thereafter, it was withdrawn.
Yes.
And my lords, the Nimhan's report, just my only
Demands
submission-
report, you produce it before the court where the trial is at the fag end. You close it, you will get acquitted. No
the
question of
response
482, madam.
Then, my lords, I ask myself one question. The cognizance taken, for a moment, if my lords can see the order.
That is also merged in the earlier order, madam.
Ultimately, the cognizance taken does not take that into account at all.
No, madam. That's not.
And my lords, even
No,
a
you
successive-
produce it. We'll see, there are many avenues of production of documents. You produce it. I am not going to pronounce one word on merits, saying that it is not, second petition is not maintainable. That's all.
My lords, may I take the liberty of having this matter on Monday? The judgments, my lords, may keep it at 4 o'clock or 4:30,
Hmm.
to that extent. My lords may keep it at 4 o'clock.
No,
I'll
whatever,
produce the
whatever
judgments.
no, whatever, you may produce
won't
all
re-
judgments
I
saying
won't I
second
won't argue
petition,
the matter.
second petition is maintainable.
No, I
But
won't
the
argue
latest,
the matter.
latest judgment, you don't do homework?
I'll submit it and
Ah.
I leave it to my lords. There'll be no further arguments. My lords may
Yes.
take it on Monday.
Monday, 4:45.
Grateful.
Tuesday, 4:40.
Grateful. Yes, yes.
Give a
we'll hand
copy,
over the
yes.
copy. We'll hand over the copy.
Learned counsel Arun Govindraj undertakes to enter appearance for the respondent, registered to print the name of so and so as appearing for the respondent. List the matter on Tuesday at 4:30 PM.
Grateful.
Yes. I told you that. Nagaran sir, one moment. I'll finish this and get back.
My lords, 32 is the rare disease matter. In case my lords are not.
There it is again on Tuesday we'll take. Yes. 30. ನಿಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗೋಗಿದೆ. The ASGS
I have very, I'll take a couple of minutes. Lord,
you also in fact submitted at length.
Yeah, I will just-
Constitutional,
I will,
constitutional body.
I'm filing my synopsis also. I'll take a couple of minutes.
Yes.
The National Commission for Backward Classes was a statutory body with the only power of suggesting who should be added in the list. That was it.
Now on a higher pedestal.
Now, then, my lord, later it has been elevated to a constitutional status. Now the commission has got the power to investigate into complaints by any person belonging to the backward class of any benefit of which he is deprived of. This is the law. On facts, my lord, the petitioner had got some coal block allocations and was carrying on some mining activities. So some people belonging to the backward classes had two types of grievances. Number one, some contractors belonging to the backward classes have provided some services. Their bills were pending. So for a long time, so they said we are not getting benefits. And some people who had lost their lands, in respect for their rehabilitation, there was an agreement which the petitioner company entered into with the government of Maharashtra, and certain amounts were due and payable to them. It had not been paid. So these complaints came to the office of the commission. The commission called for a meeting, and all stakeholders, namely the divisional commissioner, the collector, and the petitioner company were called. On 3 dates, meetings were held. And in those meetings, certain decisions were made that certain amount were paid. By the impugned commission, all that the commission did was, now my lord, the petitioners are not aggrieved by the holding of the meeting. That is not under challenge. So which means they concede that the commission had the power to call for and conduct the meeting. No, the impugned communication merely says.
Does have power to inquire into all
Yes,
this.
yes.
We can't, take away the tooth of the commission saying
No,
you
no.
have no jurisdiction at all.
Yes, yes, yes.
You have jurisdiction.
Yeah.
Under what circumstances you
True.
can?
So all in the impugned communication, what was done was, it said in the meetings you had agreed to release certain amount. Please pay it within 10 days is what was said.
Who had agreed? Petitioners.
Petitioners.
Correct.
In the all that the communication says is that what was agreed in the meeting, you please adhere to it and comply with it. That is all that is said. Now, my lord, one of the grievances was that the amount was not due and payable. My respectful submission, if it, your lordship may read it down, that any amount which has been directed in the communication to be paid shall be paid only subject to the terms and conditions in the agreement. I am not imposing myself as the commission. If it is not due and payable as per the terms of the agreement, or they say if it is due at a later stage, they may say that it will be paid at a later date. This is all that I'm not. So all that I'm saying is that there cannot be any question of questioning my jurisdiction as a commission. And the petitioners have participated in the meeting, and they have accepted that I have the right to conduct the meeting. I have merely said what was agreed in the meeting, you please comply with it. This is all that I have. But I'm filing one synopsis.
It's like saying the police station suit for recovery, they'll decide the matter.
No,
Your lordship may kindly see him.
You can't equate a constitutional body with a police station.
That is what they're doing, my lord. What they say, ultimately
No,
what they.
we'll answer whether jurisdiction is there or not.
No,
But the illustration you gave,
No,
police station cannot be equated to a
What my
constitutional
learned friend
body.
is saying is contractor's bill is pending. We don't know whether the contract, it's a backward class commission under the 338B, my lord.
Exactly.
So the question is, if a contractor's bill is pending, they can't call me to clear the contractor's bill, my lord.
No, why not? If somebody raises a
the point is, there is an agreement. Nobody has complained as on today. I've produced material to satisfy your lordship. We have cleared everybody, including the workers. And there's under the act, there is a system inbuilt for making payments. There's not even 1 rupee due from us, my lords. And your lordship may mandate directors without anything to adhere to the agreement strictly. We are not shying away from that.
That is all that we are saying.
the question that we are doing what we are required to do. Question is calling us to Delhi and making us meet, making us wait. The chief secretary.
We are aggrieved by that, making you wait.
No, not that. Malaj, only for recovering of
the actual means.
No, that's not the point, Malaj. If they are,
Yes, sir. 5 ಗಂಟೆ ಆಯ್ತು ಸ್ವಲ್ಪ.
I leave it at that. I leave it at that.
ಅಲ್ಲ ಅದಕ್ಕಲ್ಲ, break the monotony ಅಷ್ಟೇ, ಸೀರಿಯಸ್ ಎಲ್ಲ ಮಾಡ್ಬೇಕು ಅಂತಿಲ್ಲ. Yes.
So the question is that
Law will be considered seriously, don't worry about it.
in fact, your lordship have dealt this in under 338A regarding scheduled caste and scheduled tribe
Right.
commission. It's already covered by your lordship judgment.
Service matters cannot be
Sir,
entertained.
this is recovery cannot be done. That's the
Delhi
difference.
Sidling Swami, that
Yes,
judgment ಕೊಡಿ.
Yeah, we've given the compilation.
All right, yes.
In fact, your lordship.
ಅದೇ 2020.
Please.
Yes. MS Bhagwat had appeared in that.
Please. Give to the other side.
Same, I've considered everything. Where service matters cannot be
Para
entertained by
15,
them.
16, 16 and para 10 is a question of law, my lord.
See Sidling Swami, 2020.
Your lordship, so that's what your lordship's memory is.
Yes.
Para 10, 15, 16 and 17, 10 is a question of law. my
I'm aware what I've written. No
Please.
problem. Yes.
Extremely grateful for the
Yes,
time.
no, reserved. Yes, Nagaran sir.
I was just thinking, Lord, the pressure in which the honorable court is working nowadays, Lord, there's something which we fathom is difficult, Lord.
Can't help, sir.
No, I see, Lord. Only thing is, Lord, what I'm saying, in this case, the case has gone to end of September now.
This one.
Yes, Lord, that is the execution proceedings, Lord, which was troubling my learned friends and me both. So today, I'm ready to argue, Lord. I'm not seeking time. I'm just saying, Lord, if your lordship would like to fix a date, then we could give us half an hour or so, Lord. I will argue.
Even now I am ready, no problem.
I can argue, Lord. But is it necessary to do it today? Your lordship decide.
if
It is to be done, I'll do it, Lord. I have no difficulty.
No, if it is impending urgency, that's tomorrow, Monday or Tuesday matter then.
No, not, sir. Notwithstanding the fact that there would be urgency always from the client side, having regard to the, I share my learned friend's concern. Lordships have had a long day. Lord.
No, don't worry about that.
No, no.
If there is
They had a long
urgency,
day.
please tell me.
In
no.
that case, Monday Lordships may have it. But it's all right.
Monday 500.
ಹಾಗಿದ್ರೆ, Lord, I will then let's feel. Let him.
I know, my lord, every day is the same or worse. But
No,
in
if
that
my learned friend
So
can
Monday is,
concise and
every day may be different. Monday is impossible.
we are
Because
ready.
Monday to the minimum 400 will be there. A lot of pressure on the court.
No, your lordship, see the board and give us a date. As I said, my lord,
ನಿಮ್ಗೆ ಕೊಟ್ಬಿಡ್ತೀನಿ ತಗೊಳ್ಳಿ ಬೋರ್ಡ್. Every day 150 ಮ್ಯಾಟ್ರ್.
ನಮ್ಗೆ ಅದ್ ನೋಡಕ್ಕೆ ಆಗಲ್ಲ.
Every day 127, 111, 120, 142.
In fact, my lord, in another matter where clients from public sector company are waiting somewhere at the end of the list.
ಇವತ್ತಾ?
Ivattide. I was telling you some tender matter, there also no urgency is there.
No, it's in the list, is it?
Yes, my lord, it's on
Which
the list
one?
today. But I was,
Which one is that?
list 2, serial 33. I'm not saying there's urgency, my lord. They were aghast.
No, if it's a tender matter, definitely. How is it before me?
ಅದು ತಾವು further hearing ಅಂತ ಮಾಡಿದ್ರೆ it was actually not heard. But interim order, my lord, was
Then
sought.
we'll send it to the regular court.
bench ಅಷ್ಟೇನೆ.
I don't know about this. Why is it further hearing ಅಂತ ಮಾಡಿದೆ ಮೇಡಮ್ ಕೊಡಿ. The problem is sometimes councils insist and I take it and it's burdened now on me.
As it is, your lordships are overburdened.
No, that we'll see if
ಅದರಲ್ಲಿ they sought some interim order, my lord. The honorable court was not inclined to grant. They said subject to result ಅಂತ adjourn ಆಗಿದೆ ಅಷ್ಟೇ. Work is going on. I pay for the respondent.
Oh, well, who appears for the petitioner? ನೀವು respondent ಈಗ?
Now respondent.
Abhilash was here. If he comes, I'll release it from part head.
Please.
Because I don't know about this at all.
It
Why
was
I've
not
made
heard, my lord, only that the interim order, your lordship said that let the contract go on subject to.
Release the matter from the,
Give us some date, my lord, whatever.
release the matter from the status of, no, if I'm releasing it, then fixing a date to the other court. No, I'll release it now.
Please, I'll inform him also. Have him-
Abhilash inform ಮಾಡ್ಬೇಕು.
Yes.
Yes. He release the matter from the status of being part heard. Post the matter before the bench having roster. Interim order, if any, subsisting today shall continue till the next date of hearing. Yes. That's released. Now this.
This, Your Lordship may fix some date. If it's
Rolling
to be
sir.
done today, I am.
Iವರು ಒಂದು attitude I must bring to Lordship's notice. They filed a memo before the trial court saying that please sell 24 flats. This is the memo filed, affidavit was filed. But we tried to put sale for the 24 flats. They filed this petition, interim order was granted, taking up all technical objections, but that's fine. Out of which 9 flats were sold. 14 flats were sold.
Correct, 14 flats were sold.
That amount is deposited.
9 crores is.
That amount they have filed objection. So Lordships may permit us to withdraw that amount. 1 rupee is not paid. But this is ridiculous attempt. I do not want to use this term. 6 years, my lord. So I'm not kindly
now,
look at the
1
statement.
minute. One moment, Nagaran sir.
Yes.
A memo is filed by you.
Yes.
That they
Sale
are
of
permitted
24
to sell
flats.
24 flats.
Yes.
They have sold those flats. 9 crores is received.
Not all was sold.
No, 14 flats were sold. 9 crores is received. Let them take the 9
All
crores.
that I'm saying, my lord, is
Right.
so far as that 9 crore sale is concerned, there is an application filed before the lower court saying that the methodology of sale was completely contrary to court orders. They were supposed to prepare a proclamation. If your lordships would kindly call for the record.
Unconscionable, unfair. No, I'm not nothing to do
No,
with
Lord,
senior
in
counsel.
fact-
For a moment, I'm not referring
fact,
to.
my lord, on the
It's about the
earlier occasion,
attitude of the parties.
When
How
interim
can
order
it
was,
be, my lord?
my lord, when the interim order was granted, the honorable court called for the record. The entire record from the commercial court was
I will
placed before the
demonstrate.
court.
I will demonstrate there is no illegality at all.
My lord perused it and asked, where is the proclamation?
No, which court called for?
This on the
Coordinate,
court.
me?
This on, no, not the.
Coordinate bench.
Lordship Justice.
Narendra Prasad.
And at that stage, not the honorable court saw it, asked them, where is the proclamation? They were not able to show the proclamation.
Records, trial court records are here?
No, Lord, what happened then after the interim order, because auction sale had to take place, the record was sent back. Now, my lord, before the lower court, they sold these 14 flats. I have filed application, my lord, pointing out that some of the persons interested in the decree holder have participated without taking leave of the court. And
That is
I
not
have also
correct.
said, my lord.
No,
That is
one
not
minute.
correct.
According to you,
Yeah.
if the sale was done in a proper manner, it would have fetched more money?
Yes, I filed, my lord. In fact, the proclamation requires under the rules, when they issue a proclamation, they have to give the name of the.
But let my learned friend argue the matter, my lord. We will also answer. Every point I will answer. My lord. Let them not do it in this manner. Let them argue. Every point I will answer.
My lord, your lordship
They have
asked
stalled,
what
they have
is the
stalled.
urgency?
No, this is most unfair. 9.5 crores, not out of 45 crores. But what should we do? Decree holders, my lord? Is this the way, my lord?
has
The
to be
things
done
are stalled.
according to
Is this
law,
the way things are stalled? They file a memo, 24 flats to be sold. They say unequivocally, their only claim is these 24 flats, we would have fetched higher price is the valuation they had given. Order 21 rule 64 mandates that the court should not fix the valuation. They gave their valuation, we gave our valuation.
My lord,
Both valuations were
My learned
put.
friend has got such objection, my lord. I will not, my lord, say anything. I'm prepared to argue the case. I'm
Yes,
only, my lord,
let-
saying.
let them
the
argue.
lordships may take it up, my lord, when time is available. That's all that I'm saying.
Now,
If
what
it
is the next date there?
End of
No,
September.
they are sitting pretty, my lord. They are sitting pretty here. They have absolutely no reason. 46 crores, my lord, since the
Judge is
decree
retiring,
6
my lord,
years
next
passed
week.
away. Every type of objections are made. Third party
The
rights are
learned judge is
created,
retiring next
antedated.
week. The learned judge is retiring next week. There are applications filed by third parties to say that I have
How
an
many
interest in this
applications are filed
property.
totally?
It has to be inquired into. So the judge
27
said, I have no
applications
time
totally.
and posted it to end of September.
55 applications they have filed till today.
If you sell
55
flats-
applications. Humanly impossible for any judge to dispose it of every time on application.
ಇಲ್ಲಿ ಒಂದೇ ತಾನೇ petition ಇದೆ?
ಮಾಡಿದ್ದಾರೆ, but they are
Donors
not
have
ready.
filed, my lord.
Let them, lords, in all fairness, say that we'll withdraw 9.5 crores. If they want to take a date of their choice, let them take. I have no
No,
objection.
we'll take it. If there is objection, we'll take it on merits. It's all right. Then on Tuesday.
Please.
My only
Tuesday around the same, ನೀವಿರಲ್ವಾ?
ಅಲ್ಲ, morning session is lots. Accommodate me, great. I'm aware.
Oh, this is not GMCPC ನಲ್ಲ.
ಹೌದು, GM.
Then let it come in preliminary hearing.
Please.
Yes.
Please.
Great.
Interim order we continue.
Serial number 5, my lord. Auction is there.
ಯಾವತ್ತಿದೆ?
My lord, serial number 5.
Which
He is
list?
not appearing. Pass on second list. My lord, stay has been granted. Now, auction is on Monday, my lord, 18th. Paper publication ತಗೊಂಡು list 2. Fast over matter. Stay
ಬರ್ಲಿಲ್ಲಲ್ಲ?
ಇಲ್ಲ, last time ಬರ್ಲಿಲ್ಲ. Last time ಬರ್ಲಿಲ್ಲ. My lord, 35 ವರ್ಷದ litigation. ನಾವು public auction ಆಗಿದೆ 4.18 crores ಗೆ. That is sought to be stalled now. But may I pass on the
Petitioner was not there last time, is it?
yes, last time also it was not, but it was not recorded.
That's
Not come
what.
last time. He has not come. May I pass on this, my lord, paper?
1 minute. The petitioner, this court on 21/7/2025 had passed the following order. The order was passed on the premise that the award of the arbitrator of the year 2004 was put to execution in the year 2017. The respondents have now entered appearance and clarified the position that the execution had to be filed in the year 2017 on this score that there were several appeals pending before. Appeals were pending before coordinate benches.
No, yes, my lord.
Before.
And before district court, my lord.
Appeals were pending before the concerned court and before this court as well. And on conclusion of those proceedings, the execution had to be initiated in the year 2017. The learned counsel for the petitioner remained absent on 25/7/2025, though it was not recorded. The petitioner, even today, both in the forenoon and in the afternoon session, the learned counsel for the petitioner remains absent. In the auction is slated to be held on
18th.
on 18th. Therefore, the auction that is slated to be held shall continue.
Spot auction was already done. Now
The further proceedings before the concerned court shall continue, which however remains subject to the result of the present petition. List the matter on 29th.
Much.
Yes. Mr. Sakman. End of the list. End of the court.
Instead of 29, second or third, my lord, I will not be in station on 29. Second or third.
10th.
Yes.
10th September.
230 mood matters.
Yes, Prashant. Then.
Ex-parte. Order seal number 1.
Lord, the respond.
Divana.
Yes, ma'am. Writ petition 24779.
1 minute. Not about this.
063.
Pending matter.
This matter was listed on 6/8/2025. Why oversight interim order was not extended. That is only
6/8/2025.
so 6/8/2025. Matter was called in another.
1 minute. Bere courtal bandita. The interim order granted on 16/7/2025 shall stand extended till the next date of hearing.
Please.
Date and bada. Yes.
Number 2.
Yes, Prashant.
Respondent filed an application under order 21 rule 41 for disclosure.
K-wait ಇದೆಯಲ್ಲಪ್ಪ.
My lord?
K-wait ಇದೆ. ಕಶ್ಯಪ್ K-wait ಹಾಕಿದ. Not seen?
No, I have not seen. Lord, we are not informed. Lord, I'll serve them, my lord. The difficulty is,
What's the next date?
my lord, the next date is on 23rd. My lord.
I will take it on Monday. Serve on them.
Yes, ma'am.
ಏನು problem ಏನು?
Problem is that, my lord, now in terms of 23 rule 41, my lord, I've been directed to disclose the assets, which is completely alien to the rules which has been formed in form 16, my lord, where I had to disclose the assets. Now, my lord, kindly see the application what they filed.
This is execution, is it?
Yes, but it's an execution. Page 200, my lord.
Your
199.
judgment at all?
Yes, my lord, I'm the judgment. My lord, my appeal under 34 is pending before the Delhi High Court. And my lord, both the parties have agreed to argue finally. The Delhi High Court has fixed a date for hearing, my lord. In that, my lord, when that has been pending, this proceeding has been initiated.
Anyway, serve ಮಾಡ್ಬಿಡಿ. I'll take it on Monday.
My lord.
List on Monday in preliminary hearing.
Great.
Copy, sir. Kashyap and Nayak has filed caveat. Shala? Dharwad ಕರೆದು ಬಿಡಿ.
Matter pertaining to Dharwad bench. Orders seal number 1.
My lord. My lords, I'm representing petitioner Anil Khadi.
List the matter on 30th. Interim order subsisting will continue till the next date of hearing. Next.
Hearing on IA seal number 2. Sirajuddin number.
Extension of parole. Yes, government.
Please, my lord, I am for the respondent state, my lord.
ಏನು offense?
Not to offense, my lord. And on 15/2/2025, the parole was been granted, my lord, earlier.
You file, the petitioners are at, since the parole was granted on 15/2/2025 and is now expired and the petitioner has returned to the goal, the liberty is reserved to the petitioner to file a fresh petition seeking parole before the appropriate bench. Yes. Same order in the next.
Minutes. Serial
IA
number 4, my lord.
Chetan,
Please, my lords. Serial number 4, my lords. I have furnished the list of authorities on last occasion with the court officer. Yes, in the file.
list on 30th interim order subsisting will continue till the next date of hearing.
Yes. Please.
Tax matters B group which have not reached 21st or 28th.
My lord.
21st or 28th. No
26th.
individual matters. 11th
My lord.
4th or 11th, yes.
Serial number 80, my lord.
Tax matter.
Matter pertaining to that areca nuts, my lord.
ಅದೊಂದು ಪೆರಿಷಬಲ್ ಕಮಾಡಿಟಿ ಅಂದ್ರಲ್ಲ. ಸೀರಿಯಲ್ ನಂಬರ್ 80 ಅದು ಕಸ್ಟಮ್ಸ್. ಇದೊಂದು 21st ಹಾಕಿ ಅಷ್ಟೇ.
My lord, serial number, my lord, serial
All
number
other matters on
68.
4th and 11th.
My lord, serial number 60.
Oh, bank attachment ತೊಂದ್ರೆ ಇಲ್ಲ. Yes.
My lord, serial number 68. I have the benefit of interim arrangement that may kindly be extended, my lord.
Whatever
68.
orders are existing will continue, madam.
Much
Don't worry
obliged.
about it.
Serial number 25.
ಎಲ್ಲ tax matters which are not taken up, I mean B group, whether it is covered, not covered, 4th and 11th. Maybe. ಯಾವುದು? ಯಾವ್ದ್ರಲ್ಲಿ ಸರ್? ಟ್ಯಾಕ್ಸಾ? 70? ಬಿ ಗ್ರೂಪ್ ಅಲ್ಲಿ ಇದೆ. ಮತ್ತೆ ಟ್ಯಾಕ್ಸ್ ಸ್ಟೇ ಕೊಟ್ಟಿಲ್ವಲ್ಲ?
Last time notice ಆಗಿತ್ತು. Last time notice ಆಗಿತ್ತು. It was posted today to see whether it could be disposed of.
Then
To remind,
post that.
have it after 2 weeks.
No, 21st. ಅದೊಂದು 21st.
23 covered by disseminate.
Covered by ಪರವಾಗಿಲ್ಲ.
Tuesday, my lord. Second list, my lord. Hearing on IA, my lord.
BDA matters.
Land acquisition.
ಹೌದು ಹೌದು.
ಏನು?
Annexure J covered by disseminate. ಕೋರ್ಟ್ ಅಲ್ಲ.
ಜನರಲ್ ಅವಾರ್ಡ್.
ಇಲ್ಲ, ಪ್ರಿಲಿಮಿನರಿ ಅವಾರ್ಡ್ ಮಾಡಿದ್ದಾರೆ, ಫೈನಲ್ ಅವಾರ್ಡ್ ಮಾಡಿಲ್ಲ.
ಅದಕ್ಕೆ here are
25 BDA matter.
That will come. LA BDA matters will come on.
25 BDA matter 25th Lord.
ಎಲ್ಲ ಬಿಡಿ ಮೇಡಮ್, ಎಲ್ಲ ಬಿಡಿ 26th ಮೇಡಮ್.
Action is madam.